ಅಲ್ಲ ಬೇರೆಯವ್ರದ್ದು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಲ್ವಾ? ಏನ್ ಕೊಡಿ ಪರವಾಗಿಲ್ಲ ಬರುತ್ತೆ ಕೊಡಿ.
Your Honor, this is
ನೋಡಿ ಇಂಟರಿಮ್ ಆರ್ಡರ್ ಫಸ್ಟ್ ಕೊಡದೆ ನೋಟಿಸ್ ಮಾಡಿದೆ ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ಅ ಮ್ಯಾಟರ್ ಟು ಬಿ ಹರ್ಡ್, ಸೊ ಇಟ್ ವಿಲ್ ಓನ್ಲಿ ಬಿ ಹರ್ಡ್. ಗಿವ್ ಇಟ್. ವೆಕೇಟಿಂಗ್ ಇದ್ರೆ ಬರುತ್ತೆ, ಲೀವ್ ಇಟ್. ಓ ವೆಕೇಟಿಂಗ್ ಇದ್ರೆ ಕೊಡಿ ಬರುತ್ತೆ, ವೆಕೇಟಿಂಗ್ ಕೊಡಿ ಬರುತ್ತೆ.
Your Honor, this is
ರೈಟ್. ವೆಕೇಟಿಂಗ್ ಬರುತ್ತೆ. ಇವತ್ತು 20 ಹಾಕಿದ್ದೀನಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ 20 ಹಾಕ್ತೀನಿ ಅಷ್ಟೇ, ಕೊಡಿ. ಗಿವ್ ಇಟ್ ಸರ್ ಪ್ಲೀಸ್. Give it sir.
Last Monday,
Give it sir, give the memos. If you want to give the memos.
Your Honor, this
ಸ್ವಲ್ಪ
GMC
ಇರ್ತೀರಾ ಸರ್? ಕೇಳಿಸ್ತಲ್ವಾ ಅಲ್ಲಿ? ಮತ್ತೆ ಬರ್ತೀರಾ ಕೋರ್ಟ್ಗೆ? ಎಲ್ಲ ಕೊಡಿ. ಏನು ವೆಕೆಟ್ ಆಗಿದೆಯಾ? ವೆಕೆಟ್ ಆಗಿದ್ರೆ ಅಪೀಲ್. ಎಸ್ ಕೊಡಿ ತೊಂದರೆ ಇಲ್ಲ ಕೊಡಿ. Tax matters ಎಲ್ಲ ಕೊಡಿ. Tax matters you give all the memos. Wait. Tax matter all the memos you give. CRP and tax both. ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್? ಏನು? You have preferred FDPA. Where? Argument stage. Correctly rejected. No problem. ಕೊಡಿ ಸರ್ ಪರಲ್ಲ. ಡಿಟೆನ್ಷನ್ ಆರ್ಡರ್ ವೈ? ಅದು 2:30 ತಗೊಳ್ಳಿ ಕೊಡಿ. Correctly rejected. Give it yes. Suit for. Then give it yes. Pending matter. Fresh matter only on Monday. Give it yes. Give it sir. Yes, next one. If you want to give the memo, please. ಎಲ್ಲಿಂದಾರು ಬರ್ಲಿ ಕೊಡಿ.
last week.
No sir, if you all big ಇಷ್ಟು chaotic ಆಗಿ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ರೆ ಏನು ತಗೊಳಕ್ಕಾಗಲ್ಲ, ಕೊಡಿ. Yes. ಅದಕ್ಕೆ give the memos. No date sir, give it.
Last.
Please give the memos. They'll come on designated days according to seniority. ಅಷ್ಟೇ. Fresh matter ಆದ್ರೆ on the designated day. If you want that method, take it. Or I can't do anything else. Give it. No sir, nothing. Give it. ಬೇರೆ ಇಂಜಂಕ್ಷನ್ ಆದ್ರೆ ಯಾವ್ದಾದ್ರು ಸರಿ ಅಷ್ಟೇ. ನಥಿಂಗ್, ನೋ ಪ್ರಾಬ್ಲಮ್ ಸರ್, ಕೊಡಿ. ನೋ ಪ್ರಾಬ್ಲಮ್, ಗಿವ್ ಇಟ್. 2:30 ತಗೊಳ್ಳಿ. ಗಿವ್ ಇಟ್ ಸರ್. ಲ್ಯಾಂಡ್ ಎಕ್ವಿಷನ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಬರುತ್ತೆ, ಕೊಡಿ. ಐ ಕಾಂಟ್ ಹೆಲ್ಪ್ ಇಟ್. ನೆಕ್ಸ್ಟ್ 3 days ರಜಾ ಇದೆ, ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ವೆನ್ಸ್ಡೇ. ವಾಟ್ ಕ್ಯಾನ್ ಬಿ ಡನ್? ಗಿವ್ ಇಟ್. ಎಸ್.
GMCPC matter. GMC ಎಲ್ಲ
ಕೊಡಿ, ಮೆಮೊ ಎಲ್ಲ ಕೊಡಿ.
GMCPC matter.
ಎಲ್ಲ ಕೊಡಿ ಸರ್ ಮೆಮೊ, ಏನಾದ್ರೂ ಇರಲಿ ಕೊಡಿ ಸರ್. ಗಿವ್ ದ ಮೆಮೊ ಸರ್. Give the memo. No problem. Argue the matter. Give it. Yes. Give. ಕೊಡಲ್ವಾ ಮೆಮೊ? You don't want to give the memos? Then call the cases. You want to give the memos, please.
this is an execution petition. This is a
Give the memo. Give the memo. No. Give the memo.
My lord.
All argument is argument ಮಾಡಿ. If it is a fresh matter, it will come on. If it's a fresh matter, it will come on first. If you want to give it, give it. Yes. ಕೊಡಿ. ಕೊಡಿ ಸರ್. ಮೆಮೊ ಕೊಡಿ ಎಲ್ಲ.
Madam, ತಗೊಳ್ಳಿ.
Give it sir. No problem sir. Give it sir.
Milord.
No sir. Give it.
482 petition, Milord.
Give
37.
it sir. No problem. Notice ಆಗಿದೆ ಅಲ್ವಾ? ನೋಟಿಸ್ ಆಗಿದೆ ಅಲ್ವಾ? ಯಾವ ರೀಕ್ಲಾಸಿಫಿಕೇಶನ್ ಇಲ್ಲ, ಕೊಡಿ. ನೋಟಿಸ್ ಆಗಿದ್ರೆ
My lord, this is an
give it. Yes. If you want to give it.
In this matter, the respondents obtained the interim order in OS, my lordship.
Vacating stay ಹಾಕಿದ್ದೀರಾ?
Yes, sir. I am filing with the speedy disposal direction. I am filing the
ಕೊಡಿ,
petition.
speedy disposal ಕೊಡಿ. Yes. Take that speedy disposal thing. Yes.
Milord, 230.
230 why?
The reason, Milord, is this. Milord, there is a common passage between my property and defendant's property. Milord, interim expartatory interim order is rejected yesterday, Milord. That is where, Milord, there is some urgency now. Sanitary lines are passing through this particular common passage. In the
ಅಪೀಲಕ್ಕೆ
Swami.
ಅಪೀಲ ಬರೀ ನೋಟಿಸ್ ಮಾಡಿದಾರಾ?
Expartate.
ಬರೀ ನೋಟಿಸ್ ಮಾಡಿದಾರಾ?
Yes. That is the reason.
230 ಕೊಡಿ.
Please.
You give that sir.
Milord's bank account of the
Frozen now.
have been attached now.
Give it. Salary account. Not tomorrow, sir. Give it, yes. We'll take it on Saturday, give it. Yes.
But my suit is cancelled. My property is like they are trying to demolish my property.
Fresh matter.
Fresh matter.
Demolish 2:30. Yeah. Yes.
My lords, moving memo for being spoken to. There are
Why?
a few minor errors in the interim order passed.
We have put it.
Maybe listed tomorrow.
Which one, madam?
Tax matter, my lords.
Tax matter, all right.
My lord, this is commercial execution. Already my properties are attached. They'll go for sale. Actually, non-signatory to the arbitration are made as a party. They are executing the order on them. There's a reason.
When is the next date?
22nd is there, my lordship.
When is the next date before the court?
22nd.
22nd, 22nd.
Lord, GMCPC, Lord, fresh matter, Lord.
Lord,
No dates. First
Shanwara,
September ಬೇಕಾ
Shanwara,
ತಗೊಳ್ಳಿ.
Shanwara.
First September ಬೇಕಾ ತಗೊಳ್ಳಿ. ಇಲ್ದೇ ಇಲ್ಲ ಕೊಡಿ.
my lord, at the time of making the
Totally.
notice, my lord.
Whatever it is, fresh up pending.
Pending, my lord. My lord, 376 consensual 6. At the time of making the
482
notice.
ನಾ
482.
ಕೊಡಿ. Friday ಕೊಡಿ.
One submission.
Madam, Friday ಅಂತ ಹೇಳಿದ್ರು. Friday.
ಏನು ಸರ್? ಕೊಡಿ ಸರ್. Argue the matter, sir. It will be posted on first. Yes, give it. ಇಲ್ಲ ಅಂದ್ರೆ 8th. Saturday. Saturday I am not sitting at all. ಕೊಡಿ ಸರ್. ಯಾವ್ದು? ಸಫಾಯಿ ಕರ್ಮಚಾರಿ. Yes. Why? What ex parte order?
On my property, they're going ahead with the construction, my lord.
Overnight construction ಮಾಡ್ಬಿಡ್ತಾರ ಕೊಡಿ. Yes, 2:30 ಗೆ urgency ಇಲ್ಲ ಅದು ಕೊಡಿ.
My lord,
Yes.
there is an ex parte, they're aware of it, my lord. Other parties have not granted, they're all colluding together, they're going ahead with the construction.
Okay, give it. Yes.
Because it's my
2:30, yes. Okay, give
My
it.
lords,
Yes, madam.
GMCPC fresh matter, my lords.
First September.
My order of clubbing, my application for clubbing has been rejected in the 3 different suits. My counterclaim is at large against the forest department, my lords. I state that,
Then first ಬರುತ್ತೆ ಕೊಡಿ.
my lords, kindly, it is on 22nd for
Next.
defendant evidence.
Next date is first. Give it.
Your
Milord,
22nd
covered by
at-
judgment, my lord, is a land.
ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ? ಅಷ್ಟಲ್ಲ urgency. Stop overpowering, sir. Yes.
22nd at least. It is posted for defendant evidence at start.
When
after
is the next date?
22nd even.
All right, 22nd. ಕೊಡಿ.
Obliged.
Serial number 50.
Adjournment is on, yes.
My lord,
Fresh matter, my
ಎರಡು
lords,
connect-
Give it, sir.
connect-
after the commencement of trial, my lords, application for amendment of return
ಎರಡು
statement has
connect
been allowed.
ಮಾಡಿಸ್ಬೇಕು.
Now, my lords,
Next date,
next date is my lords,
Both the
29th, my
matters are
lords.
connected.
Monday, 29th, 28th ತಗೊಳ್ಳಿ madam.
8th, my
There
lords.
are 2 writs has been
28.
filed. It has to be connected.
my lord,
ಏನ್ ಹೇಳಿ?
covered by judgment, my lord, land acquisition matter.
ಅಷ್ಟಕ್ಕೆ ಇಷ್ಟೊಂದ ಕೊಡಿ. Yes.
Covered.
ನೀವು ಹೇಳೋದು
ಅದರಲ್ಲಿ
ನೋಡಿ,
ಪಾರ್ಟಿಷನ್
ಏನು
ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಏನ್ ಪರವಾಗಿಲ್ಲ,
ಅದು
ಕೊಡಿ sir.
ಲೋಕದ ರೆಫರ್ ಆಗಿದೆ. ದಟ್ ಹ್ಯಾಪನ್, my lord, ಇದು
Give it,
ಪಾಸ್
give it.
ಆಯ್ತಂದ್ರೆ ಸೆಟ್ಲ್ ಆಗತ್ತೆ ಮ್ಯಾಟ್ರು. ಹಾಗಾಗಿ
28th ಆಗ್ಬೋದು ಕೊಡಿ. Yes.
My lords,
madam,
this is a old.
28
ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಪೆಂಡಿಂಗಾ?
ಪೆಂಡಿಂಗ್ ಇಲ್ಲ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
My lords, this is a old matter, my lords.
Give it.
The 96 crore
Give
rupees
it,
has
give
to
it.
be deposited. my
ಕೊಡಿ.
lords. My lords, this is a
Friday,
old
my lord.
matter. As
No
of as
Friday.
this is a
You
fresh
don't
one.
fix the date, give it.
Why? Because, my lord, warrant has been issued, my lord,
No
consensual
problem.
6. At the time of
482
making the 482.
482 Friday ಬರುತ್ತೆ ಕೊಡಿ.
ಅಲ್ಲ, at the time of making the notice, my
482
lord,
Friday ಬರುತ್ತೆ, ಅದು ಬಿಯಾಂಡ್ ಅದಕ್ಕೆ ಮುಂಚೆ ಆಗಲ್ಲ. Yes, call the case.
My lords, may I be pleased to make one mention, my lords?
What is it?
My lords, your lordships were pleased to grant an interim order directing the respondents not to alter or change the nature of the property, my lords. Despite your lordship's order, despite a legal intimation via a legal notice, despite police intervention, my lords, rampant construction on the property is being carried out in gross violation, my
that?
lords, of your lordship.
Who granted the interim order?
My lords, your lords only granted the order, my lords, on 16/9. An interim order of
On
temporary
16/9?
injunction- Yes, my lords. On 16/6, my lords, I'm sorry.
ಯಾವ್ದು ತಗೊಳ್ಳಿ.
Despite your lordship's order, my lords.
Call the cases, yes. Give the memos.
Number 64, my lord.
Give the memos. Give the memos, sir, yes.
Serial number 64.
Adjournments ಇಲ್ಲ ಬೆಳಿಗ್ಗೆ.
Withdrawal, my lord.
Withdrawal ಕೊಟ್ಬಿಡಿ ಇಲ್ಲಿ ಯಾವ್ದನ್ನು.
Serial number 64, my lord.
ನೀವು ಕೊಡಿ.
First list.
ಇದೆ ಅಂತ. List 2, I'll take it at 2:30. Tax matters, nobody need wait. I'll sharp at 2:30 I'll take, will dispose agli.
For the respondent, my lords.
For the petition.
My lords, I request for a week's time in this matter. We'll file objections to their
Which is that
IA.
matter?
That can be disposed of, my lords. Order 39 rules 1 and order has been challenged.
Ah.
The petitioner is the defendant before the trial court.
My
my lord.
lords, I request for a week's time.
No
my lords,
week's
and-
time.
My lords, if I may just mention, my lords, the arguing counsel is from Mangalore, my lords. He's coming down personally next
Mangalore
week.
is not
I
Massachusetts, madam.
understand, my lords. I'm only
Yes.
the local counsel. I
No,
don't have
no,
instructions.
don't tell me all this.
I'll file my
Then I'm going to
objections.
take this matter. Now, just tell me, Mangalore in the Vartar Council, what nonsense?
My lords, I'll file my objections.
Nothing,
my
nothing.
lords.
Yes, sir.
My lords, the petitioner is the defendant before the trial court, my lord. Suit for injunction. I have the plaintiff has obtained an injunction order, my lord, under Article 39 rules 1 and 2. That has been confirmed, my lord, in the MA. On the previous occasion, my lord, the Honorable Court has granted the interim order. The commercial shop is
Interim
there,
order
my lord.
idea.
Interim order, then.
Order of status quo is there.
Status
my
quo is
lords.
granted, my lord,
Ah.
and the rentals, my lords, the commercial shops are constructed in the scheduled property. The trial court, my lord, on 5/7/2022, my lords, the Honorable Court has granted, my lords, the petitioner is entitled to receive the rentals, my lords, as on the, my lords, date of the
Status
suit,
quo
my
in
lord.
respect of scheduled property.
Scheduled properties, my lord.
Ah,
But the
okay.
rentals, my lords, has to be received to the petitioner, my lords, in the present writ petition. That has not been given, my lord, by
As a
the.
final relief.
No, on the last.
No,
date of
you
hearing,
want the interim order, final relief by way of an interim order?
No, my lords. The Honorable Court has granted, my lords, an interim order stating that, my lord, petitioner is entitled to receive the rentals from the commercial shop, my lord. That has not been
Where is
granted.
the interim order?
My lords, I have produced, my lord, along with, my lords, of the IA for direction, IA 1 of 2025. Para number 6, my lords, on the IA. I have extracted the, my lords, order passed by the Honorable Court, my lords, on 27/5/2024, my lords. IA 1 of 2025, my lords, for direction.
ಏನಿದೆ ಹೇಳಿ ಅಲ್ಲಿ?
My lords, para 6, last line, my lords.
ಹೇಳಿ.
My lords, however, during the course of argument, both the learned counsel for the petitioner as well as the respondent submitted that pending disposal of the above petition, if an order is passed directing the parties to maintain status
That is
quo.
your application, sir.
Yes, my lord. And the
Order
further-
ಎಲ್ಲಿದೆ ನಿಮಗೆ?
Lord, the further, my lord, further I have extracted. Hence the following, my lord, the parties are directed to maintain status
ಈಗ
quo. and
ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ ಅಲ್ಲಿ?
No, application has not been pending, my lord. That has been confirmed in the MEA, my lords. And challenging the MEA order, my lord, I have preferred this
ಈಗ
petition.
OSL ಆರ್ಡರ್ ನಿಮ್ ಪರವಾಗಿತ್ತಾ?
No, my lords. Interim order.
ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್.
Concurrent pending. My grievance is only, my lords, to
Status quo only.
receive the, my lords,
Anything else, sir?
rentals.
Status quo, I will continue and direct the court to consider, take it further, that's
So
all.
with respect to, my
No,
lords, rentals, the Honorable Court, my lords, has specifically stated that, my lord, the petitioner is entitled to receive
No,
the
no.
rentals.
ಅವ್ರು ಮಂಗಳೂರು ಅಂದಿದ್ದಕ್ಕೆ ಮಾತ್ರ ಕೊಡ್ಬೇಕು ಈಗ ಆರ್ಡರ್ನ.
My lords, apologies, my lords.
What is that submission?
My lords,
Council should come from Mangalore.
No, my lords, I don't have instructions in this, my lords.
What is this? This is
I'll-
not correct.
Apologies, my lords.
That when the petitioner shall be entitled to receive the rentals in the scheduled property prior to 5/7/2022. That is a specific order, my lord, passed by this Honorable Court. Being aggrieved by that, my lord, I have preferred the present application, my lord. That is the only grievance.
This court, the outside order,
My lords, on 27/5/2024.
27/5.
2024, my lords.
ಏನಿದೆ ಅದರಲ್ಲಿ? And
Lords,
the
hence the following, my lord,
permitted to collect the rents in respect to suit scheduled property.
Yes, my lords.
Regarding portion already been leased.
Prior to
Both parties would be
5/7/2022.
satisfied. What has happened ಇದಾದ್ಮೇಲೆ?
My lords, there are commercial shops, my lords.
ಇಲ್ಲ,
in the
ಸ್ಟೇಟಸ್
schedule-
ಕೋ ಅಂತಾನೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಇದಾದ್ಮೇಲೆ.
Status quo ಇದೆ, but the petitioner is entitled to receive the rentals from the, my lords,
Correct.
the lease, which
Hmm.
is, my lords, executed in the scheduled property.
ಆಯ್ತು, ಈಗ
That has not
ಏನಾಗಿದೆ?
been, my lords,
Who is not paying?
the rentals, my lords, as receiving the respondent. That has not been given to the petitioner, my lord. That is the only grievance. There is a specific order, my lord, to collect the rents of the scheduled premises, my lords, by the petitioner. But they are giving, my lord, to the respondents.
Petition who is the tenant?
And then, my lord, I have given lease to the some other peoples, my lord. In the there are 8 commercial shops, my
To
lord.
collect the rent according to the order.
But they are not giving, my lords.
What can be done? Are there parties here?
They are not the parties, my lord.
Yes, who is collecting the
The
rent?
respondent is collecting the
Why?
rents, my lord.
My lords, I need
Since
instructions.
petitioner and
My lords, may
respondent
have
are
it
the
on
brothers.
Friday, my
Us over.
lords.
My lords, Friday,
over,
my lords.
yes.
My lords,
I will pass the order. There's already an order of the coordinate bench. Yes.
my lords, kindly have it on Friday. Tomorrow, my lords.
List
My
to-
lords, I don't have any
list
instructions.
tomorrow, yes.
Please, my
Please,
lords.
Ask him to come from Mangalore tomorrow. Yes.
My lords, I appear for the respondent in this matter.
Not the short question for my lords considering.
Order Sally. It's come, non-filing of wakalat on behalf of petitioner, not pressing IA.
Lord, my learned friend, Mr. Prashant has already filed the wakalat.
That's someone else had undertaken on the last date.
No, there must be some mistake. I'm on record through.
Gautam Krishna yaru?
Gottilla.
Gotilla?
I don't know who's made that
Who,
undertaking.
from whom did you take NOC?
I did not come on NOC. I'm the petitioner and I filed for petitioner. There is some. error.
Registry to delete the name of Gautam Krishna is appearing for the petitioner in the cause list. Interim order idea?
Interim order ಇದೆ.
Idea?
ಇಲ್ಲ ಇಲ್ಲ
Sorry.
ಇಲ್ಲ. Sorry, my apologies. My apologies. ನಾನು ಐತಾಕ್ಷಿ ನನ್ನ ನೋಟ್ ಎಲ್ಲ ಇತ್ತಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
ಹಾಗಾದ್ರೆ ಇದು if this is over ನಾಳೆ ಬರ್ಲಿ. Not in this stage.
ಆಯ್ತು.
Yes.
Whatever you allot, we complete.
List heard the learned senior counsel Uday Holla appearing for the petitioner. ಅದಾದ್ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿ ಲಿಸ್ಟ್ tomorrow in preliminary hearing. Yes. Rectification of office objections.
ಒಂದೇ ಇದ್ರೊಳಗೆ ಏನಿರ್ತದಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಒಳಗೆ ಮಲಾಡ್ ದಿ
Yes,
ಅರೆಸ್ಟ್
not
ವಾರೆಂಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಇಶ್ಯೂಡ್ ಅದನ್ನ ಹಿ ಹ್ಯಾಸ್ ಚಾಲೆಂಜ್ಡ್ ಮಲಾಡ್ ದೇರ್ ಇಸ್ ಅ ರಿಕವರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ 3 lakhs ಅಮೌಂಟ್ ಮಲಾಡ್ ಡಿಕ್ರಿ ಹ್ಯಾಸ್
ಈಗ
ಬಿನ್ ಡನ್.
ಎಷ್ಟಿದೆ ಮೇಡಮ್?
3 lakh ಇದೆ, 1 lakh ಯಾವ ಡೆಪಾಸಿಟೆಡ್ ಮಿಲಾಡ್.
ಇನ್ನ 2 lakhs ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
ಇಲ್ಲ, ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದಿ
ಅಂದ್ರೆ
ಅಲ್ಲ
ಎಂಟರ್ ಮಾಡ್ರಿ ಇಲ್ಲ.
No, ಮಿಲಾಡ್. ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದಿ RFA ಮಿಲಾಡ್ 690 of 2025. That is for admission ಮಿಲಾಡ್. Pending for admission
A
ಮಿಲಾಡ್.
decree is ಮಲಾಡ್ is before ಮಲಾಡ್.
I have totally denied the
RFA
execution of
ಹಾಕದೆ
the
ಆಮೇಲೆ.
RFA is pending ಮಿಲಾಡ್.
ಅದೇ ಡಿಲೇ ಹಾಕಿರ್ತಾರೆ ಅಷ್ಟೇ. Yes.
ಅಲ್ಲ, ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ಲ. They have not
ಇನ್ನ 1 ಲಕ್ಷ
furnished
ಕೊಟ್ಬಿಡಿ.
They have not furnished a copy ಮಿಲಾಡ್.
What copy?
Through
Direction and IS copies not served.
through register post it has been sent.
ಆಯ್ತು. Application in IA 2 of 2025 for early hearing stands dismissed.
Please.
The IA 1 of 2025 for direction will be heard along with the main matter. List the matter on 10th September.
Copies may be.
Copy of the application. One dismiss ಆಯ್ತು ಅದೇನ್ ಬೇಡ ಬಿಡಿ.
Please, direction.
ಅದು along with the main matter ಕೊಡಿ. Yes. Post immediately after service of notice upon the second respondent.
ಡೇಟ್ ಅಂದಿದೆ.
Kindly extend interim order.
Awaiting ಯಾರಿಗೆ R1 ಗೆ ನೀವು?
No, R1 ಗೆ.
Interim order subsisting, yes.
Date September, any date. Date can be fixed.
Post immediately after service. Next.
5, same.
Same.
6,
Interim order extension, serial number 5.
6.
Office note regarding petition.
For the respondent.
Where does not tally.
Lord, on the
Vacating
last-
stay.
No, on the last date of hearing, they said they will withdraw the petition. If they
Withdraw the
don't cha-
petition.
Yes, that is what they.
I appear for the petitioner, my lord.
Yes.
On the last date, your lordship had extended the stay granted to me on the rich side. I was challenging the order in the MFA.
Last time I have passed a detailed
Yes, yes,
order.
I agree with your lordship. I'm not
Takes time to
disputing.
withdraw, either withdraw the petition or place on record the decision of the
Yeah, the
management.
decision is to file a review petition, my lord. The review
withdraw this
petition has been filed on that date.
Filed already?
Yes, it's filed, and
The
it was
learned counsel
listed for
appearing-
hearing yesterday, my lord, but it didn't reach. That was my difficulty, my lord.
Where?
In the court hall 20.
Not my problem. This court on 31/7/2025 had passed the following order. The order was clear that the petitioner had sought time to either withdraw the petition or place on record the decision of the management. The learned counsel appearing for the petitioner now submits that the review petition is preferred against the order in miscellaneous first appeal 3278 of 2025, and the review petition was listed yesterday, date kodi. In the light of the remedy of review being availed off by the petitioner, nothing further would survive for consideration in the subject petition. Liberty is reserved to the petitioner to urge all the contentions urged before this court in the review petition. Review petition said to have been filed. Yes, ordered accordingly. With the aforesaid observations, the petition stands disposed, ordered accordingly. Next.
In this case, Shri NRB undertakes to file wakalat for
Yaru?
R1 in this case. Shri NRB.
NRP?
NRB.
NRB ಅಂದ್ರೆ ಏನು?
N Raghu.
GRB ತುಪ್ಪ ಹೇಳ್ದಂಗೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. NRB ಅಂದ್ರೆ ಏನು? What do you mean NRB?
ರಘುಬಾಬು ಎನ್ ರಘುಬಾಬು ಅವರು ವಕಾಲತ್ತು ಫೈಲ್
ಪೂರ್ತಿ ಹೆಸರು ಹೇಳಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇದು. Learned counsel so and so submits that is entered appearance for the respondent, registry to print the name of so and so is appearing for the respondent. List after 2 weeks, interim order
R1.
First respondent. Interim order subsisting will continue to the next date of hearing. Next.
8. For the petitioner in this case, your lordship, the copies have duly been served to the respondent counsel, your lordship, on 31st of July. The copies have already been filed, your lordship. This is the office copy, your lordship.
File it in the registry.
It's already been filed, your lordship.
Office copy, why are you giving it to me then? It should be here.
Please, your lordship.
Learned counsel for the petitioner submits, needful has been done, office to
Kindly
verify.
extend the
List
interim
of,
order.
wait, list after 2 weeks, interim order subsisting will continue to the next date of hearing. Next.
Great. 9.
For the petitioner.
Please, my lords, I had to file my wakalat, my lords.
Learned counsel, yarige?
R4 ಗೆ, my lords. I had to file. I did not file. Maybe next
Nirup.
week. Yes, please, my lords.
Learned counsel, Nirup, ಇನ್ನು ಹಾಕಿಲ್ವ ವಕಾಲತ್?
Next week, anytime.
Why you need 1 week to file wakalat?
No, he was not. He was traveling, my
For
lords.
the fourth respondent submit, counsel for the fourth respondent seeks a week's time to enter appearance. Interim order, yeah? List after 2 weeks,
Please, my lords.
needful be done in the next 2 weeks.
10.
Filing a complaints memo.
Filing what?
Complaints memo of being served with the respondent 3 and 4, my lord.
Learned counsel submit, registry file. Learned counsel submits that needful has been done.
No. Only for respondent 3 and 4 has been served, my lord. The
Counsel for
remaining
the
are uncontested.
Counsel for the petitioner colleague files a memo of service of notice upon respondents 3 and 4, who according to him are the only contesting respondents. Therefore, memo ಇಲ್ಲಿ dispensation.
I will take the steps, my lord. I will take the steps.
The learned counsel seeks a week's time to take steps insofar as the other respondents are concerned. The steps be taken, interim order, yeah?
ಇದೆ.
Steps be taken in the next 2 weeks. Interim order subsisting will continue to the next date of hearing. Next.
Much obliged.
11.
Post immediately after service of notice.
Second respondent, my lord.
R1 here.
Appearing for the petitioner, Your Honor.
R1.
R2 only.
R1.
Your Honor, R1 and R3 are actually mother and son. R1 is the mother, R3 is the son,
All
and
right.
R2 is the institution that's run by them.
R2 is the institution, your
Sorry.
honor. Nowhere connected to this.
Mother and son connection ilva?
I will verify.
I'll record that and
I am representing R2.
no
only,
connection mother and son to the institution andralla. So institution is not run by
Really?
both of you.
In R2, R1, my lord.
Yes.
Name is wrong, my lord. His name is Bhuvneshwar Raju, my lord.
1 minute. Post immediately after service of notice upon respondents 1 and 3. List after 2 weeks. Interim order subsisting will continue to the next date.
Your Honor, I would kindly like to press for some sort of interim order to be granted.
Some
Your
sort, and I have granted all
Honor,
sort
this
of.
is a status quo actually
That's
with
enough,
respect
yes.
to.
Yes,
Your Honor,
yes,
the
next.
petitioner has invested his hard-earned money. This is a 30-40 site, Your Honor.
No
He wants
problem.
to,
Nothing is going to happen. Yes.
12.
Your Honor, date may be given at least.
For respondent number
Come,
1.
yes. Furnishing.
12.1 ನಲ್ಲಿ the parties are already for the court. My lord Srinivas Reddy is appearing for R1.
R1, my lord, yes.
Lord,
Registry to print the name of so and so as appearing for the first respondent.
and Mr. Parshuram is appearing for R2.
R2, my lord.
R2 Parshuram. R3
The R3 society notice and take steps straight.
learned counsel seeks a week's time to take steps insofar as service of notice upon the third respondent. List after 2 weeks. Interim order subsisting will continue to the next date of hearing. Next.
13.
2 and 3, I'm seeking dispense of notice.
Learned counsel files a memo. SK.
I have served notice.
Just after 2 weeks, interim order subsisting will continue to the next date of hearing. Next.
14. Wait, sir.
Post immediately after
I
service.
appear for respondent number 1, my lord.
I appear for respondent number 2, my lord.
2 and 3 and 4. New 2.
Please, my lord.
3 and
3 and post immediately after service of notice upon respondents 3 and 4.
Much obliged.
Yes, next.
interim order.
Interim ಮಾಡಿದ್ರೆ continue ಮಾಡಿ. 50?
Wait for petitioner, please. Bring alerts up 17, week time, please.
My lord, we not even received.
Steps to be taken in respect deceased are 15.
Please, file application.
ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ sir.
Learned counsel seeks a week's time to do the needful insofar as our deceased R15 is concerned. Interim order subsisting will continue to the next date of hearing. Needful will be done in the next 2 weeks.
Please.
16.
Await notice.
Post immediately after service of notice upon respondents 1 to 5.
The interim order.
2 weeks IO. Next.
17.
For the petitioner, my lord, in the due course of the day, PF will be paid. And R2, R3 and R4 are wife and kids of R1. And it has been brought to their notice. So PF will be paid in the due course of the day, my lord.
Counsel for the petitioner submits needful will be done in the course of the day. For course of the day. List after 2 weeks, interim order subsisting will continue to the next date of, next.
18.
R1 and 13 to 15, wakalat today filed.
R1 13 to 15.
15.
Learned counsel so and so submits that is entered appearance for R1 13 to 15. Registry to print the name of so and so is appearing for R1 13 to 15. Yes. Interim order, yeah? List after 2 weeks IO. Next.
19.
Notice is served to the learned counsel for the petitioner who is counsel for appearing before the trial court.
Learned counsel submits needful has been done. Office to verify.
Interim order may
Interim order 2 weeks IO. Next.
Interim order may kindly.
Who's that?
20.
Extend ಮಾಡಿದ್ವಿ.
It's 20, my lords, I appear for the petitioner, my lords. It's this copy, my lords, the acknowledgement has been served, but my lords, it's not been filed before this court. It's 3 days or 4 days, my lords, may be given. Lords, the needful will be done. Lords, my instructions are, my lords, it's been served. My lords, the acknowledgement is not filed.
There is an order that if you make no effort, it will get vacated.
Please.
Where is the acknowledgement?
Lords, 3 days, my lords, I'll file the acknowledgement, my lords.
This is on 29/7.
Please, my lord.
20 days ಆಗಿದೆ.
Lords, I'm just a proxy counsel, my lords.
Then we'll vacate.
Lords, may I have
Learned
it,
counsel for the
my lord,
petitioner.
Saturday, my lord.
Counsel representing the petitioner seeks 3 days time. 3 days granted.
Lords, may I have it Saturday, my lords.
No,
By
sir.
then I'll file a.
No, sir. You're a proxy counsel. Why are you worried? Yes. Next.
21.
Petitioner in this case. Appeals has been served to the contesting respondents. Filed wakalat for respondent 4, 12 and 30.
ಯಾರು ಹಾಕಿದ್ದಾರೆ?
4, 12 and 13 ಗೆ HP ಲೀಲಾಧರ್.
ಲೀಲಾಧರ್ ಹಾಕಿದಾರಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡಿದ್ವಿ ಮೇಡಮ್?
ಇಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ ಸರ್. It's an amendment application has been rejected. It has been
Rejected. Suit for?
Suit for partition. Defendant return statement. Amendment for return statement has been rejected. Page number 20, 22. It's only elaboration of the earlier defense taken by the.
List on 29th for preliminary hearing.
Okay. 22.
R1
For a
to
week's time.
Appearing for R4 to 6 here.
yes. R7 served. R1 to 3 second time.
Steps, fresh steps.
Learned counsel for the petitioner seeks a week's time to do the needful quay R1 to R3. List 2 weeks time is granted to do the needful. Interim order subsisting will continue to the next date of hearing.
23.
Awaiting service for summons.
Interim order.
Post immediately after service of notice. IO is next.
Interim order may kindly be extended.
Yes, sir.
24.
Petitioner, my lord, awaiting service.
Post immediately after
You're an R3 is nothing, arrayed as defendant in original suit. R3, under she has been placed as the defendant number 2.
I think service notice ಆಗ್ಬೇಕಲ್ಲ. Post immediately after service of notice upon the respondent.
Interim order may kindly. Please.
25. Await service.
Post immediately after service of notice upon the second respondent. Interim order to continue.
Hand summons to
ಕೊಟ್ಟಿದ್ದೀರಾ?
has been taken, memo has been filed, my lords.
Learned counsel for the petition has the memo filed by the petitioner evidencing service of notice to second respondent by way of hand summons is taken on record.
That's even for R1, before the trial court we have served. Even
R1
that memo
again?
has been filed to the trial court lawyer. Before the trial court.
And so far as the others, the petitioner submits, needful has been done, office to verify.
My lords, one more request, my lords. R1 ge, he stays in abroad, my lords. Through email, the service may be allowed, my lords.
You effect it, yes.
Interim
List
order.
after 2 weeks, interim order subsisting, we continue to the next date of hearing.
Great.
Yes, next. No representation, we have. Finally, a week's time is granted to do the needful. In the event needful is not done, the interim order would stand automatically vacated. Subject to the aforesaid, interim order stands extended to the next date of hearing. Next.
27.
I'm appearing for the petitioner, my lords. A week's time could be granted to take out hand summons, my lords.
Why you have not taken hand?
My lords, on the previous date, my lords, the interim order was granted on the condition, my lords, to take hand summons. But my lords, my colleague.
This court on 4/8/2025 had passed the following order. Despite the order of service of hand summons, no hand summons are taken. The order clearly indicated that in the event the petitioner would not take out hand summons and serve the respondent, interim order would get automatically vacated. Therefore, it is vacated.
My lords, what has happened
The
is, my lords.
petitioner is at liberty to serve and then seek restoration of the interim order. Next.
Great.
28.
I'm appearing for respondent 2 to 4.
Lords, filed, my lords, one memo for dispensation of R11. Lords, R11 is plaintiff, my lords, in the original
Lord,
suit.
she
Lords.
died, my lord, actually. She died. Is there one of the co-plaintiff? Then leave that, not filed an application to bring on record.
Serve the petition. ಈಗ ಯಾರು ಎಲ್ಲರೂ ಸರ್ವ್ ಆಗಿದೆಯಾ ಈಗ?
Lords, she is
Post
the
immediately after service of notice upon the first respondent. ಅಲ್ಲ respondents, unserved respondents 1, 3 ಏನೇನದು 1 ಇಲ್ವಾ ಈಗ?
one idare, my lords, 1, 3, 8, 9 and 10. 11, my lords, I filed memo for dispensation.
Needful be done by the next date. List the matter on
Officer
17th.
the right objection on my wakalat. No, I filed
Office
power of-
objections, que wakalat stands overruled. Yes, next.
power of attorney to the like.
Next. ಯಾವುದು? ಆಯ್ತು. ಒಂದು ವಾರ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಇಂಟರ್ ಮಾರ್ಟ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದ್ದು.
Lords, 28 interim order, my lords.
Yes.
28, my lords, interim order to extend.
Next.
29. Await service notice.
Post immediately after service of notice upon the respondent.
He extended the
Interim order continues. Next.
30.
The 2 days time will pay process.
Unserved return furnishing of FPF
Yes,
Not claimed, Lord.
2 days.
R3.
returned with R3 shall not claim. R3 ga,
R2.
the postal shara indicates that the third respondent has shara indicates that the cover has been returned as the third respondent has not claimed. Therefore, the registry to print the name of the third respondent and show the said respondent as served. Insofar as the second R2 is concerned, week's time is granted to the petitioner to do the needful. Interim order list after 2 weeks, interim order subsisting will continue to the next date of hearing.
31.
Learned counsel submits, needful has been done, office to verify. Acknowledgement ಹಾಕಿದ್ದೀರಾ?
ಕೌಂಟರ್ ಫೈಲ್ ಮಾಡಿ.
Yes, so it's interim order there, continue ಮಾಡಿ. Yes, list after 2 weeks.
Interim.
Next.
32.
Respondent number 1, my lords. For the respondent number 1.
Notice simple second respondent returned unserved. I will take steps to him.
R1, learned counsel seeks a week's time to do the needful. List after 2 weeks, interim order subsisting will continue to the next date of hearing. Next. 31 ನಿಮ್ದ ರುದ್ರಯ್ಯ. ಪಕ್ಕದ ಕೋರ್ಟ್ ಇಲ್ಲಿ ಹೇಳಿದ್ರೆ ಎಸ್
IPFL petition, I served copies on all the R1s. R2 serve ಮಾಡಿ file ಮಾಡಿದ್ದೀನಿ.
Learned counsel submits, needful has been done, office to verify. List after 2 weeks, IO. Next.
Much of IO extension.
34.
Your lordships had directed us to serve on the counsels before the trial court. I had served and I filed the acknowledgement also, my lords.
In this matter, my lord, may I, my lord, with your lordship's leave.
You are appearing?
We are for
Are you
respondent.
appearing?
Yes, my lord, I undertake to file the wakalat, my lord, kindly call it next week, my lord. I'll file
Learned counsel, ನಿಮ್ಮ ಹೆಸರೇನು sir?
Anantaram GR, my lord.
ಸರಿ. Learned counsel so and so undertakes to enter appearance for the respondent, registry to print the name of so and so is appearing for the respondents.
Interim order may be kindly extended.
Lest after 2 weeks, interim order subsisting will continue to the next date of hearing.
Grateful.
Yeah, same order.
36.
Respondent 1 and 2.
Respondent, sir.
1 and 2.
KV Girish. Interim order ದೇವಣ್ಣ.
Interim order.
Learned counsel with the petitioner submits needful has been done. ಸರ್ವಿಸ್ ಆಗಿದೆಯಲ್ಲ ಮತ್ತೆ ಹಾಕಿದ್ದಾರೆ ಇವರು. R1 and 2 ಯಾರು? ನೀವಾ?
I am for.
ನಿಮ್ಮ ಹೆಸರು?
Nischal, my lord.
So and so undertakes to enter appearance for respondents 1 and 2.
I filed my wakalat already.
Registry to
It's
print the
printed.
name of so and so is appearing for respondents 1 and 2. List the matter after 2 weeks. Objections, if any, by then. Next.
37.
Petitioner in this case.
R1 to R13.
Your lordship, they have different lawyers. There was a notice is already served on the advocate for D1.
Learned
But now
counsel
there are so
submits
many lawyers.
needful has been done.
Kindly, I may be permitted to take notice on the advocates for D11, 2 to 13.
1 you have served.
One I have already
Learned
served.
counsel for the petitioner submits, counsel for the first respondent has been served. Therefore, the counsel for the respondents 2 to 3 also be served by
2
the
to
next date.
13.
By the next date, yes.
Kindly,
In just after 2 weeks, interim order subsisting will continue
short date may be
in
given.
2 weeks, madam. Yes, interim order is there.
Interim order may kindly be extended.
38.
Sorry, I appear for the petitioner, my lord. I've
Post immediately after service of
I've
notice
done the
upon
needful regarding service on the trial court lawyers, my lord. Before the trial court, the lawyers.
R2 to R5.
R2 to R5, I've taken out process.
R1, Mandian.
I appear for R1.
R1, your name is already there. Post immediately after service of notice upon the respondents 2 to 5.
My lord, interim order.
Interim
may be-
order subsisting will continue to the
Much
next date.
obliged.
39.
Petitioner. Needful has been done.
Learned counsel submits needful has been done, office to verify.
I filed it yesterday with the memo. I filed it yesterday with the memo, the acknowledgement.
Yes, already filed, yes.
Yes,
Needful
yes.
has been done, office to verify. Yes, next.
40.
That's one submission in respondent number 1 to 4 notices may be dispensed.
Memo Kodi.
Please.
Yes.
So 40 for the petitioner. Yeah, serve the copy to the counsels on the trial court.
Learned counsel submits the copies of the petition, service has been effected upon the counsel for the respondents appearing before the concerned court. List after 2 weeks.
Interim order.
order. Yes, next.
41.
Needful done.
Learned counsel submits needful has been done, office to verify. Interim order, yeah?
28.
List on 28th. Yes.
Final hearing fixed by the trial.
I will also fix it. 28th, yes. 28th in preliminary hearing.
Appear for respondent. Next time we'll wakalat file ಮಾಡ್ಬೇಕು.
40?
42, my lord.
An on filing of acknowledgement service. Learned counsel so and so undertakes to enter appearance for the respondent, registry to print the name of so and so as appearing for the respondent. Yes.
8 to be fixed for final hearing, my lord.
Final hearing. Interim order ilva?
ಇಲ್ಲ.
28th, yes. 29th.
Much.
Preliminary hearing, yes. 40?
43. 43.
Served on the trial court. Interim order ಕೊಟ್ಟಿದ್ದೀನಾ?
No, my lords.
ಕೊಡುವಂತ
Lordship said after
ಕೇಸಲ್ಲ.
notice, your lordships will consider. The only ground is no reasons are assigned. Because ultimately, if a decree, my lords, is to be,
FDP.
lords, there is an FDP which they have initiated, my lords, but I have filed an independent suit. That suit was decreed. That suit's knowledge was to them because we had already stated about in the final decree proceedings. They don't contest the proceedings, the suit is decreed ex parte. They file miscellaneous. Now that miscellaneous, in the miscellaneous, my lords, the decree which is obtained by me is stayed without reasons. Because some prima facie case is to be made out.
You stayed until further orders, sir.
Yes. Lords, very peculiar, it is first stayed until further orders. and then we file an application, my lords, for vacating, then they say that no, it will not be considered.
Heard the learned senior counsel, D.R. Ravi Shankar appearing for the petition. Next date, yavat?
That I'll have to ascertain, my lords.
Should we wait for respondents? Next date, yavat ide?
To ascertain. I'm sorry, I'm.
Let's see. Then I'll post it for preliminary hearing on Friday.
Lordships.
Post the matter for preliminary hearing on Friday. Yes, 160 ಆಗೋಗಿದೆಯಾ? Friday ಬೇಡ ಮಾಡಿ. 29, 28. Yes.
An application is filed.
44.
Application is filed, my lord, to
I
send the
appear for respondent number 234. Today,
Counsel so and so undertakes to enter appearance for respondents 2, 3 and 4. Registry to print the name of so and so. Contesting yaru?
The application is filed for sending the documents for fingerprint experts. The petitioner, they acquired the title, my lord, under 3 sale deed.
1970 though.
74, but
74 registered.
74 sale deed, my lord, correct. But the question is,
stay ಕೊಡಂದ್ರೆ ಅವಾಗಲೇ ಕೊಡ್ತಾ ಇದ್ದೆ.
the problem is this, my lord, the document has not been executed by her father. But two admitted documents, the only thing is what the learned judge.
When did the father die?
75.
1975.
1975.
Not these.
Suit instituted?
2011. 2011.
Now you got to know your father did not execute that sale deed.
But the problem is she was not educated.
Father has not challenged. His wife also not challenged.
In their lifetime, nobody did.
Acted upon. Now the legatee under the will.
But
That
the
will,
problem is the land
will
was-
also.
The case is they were in possession. Land was acquired. When we approached
Compensation.
when we approached the authority for compensation, they said no,
ಅವಾಗ್ಲೇ
we have not-
ಬರೋದಿದೆ
it has
ಎಲ್ಲ
already been sent.
That's
Therefore,
why
declaration-
compensation ತಗೊಳಕ್ಕೆ ಅದನ್ನ ಮಾಡೋದು.
Not that. Declaration. But if I am
The
able-
declaration that the document is not binding.
Not declaration is that the document is now 8/7/1974 document is not binding. The reason
That's
is
all you can seek.
not her father.
Compensation ಬೇಕು ಅಂದ್ರೆ ಅದೇ ಕೇಳಕ್ ಸಾಧ್ಯ ಈಗ.
Yes, sir, yeah, correct. The question is her father acquired the property under 2 sale deeds. One, of course, my lord, it is the certificate copy of original is not available. Another one is available. And
What did the father do during his lifetime? What did the wife do during her lifetime?
This document was executed a few months before he died.
That's all right. What did the wife do?
She also died, my lord, on
ಅದೇ that's what.
she
ಅಲ್ಲ
died
50
in
ವರ್ಷ ಏನ್ ಮಾಡಿದ್ರು ಎಲ್ಲರೂ?
89 ಅಲ್ಲಿ ತೀರಿಯೋದ್ರು ಅವರು.
ಅಲ್ಲ 89, 75 to 89 ಇದ್ರಲ್ಲ 14 ವರ್ಷ.
She died, my lord. She was illiterate, my lord. Within few months he died.
Root itself should hopelessly barred.
My lord, if I am able to prove that the document, the signature is not genuine
sir,
signature.
not at all. We will not permit this. Nothing wrong in the order.
But what learned judge just said is, my lord, you filed an application to the wrong provision 1. Secondly,
That reason we will.
it make
We will tweak the reasons. But the order is
The
correct.
alternative reason may not help the party, but ultimately, my lord, if the document is sent in the way.
Sir, ನೀವೇ ಹೇಳಿ, can this be allowed? What is this? Father, mother ಯಾರು ಮಾಡಿಲ್ದೇ 50 ವರ್ಷ ಆದ್ಮೇಲೆ ಅದೇ ಹೇಳಿದ್ದು. Under the will you are now seeking to go into the root of the matter. ಯಾಕೆಂದ್ರೆ compensation.
That too, legatee under will, his will itself is.
ಎಷ್ಟು compensation?
2-3 ಕೋಟಿ ರೂಪಾಯಿ.
2-3 ಕೋಟಿ. ಅದಕ್ಕೆ ಇವೆಲ್ಲ. Yes.
That's the question. Ultimately, my lord, his will has been probate. Will is proved actually. Will has been proved by will executed by the.
Will ಬಗ್ಗೆ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. These documents you can't question. Now your case is that this those deeds are not binding of 1974.
Declaration of title and also that document is not binding on me because that document itself is not.
Father has not
by him.
executed.
Not executed. It's not his signature. It is obtained by fraud or something.
Father himself did not dispute. Wife did not dispute.
They were illiterate and they could not do it. That is what.
Not at all. ಇದು ಸೂಟ್ ಬಗ್ಗೆ ಬರೆಯೋದು ಬೇಡ. Suit itself was not maintainable ಅಂತ ಬರೆದ್ರೆ ಹೋಯ್ತವಲ್ಲ.
ಅದ್ ಬೇಡ.
ಅದಕ್ಕೆ ಆರ್ಡರ್ ಬೇಡ. You urge every contention there.
What learned judge has said is, I can compare the signature under section 73, it's alternate old act.
ಅದು ಮಾಡ್ಕೊಳ್ಳಿ ಬಿಡಿ ಏನು.
And therefore it is not required. My respectful submission is, it is a thumb impression. Thumb impression comparison is little difficult. And expert opinion is required is only contention we have urged before that.
One who is not disputed in the lifetime, we will not permit someone else to dispute. ಅದು ಬರೋದ್ರ ಮೇಲೆ ತೊಂದರೆ ಆಗುತ್ತೆ.
Yes.
Not a case. We'll permit you to urge all the contentions there. Heard the learned senior counsel G. Krishnamurthy appearing for the petitioner. The learned senior counsel, after arguing the matter at length, would seek leave of this court to withdraw the petition and urge every contention that is urged in the subject petition before the concerned court at the relevant point in time. In the light of at the relevant point in time, reserving such liberty to the petitioner, the petition stands disposed. Yes.
Even otherwise it may not be ಅಂತ ಮತ್ತೆ party I have considered ಅಂತ ಆಗಬಾರ್ದು.
ಇಲ್ಲ, after arguing the matter at length ಅಂದ್ರೆ ಅದು ಅರ್ಥ ಆಗ್ಬೇಕು. ತೊಂದರೆ. Yes. Considered ಇಲ್ಲ. Please.
45.
11/8, my lords, the copy served on the advocates on the trial court.
Learned counsel submits needful has been done, office to verify.
Authorized for the arguments, my lords, the matter.
ಏನ್ matter ಏನು?
For amendment of the plain, my lords.
Amendment.
Yes, my lords. Only suit is for the.
OS 2023.
23, my lords, the issues are framed on 19/8/24.
Suit for?
Suit for
specific performance.
Yes, my lords.
What do you want to amend?
To amend, my lords, the trial court has framed the issue. Issue number 1, that whether the plaintiff proves that they have paid the amount through check. Only in that an agreement, it is stated that it has been paid on the check. But my lords, after the registration, the amount has been paid by cash. But oversight.
By issue frame, by oversight.
By oversight, that is not stated in the plain, my lords.
This is why I did not grant any order. Let him come. Serve ಮಾಡಿದಿರಲ್ಲ.
Tomorrow is for the
argument. ಪರವಾಗಿಲ್ಲ, argue ಮಾಡಿ. List the matter on.
The DW1 is admitted for the receipt
29th. Yes, he has admitted cash.
Cash. But they are contending that it is received for some other purpose. So kindly see the page number 92, my lords. The cross examination part.
What other purpose?
For loan, they are saying. Kindly see 8th line, my lords. DP1 ರಲ್ಲಿ
ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿ ನಾನು ಒಟ್ಟಾರೆ 6 ಲಕ್ಷ ಹಣ ಪಡೆದಿರುತ್ತೇನೆ.
ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿ ಕೊಟ್ಟಿರುತ್ತೇವೆ. ಒಟ್ಟು 6.5 ಲಕ್ಷ ಹಣ ಪಡೆದಿರುತ್ತೇವೆ. ಸಾಕ್ಷಿ ಮುಂದುವರಿದು ಹಣವನ್ನು ವಾಪಸ್ ಮಾಡಿರುತ್ತೇವೆ ಎಂದು. DP1 ರಲ್ಲಿ ಏನು ಗೊತ್ತಿಲ್ಲ.
ಇದು ಲೋನ್ ಅಂತಾನೆ ಕೊಟ್ಟಿರೋದು.
ಲೋನ್ಸ್
ಲೋನ್ ಅಂತಾನೆ ಕೊಟ್ಟಿರೋದು.
That has to be decided, my lords, in the trial. Unless, my lords,
ಇವ್ರಿಗೆ ಏನ್ ಗೊತ್ತಾಗಲ್ಲ, ಅಮಾಯಕ ನೀವು ಲೋನ್ ಅಂತ ಕೊಟ್ಬಿಟ್ಟು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿಸ್ಕೊಂಡ್ಬಿಟ್ರೆ.
Receipt of amount, my lords.
We'll see. Yes, let him come. Let the counsel come. Seek adjournment there. List the matter on 29th. Yes.
46.
But this is the case where your lordship agreed to hear this matter.
Agreed to hear. Sorry, I withdraw my agreement. Yes.
This is the case, Lord, where order 21, appointment of court commissioner, your lordship had remanded it. Lord, then it again came back without, Lord, absolutely no reasoning.
Initially, there was no reasoning.
Same, no reason.
Yes. Subsequent to that, it's about 5 or 6 pages with Milord.
My colleague, Milord, made a request to your lordship, Milord, that
we'll quash it and send it back.
Here.
Milord, in fact, both of us were unanimous to say, Milord, if this honorable court can itself decide the issue, because it
again,
may be a
pass the
futile
same
exercise.
order.
We go back there.
As it is, it's a 2015.
26/9 application.
Yes.
Tell me what.
Yes.
What's in this? Who filed the application?
Their application.
Suit for declaration.
Suit for declaration.
I wait. Let him tell. Yes.
Please, Milord. Milord, on the last occasion, what I had pointed out is, Milord, there was, so initially I had filed a suit for injunction, Milord. Subsequent to me filing a suit for injunction, that suit was dismissed. It was called before this honorable court. There were observations made, Milord, by the appellate court. But there was an observation saying that, see, insofar as this particular property is concerned, you may not be fully in possession of the property. You may do so by filing a comprehensive suit for declaration. This
so
was
you
what
filed
was
a suit for declaration.
I filed a suit for declaration. Now, Milord, there are certain observations which are made, certain admissions which are also made by the defendant. He says, see, I have nothing to do with your property. You are the owner of your property. So that resolves prayer number 1 for me. Prayer number 1 will be decreed as it is. Now the issue is this, Murad. The observation made by the RFA in the RFA, Murad, observation is that you are not fully in possession of your own social property. So there is an encroachment.
Seek correction in that order.
Not it isn't, because the encroachment is in my property.
Fine.
So to determine, because here the issue is this, Murad, in the previous.
Where is the order in RFA?
Murad, order in RFA is.
Now what happens if a court commissioner is appointed?
Look, that it's already decided. Lord, in the earlier suit also, he has got a commissioner appointed. The report is that, Lord, I am in possession of my property, his property. The site which he has purchased was formed in my property. Now what he is saying is, the sketch was based on a compromise which his vendor had entered into with me. It is not so. I'll point out, Lord, that there were earlier proceedings, Lord, before the Tahsildar, Assistant Commissioner, Lord, DC, then KAT, Lord, then when it came to the High Court, then his vendor said, all right, I will stop this litigation and you take your property, I'll take my property.
We'll hear it on Saturday.
Saturday.
Yes.
It will require a little bit of going through the facts.
26(9) application consider madbekare.
Because Shadakshari Prakara, you have to
suit
decide
yes.
whether it is necessary or not is what.
My lords may kindly see my lord's previous order itself. My lords is referred to it. Please.
Saturday.
Third and preliminary hearing. Yes.
Yes.
Please. Oblige.
Ah.
47.
For petitioner in this matter, my lordship.
Just to ease out some burden, minutes, I made some comparative boundary analysis minutes which could help your lordships. Or one query.
ಏನಿದು?
This is a suit for declaration and permanent injunction which was filed.
Solid. Why are you here?
We are seeking relief. There is a MA in which the interim relief for in IA1 39-192 order 39-192
Not granted.
That was granted to us in the trial court, which was subsequently set aside by the appellate
First appellate court.
Yes, my lord. So in this, my lordship, the boundaries of the scheduled property is.
I just placed this on record. It might come to your lordship. I made a small table of the boundaries.
Boundary table.
Because there are a lot of title deeds. I can just place this notes on record that in his documents, the flow of boundaries is in order as found in the suit schedule, and the flow of boundaries.
Will direct status quo to be maintained. Go before the court.
We are in the possession of the property, my lordship.
What has happened was, I just only one thing. Your lordships could just see that table for a moment there. Plain boundaries not says like this. Plain boundaries not says road partially admitted, and not the factual boundaries in the survey sketches, road and a part of survey number 61/3. So there's an attempt made not to take over the lands of the defendant. Then not on the western side also not the properties of your lordship will see part of survey number 61/5 and 61/11 will come.
All right.
Because he has said my land is coming on to the west. On reality, my lands come on the north and south of the plaintiff. And then north, I've just pointed out.
North and west.
North and south onto the north of the plaintiff.
Him the problem 61/2 and
61/3 and 61/12. I've just there is a compilation of survey records also. There's a small sketch minutes in the first page. In the next compilation, in page 1 there.
Why was it granted before the trial court?
On a wrongful premise that I had admitted that there was an encroachment.
My lordship, it is based on their document.
That is set aside by the by the appellate court.
That has been undone by the.
Actually,
then who is in possession now?
We are in the possession, my lordship.
You
Actually, the survey reports which they have provided is the survey report has been done in the year 71-72, my lordship. However, if we consider Annexure P in the document, page 110 in the petition, my lordship, that is the purchase deed or sale deed of the respondent in this matter, my lordship. There also, the boundaries, it is clearly stated that towards the west is the property of the petitioner, earlier owner of the petitioners, my lordship. So we are, their position is as per the sale deeds, which was there, even respondent as well as the plaintiff in this matter. However, they are bringing up the survey reports now after 50 years and trying to depossess our, take out our position as well. my
Maintain
lordship.
status quo, let the suit be decided.
They are
I have
also
no
trying
issues,
to
but can I
harm
only-
with,
can I only
by way
request
of
only one thing?
destroying the
Wait.
crops as well, my lordship.
That's might I
The
only request only one thing.
photographs has been placed in.
1 minute. Your lordships are seeing the survey sketch for a moment. In terms of the survey sketch, my lords, the boundaries, my lords, of the plaintiff is bound on the east by road, portion of the east by road.
Don't argue the suit here, sir.
Exactly, my lords.
Injunction was granted, that is now
Kindly
reversed.
see the reason. my
So
lords.
parties, you maintain status quo,
Lords,
let the suit be
kindly see on
decided.
what ground injunction was granted only for 1 month.
Aye, tondre illa.
Lords,
Encroachment ಅಂತ.
No, no. That is what the first appellate state court. Nobody has made an admission about encroachment.
Where is the admission now?
My lords,
Page.
let them show, but there is no such admission. That's a negative inference, not what the trial court drew.
Where is the order, sir?
Not the trial court's order. Your
Trial
lordship will
court
find
is
it
on
at
Annexure, Annexure S, my lordship.
Page.
Page
138.
38, my lordship.
ನಮಗ್ ತಪ್ಪಿದೆ ಅದು ಸ್ವಲ್ಪ.
Annexure S. No, not 138. That is page 128, my lordship. In page 130, para 3, my lordship. Actually, the plaintiff encroached the property of 5 guntas
Right,
in.
that's a thing that is to be,
This is where.
that is the thing that is to be decided.
And the first appellate court said, kindly see, my lords, para 11 there.
Where is the first appellate court's order?
First appellate court has gone in depth, my lords. It has said there is no such.
Annexure A, my lordship.
It
Page
starts from.
17.
It starts from page 17 minutes. The grounds will have been laid out, the reasons minutes will be found from 24. After going through the entire set of records minutes, the court comes to a conclusion that minutes, the plaintiff has furnished false boundary which is in contravention to settled revenue survey records of the year 1972. It subsumes the properties of the defendant if an injunction is granted vis-a-vis the said boundaries are concerned.
The survey documents are placed before the trial court, my lordship. That is mentioned in the trial
And
court's
the first
order as
appellate
well.
court also.
In Annexure S, page 120, 129, 130, my lordship, 131. The last para 9 says that, sir, my lordship.
No, 131 BD, come to page 27. Where the appellate court has decided, I mean, considered everything. ಸದರಿ ಕ್ರಯಪತ್ರಾನ್ವಯ ಬಿನ್ ಸೋ ಅಂಡ್ ಸೋ ಇವರ ಮ್ಯೂಟೇಶನ್ ಆಗಿದ್ದು 61/4 ಅನ್ನು ಮಾರಾಟ ಮಾಡುವ ಮೊದಲು ಹಾಗೆ ಅಂಡ್ ಕಮ್ ಟು ಪ್ಯಾರಾ 12 ಅಲ್ಲ ಒಂದು ನಿಮಿಷ ಪ್ಯಾರಾ 12
ಸದರಿ ದಾಖಲೆಗಳ ಪ್ರಕಾರ
ಪೇಜ್ 31 ಪ್ಯಾರಾ 12 ಆನ್ವರ್ಡ್ಸ್.
ಯಾವುದೇ ದಾಖಲಾತಿಗಳು. However, we had not provided the sale deed of the respondent at that time, my lordship. However, their possession is as per the boundaries as scheduled in the sale
I'll just
deed
point
itself.
out, if there's
They
an
are also in
injunction
the
in
possession
terms of the
same.
survey sketch minutes, I will have no objection.
And further, my lordship, they are, we were in possession and we were growing, cultivating crops. We are growing, cultivating crops as well. They have destroyed it. The pre and post photographs of the same has been provided.
ಯಾವ ವರ್ಷದ್ದು?
Minutes, it is of the year
25. 24, the suit was filed, my lordship.
24 ಅಲ್ಲ 23 of 2025.
24.
So, at least an temporary.
Yes,
injunction.
we'll hear it. Stage ಅಲ್ಲಿ ಇಲ್ಲ.
Illa, Swami. That is the reason they are destroying our crops as well, my lordship.
Why are destroying the crops?
That is provided.
Why would any farmer do that minutes?
They have
Either
done
in
that,
his
my
land or
lordship. And
somebody's
annexure R may be referred, my
Farming
lords.
lands.
We have provided photograph proofs
No,
of
no,
the same.
yes. The first appellate court appears to be right. Yes. Bless the matter after 2 weeks. Next.
48.
Post immediately after service of notice
Pulled
upon.
The respondent bank in this
You're
matter.
appearing?
Bajaj
Counsel
Finance.
Francis Xavier undertake, you already filed Wakala?
No, no, I have to. file
Undertakes
that.
to enter appearance for the respondent.
My lord, in this case, my lord, we has taken the law. We initiated the surface measures. The interim order is that, my lord, till the trial court consider an application under 39 rule 1 and 2, there is a stay. That is the interim order.
What
My
is
lord.
state?
They approached the civil court, my lord, I have not received
One
any
sub-
summons
my
from
lord,
the
one
Honorable
submission
Civil Court.
before my senior.
1 minute, yes, tell me.
My lord, we are led by Mr. Srinivas Raghavan. He is unavailable today. My request for 28 or 29, my lords, or even Friday, my lords.
My lord, there is a suit. If appears to be there is a suit, my lord, if there is a suit, if they want to get the interim order at the hands of the trial court, my lord, let them get the interim order at the hands of the trial court. This court has granted a stay till the interim application is considered. My lord, as far as my knowledge, the instruction
No,
is
no,
concerned.
now only till your appearance, that's all.
Yes.
Now you entered appearance there.
I have not been served any notice, my lord. No summons has been.
I'll ask both of you to appear on a particular day. After that 2 weeks, the court will consider and dispose it.
Yes, my lord.
Ashte.
Read petition may be disposed
Srinivas
of.
Raghavan ಬೇಕಾ?
There is a direction to the trial.
The petitioner is before this court on the ground that the concerned court only issues emergent notice under, despite an application order 39-192 being filed seeking temporary injunction against the respondents. The petition, owing to the urgency in the matter, this court had granted an order of interim order of granted temporary injunction, which reads as follows, page 4, dated 4/8/2025. The learned counsel appearing for the counsel for the respondent bank has now entered appearance and would submit that the concerned court be directed to consider the application on hearing both the parties. In the light of the said submission of the respondent's counsel, which is not opposed to by the petitioner, I deem it appropriate to dispose the petition, directing the concerned court to conclude the proceedings, directing the concerned court to pass an order on the application under Order 39, Rule 1 and 2, after hearing both the parties within an outer limit of 4 weeks from the date of receipt of the copy of this order. In the light of the interim order subsisting in the subject petition, the same would continue till the next 4 weeks, or the order that would be passed under Order 39, Rule 1 and 2 by the concerned court.
My lord, my right to file a written statement. and application.
Yes, and it is needless to observe that the respondent defendant has every right to defend the action. Yes. Ordered according.
49.
Petitioner, my lord. This case, my lord, I have challenged the delivery warrant, my lord, issued by the trial court.
Why?
The suit for eviction, my lord. This case, it is arrears, everything is paid, my lord.
Then why delivery warrant?
My lord, the respondent number 1, my lord, before the trial court was the original owner, tenant, my lord. Then he has sublet the property to me, my lord. I am in possession of the property, my lord. The trial court, my lord, dismisses the petition against me, my lord, holding that the respondent number 1 is in possession of the property, my lord. And now, my lord, in the execution petition, the bailiff was appointed, my lord. The bailiff also has submitted the same report saying that the petitioner here is in possession and not the original tenant, my lord. And now, my lord, though there is no order as against me, my lord, the executing
Office
court,
objections,
I'll comply, my lord. By tomorrow, I'll comply.
Petitioner to serve on the counsel who represents the respondent in the execution proceedings and file an acknowledgement of such service. There shall be an interim order of stay. Execution proceeding, the delivery warrant sakala. Interim order of stay of the delivery warrant that is hanging on the head of the petitioner till the next date of hearing. Place the matter on 17th September in preliminary hearing. The copy of this order shall be released only after compliance with the office objections. Next.
50.
This case where
Maintainability.
the fraud and submission of the
23-3 na.
23, Last may kindly see the on 9
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
order date 39-1 and 2 applications have been filed before the trial court by the plaintiff, not to alienate, not to dispossess, not to put up construction. The Last may kindly see the reason given by the trial court. Absolutely, there is no reason as such. Page 315. No reasons have been assigned. All the 3 applications have been allowed ex parte. It is a case where on 3/4/1991, father executed a register agreement of sale in favor of
2005 OS.
Please, ಒಂದು ಅದು ನಾನು ಇದಕ್ಕೆ ರೆಫರೆನ್ಸ್ ಹಾಕಿದ್ದೀನಿ. 2005 ಅಲ್ಲಿ ಒಂದು ಸೂಟ್ ಹಾಕ್ತಾರೆ. ಸೂಟ್ ಬೇಸ್ಡ್ ಆನ್ ದಿ ಪವರ್.
Where is the now impugned order?
Page 315. Matter up to the Supreme Court.
315, second volume ಇದೆ ನೋಡಿ.
Matter went up to the Supreme Court, confirmed in our favor, page 315. Absolutely, though no reference of previous suits, this is the third suit filed by the plaintiff. Absolutely, there is no
Suit for?
reason as such.
Suit
For bare injunction.
earlier suits for
Earlier suit for declaration and injunction. IA1 has been filed.
Lost.
That has been rejected by the trial court.
suit for declaration and injunction lost
Last.
up to Supreme Court.
Supreme Court. Second suit has been filed by the same relief. If the suit is pending before the trial court. This is the third suit without disclosing the earlier two suits which were confirmed by the Supreme Court.
Which is the second suit?
Second suit is 1815 of 2007. After the
ಇದು ಇನ್ನೂ pending ಇದೆಯಾ?
ಇದು pending ಇದೆ.
2005 suit is over.
ಅದು pending ಇದೆ.
2005 pending ಇದೆಯಾ?
5 pending ಇದೆ.
ಮತ್ತೆ Supreme Court ಹೋಗಿದ್ದೇನು?
Interlocutory application has been filed in 2005. That was dismissed by the trial court. Come before this court in an MFA. MFA was dismissed. Review petition has been dismissed. Then went to the Supreme Court. Supreme Court confirmed the order. After that, this second suit has been filed. It is pending before the court.
Now where is the impugned order?
We are lost to kindly see the impugned order is page 317. 315, sorry.
315.
Kindly see the schedule, 280. All the piece and parcel of the property bearing survey number 15/1C measuring 2 acres 1 gunta situated at Yelagunta village. The very same schedule in the earlier suit, page 41. Page 41.
Heard the learned counsel Chandrachud appearing for the petitioner. The petitioner is the defendant in OS 4504 of 2025. The concerned court has granted an order of injunction restraining the petitioners from putting up construction even. The order answers 3 applications in one go. The learned counsel appearing for the petitioner takes this court through the documents appended to the petition to demonstrate that the plaintiff has now instituted the suit which is third in line. The first one was in OS 3490 of 2005, in which there was no injunction granted.
Injunction application rejected.
In which the injunction sought for was rejected. Rejection of which was challenged before this court by filing an appeal. The appeal comes to be rejected. A review petition against the appeal was filed which also comes to be rejected. This was tossed by the defendant before plaintiff before the apex court only to be rejected. After which it transpires a second suit comes about in OS 1815 of 2007, again seeking relief of injunction. The said suit is pending consideration. In the teeth of the pendency of the said suits, in which there is no relief granted to the plaintiff suppressing all the other suits pending, institutes the subject suit in OS 4504 of 2025 and files 3 applications. One injunction, the other stoppage of further construction and not to alienate the property, all of which are pending in the other suits. The plaintiff does not divulge the pendency of those suits. The court has by a perfunctory order allowed all the applications and granted the relief which ought to have been only granted at the final stage. In that light, the order impugned in the subject petition shall stand stayed. The petitioner shall serve on the counsel who represents the plaintiff before the concerned court and file an acknowledgement of such service. List the matter on 17th September.
2, 3 and 4 may be dispensed with.
Memo.
Please.
2, 3, 4 dispensation memo. Next.
Hearing on IA 51.
For the respondent, my lords. My lords, the suit is received the application for vacating. And my lords, we have sent them, my lords. We have filed a memo, my lords, where we have sent them through RPAD post, my lords.
Application copy ilva?
ಇಲ್ಲ ಇಲ್ಲ my lords,
Stay
they have
and,
sent-
what is the stay granted?
further proceedings will stay.
My lords, further proceedings ಮೇಲೆ stay ಆಗಿದೆ my lords.
What is the order and challenge?
Lord, application filed under order 30,
Ah,
rule 3 of the Code of Civil Procedure
ah,
to disclose the partners of the plaintiff's partnership firm has been rejected.
why do you want that?
Lord,
What is the suit for?
suit for ejectment.
Why do you want that? You are a tenant.
I am the tenant, my lord.
Ah,
Lord, in the year 1999, my lord,
hmm,
I have paid, my lord, 30 lakhs, rupees 30 lakhs.
hmm. To whom, sir?
The father of the present partners of the
Ah.
plaintiff firm.
Sorry.
My lord, and as agreed by him, my lord, for a period of 30 years,
Hmm.
the premises have been given for rent.
Hmm.
Now, my lord, in the 2011, after the death of the father of the partners, my lord, they have filed a suit. Now, my lord,
ಯಾಕೆ ಅಗ್ರಿಮೆಂಟ್ ಏನಿರ್ಲಿಲ್ವಾ?
ಇದೆ my lords.
ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ವರ್ಷ ಇದೆ?
11 months my lords.
that is their concern. We have denied it. My lord, only once, now,
Produced any document evidence.
I have produced a document,
Yes.
Lord, along with the memo, on dated, Lord, 29/9/2023, wherein, my lord, they have admit all the partners, my lord, have retired. My lord, order 30.
ಏನ್?
Order
Only,
30.
only to drag the proceedings.
No, no,
ಬೇರೆ
order-
ಏನಿಲ್ಲ ಇದ್ರಲ್ಲಿ.
Order 30, rule 3, may kindly be looked into for a moment. my lord.
yes, sir.
Order 30.
Yes, sir.
It mandates, my lord, to produce, disclose the partners. That is the, since, if the partners
ಎಲ್ಲ
are retired.
ಪಾರ್ಟ್ನರ್ಸ್ ರಿಟೈರ್ ಆಗಿದ್ದಾರೆ, ಅದನ್ನ ಹೇಳ್ತಾರೆ ಅವ್ರು ಅಷ್ಟೇ ರಿಟೈರ್ ಆಗಿದ್ದಾರೆ ಅಂತ.
ಯಾರಿದ್ದಾರೆ at present, who are the
ನೀವು
partners?
ಯಾರಿಗೆ ಕೊಟ್ರಿ
They
sir?
cannot, my
Whom-
lord,
sir,
continue the suit.
Whom did you pay the money? To his father.
Ashwal, my lord,
ಆಯ್ತು ಅಷ್ಟೇ.
owner,
ಈಗ ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು? 30 ವರ್ಷ. ಯಾವಾಗಿಂದ ಇದ್ದೀರಾ ನೀವು ಇಲ್ಲಿ?
99.
99 ಇಂದ.
ಹೌದು.
ಅದು 30 ವರ್ಷ ಆಗುತ್ತೆ.
ಇಲ್ಲ ಆಗಿಲ್ಲ, 2029 ತನಕ.
ಹೌದು, ಕರೆಕ್ಟ್. 4 ವರ್ಷ ಇದೆ. ಎಸ್ ಸರ್.
My lords, they have not given any documentary proof for what they are saying, my lords. It is just an afterthought, my lords, that I have paid 30 lakhs and my lords, if my lords may pursue. the
Anything
order
else, sir?
Lord, order 30, rule 3, my lord.
Yes.
IA,
Order 30
IA
rule
upon
3.
IA, my lords. They are keep on filing IAs, my lords.
One
It's have
minute,
been-
1 minute. Order 13 rule 3 ಹೇಳಿ
Order
sir.
30, 30.
Order 30 rule 3.
Yes.
Yes sir.
Order 30, my lord,
Hmm.
rule 2, my lord. Disclosure of partners' names. Where the suit is instituted by the partners in the name of their firm, the plaintiffs or their pleaders shall, on demand in writing by on or behalf of the defendant, any defendant, forthwith declare in writing the names and place of residence of all the persons constituting the firm on whose behalf
Where is the
suit
implement order?
instituted. Annexure E, my lord. The court says, no grounds is made out to grant relief.
Anything else?
And my lord,
ಎಷ್ಟು ಯಾವ ವರ್ಷದ ಸೂಟ್ ಇದು?
2000,
2012.
2012. Will direct the suit to be concluded in 3 months.
My lords, actually, there was already a direction we have obtained, my lords, that
Where
they
is
have
that?
not.
Where is page?
My lords, it was in a different.
Page.
Writ petition, my lords. In
Different,
my statement
page.
of objections, I have stated, my lords.
Lord, I have produced
They have
them.
not,
I have produced, my lord, the
mentioned-
memo.
they have not
That is-
mentioned that.
Are you a partner with them?
No, my lord.
ಇಲ್ಲ ತಾನೆ? That is between partners. Yes.
Lord, the
No.
order 30, it mandates, my lord,
If there is a dispute between
Yes, my lord.
partners, are you a partner?
there is a dispute between the partners.
Are you a partner?
I am not a partner.
You are a tenant.
Lord, when there is
Yes.
a mandate provision, my lord.
Oh, no, sir.
Lord,
That is dispute between partners.
Lord, if the partners,
ಆಮೇಲೆ?
Lord, are not in the, Lord, they cannot continue the suit.
Anything else, sir? ಇಲ್ಲ ಯಾವಾಗ ಬಿಡ್ತೀರಾ ಅಂತ ಅಫಿಡವಿಟ್ ಹಾಕಿ ಇಲ್ಲಿ ವಿಲ್ ಕ್ಲೋಸ್ ದಿ ಸೂಟ್ ಇಟ್ ಸೆಲ್ಫ್. ಇಲ್ಲ ಅಂದ್ರೆ ಐ ಡಿಸ್ಮಿಸಿಂಗ್ ಇಟ್ ನೌ. ಎಸ್. ಇದು ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ, my lords, ಅವ್ರ ಪರ stay
23 ಇಂದ.
Stay ಆಗಿದೆ, my lords.
The petitioner is before this court calling in question an order dated 30th August 2023 passed by the concerned court rejecting an application filed by the petitioner, the tenant, on IA 15, seeking to divulge the names of the partners of the partnership firm which had let out the property to the petitioner as obtaining under Order 30 Rule 3 of the CPC. The petition heard so and so. The petitioner is the tenant. Is said to have come into possession as a tenant in in subject premises on an agreement with the father of yaru?
Plaintiff.
Plaintiff,
Father of the plaintiff. It's a firm, sir.
Here in respondent.
Allah, sir.
Partner.
Erstwhile partners of Balaji Agarbatti Company, represented by 3 partners. The learned counsel for the petitioner, were 3 partners. The suit is instituted by the 3 partners in OS 2313 of 2012, seeking eviction of the present petitioner, the tenant, who was put in possession in the year 1999. It is the case of the petitioner that he had entered into an agreement with the father of the present respondent. Yaradu? Which father? Yar father?
Lords, it is
Balaji, Bhaskar.
all of their fathers.
All of their fathers, sir.
They're family members.
Oh, sir, yes. With the father of the respondents, and the lease was for a period of 30 years, though no document comes about to that effect. The learned counsel, the suit is of the year 2012, and at the time when the suit was at the stage of its conclusion, files an application under Order 30 Rule 3, seeking divulgence of the names of the partners of the firm on the score that he had entered into an agreement with a particular partner, which was for a period of 30 years and was and is to remain for up to 2029. The issue in the list is not with regard to the merit of the matter or the merit of the claim of the petitioner or the defense of the respondent. The petitioner files an application as observed herein above under Order 30 Rule 3 to divulge the names of the details of the partners of the partnership firm, and seeks to place reliance upon the said partnership firm. The concerned court, by the impugned order, rejects the application. The reason rendered to reject the application is as follows, page 30 and 31. The reliance placed on Order 30 Rule 3 by the counsel for the petitioner is on the face of it misplaced, as the petitioner is a tenant and there is no dispute between the plaintiff and the defendants qua the partnership of a partnership firm. The suit is for ejectment suit is for eviction of the tenant who was put in the premises as a tenant and not as a partner. Therefore, the order of the concerned court which rejects the application does not warrant any interference as it does not brood any perversity or error apparent. The suit is of the year 2012 and still languishing before the concerned court for the last 13 years, and the suit is one for eviction. Therefore, in the light of the suit pending for 13 years, I deem it appropriate to infuse finality into the proceedings. The concerned court shall endeavor to conclude the suit with an outer limit of 3 months from the date of receipt of the copy of the order. Finding no merit in the petition except the aforesaid observation, the petition stands disposed.
Since the evidence is going on, Lord, 5 months or 6 months.
No, sir. ಇನ್ನೂ ಕಮ್ಮಿ ಹಾಕ್ಬೇಕಾಗಿತ್ತು. ಯಾವತ್ತು ಲಾಸ್ಟ್ ಆರ್ಡರ್ ಯಾವ್ದು? ಎಲ್ಲಿದೆ ಆರ್ಡರ್? ವಿಚ್ ಪೇಜ್?
ಆರ್ಡರ್ ಶೀಟ್ ನಾವು ಕೊಟ್ಟಿಲ್ಲ ಅನ್ಕೋತೀನಿ.
ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ? ನೋ ದಿಸ್ ಕೋರ್ಟ್ಸ್ ಆರ್ಡರ್.
ದಿಸ್ ಕೋರ್ಟ್ಸ್ ಆರ್ಡರ್
ಎಲ್ಲಿದೆ?
So not able to find it.
No, why did you say that? There was already an order.
My lords, yes, my lords, not this court's order, my lords.
Not this court, sir. Coordinate bench order ಅಲ್ಲಿ conclude ಮಾಡಬೇಕು ಅಂತ ಅದು ಕೊಡಿ.
1 minute. That was within 6 months, my lords.
When?
My lords, in my statement of objection, I have mentioned.
When? Writ petition number ಹೇಳಿ, ಯಾವ disposal
Writ
ಹೇಳಿ.
petition number is 7083 of 2023, my lords.
708?
83 of 2023, my lords.
6 months ಇತ್ತಾ?
6 months ittu, my lords.
3 months, in the last 3 months ಅಲ್ಲಿ. In the light of the fact that there was already an order passed by the coordinate bench way back in the year 2023 to conclude the suit within 6 months, not 6 months, but 24 months have passed by and the suit is still languishing. only on the score that the such subject petition is pending on and an interim order is granted in the ಅದನ್ನ ಪ್ಯಾರ ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ ಲಾಸ್ಟ್ ಬರ್ರಿ. ಎಸ್ ಸರ್, 3 months ಇನ್ನ 2 months ಮಾಡ್ಬೋದು. ಎಸ್
52.
Matter may request for a week's
ನೋ ಸರ್, ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಲಿಸ್ಟ್ ಆಗಿ ಡೋಂಟ್ ಆಸ್ಕ್ ಎಟ್ ಆಲ್. ನಿಮ್ಗೂ ಬೇಕಾ?
After 8th September, senior counsel will have to meet.
The learned counsel for the petition respondent who has filed application seeking vacation of the interim order wants time. List the matter after 2 weeks.
Date may be given.
No, sir.
After 8th May.
No, sir.
Senior counsel will have.
So what? No, sir. Yes.
53.
For respondent number 1 in this case, my lord.
Lords, for the petitioner, my lords, I seek a short accommodation, my lord.
Vacating stay ಇದೆಯಾ?
ಹೌದು sir.
ಎಲ್ಲಿದೆ?
I have filed application for vacating stay.
Where is the vacating stay application?
It is not listed.
No, no. Yes. LR's on record ಅಷ್ಟೇ, vacating stay ಇಲ್ಲ.
ಇಲ್ಲ ಇಲ್ಲ, ನಾನು ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಯಾವತ್ತು ಹಾಕಿದ್ರಿ?
On 6/5/2025 itself is filed, my lordship. And this honorable court directed to serve the copy and also serve the copy on the petitioner counsel
What's
on
the suit for?
16/6/2025.
My lords, the counsel on record is standing counsel for the department, my lords. There is
so?
the tax day, my lords, like is held up. Kindly have it on any other day, my lords.
My lordship, only given
History to put up in suit ಏನು?
Partition, my
came to be dismissed, came to be allowed. Allowing and also they have filed an appeal challenging the partition decree, my lord. Thereafterwards, my lord, they filed during the pendency of RA. RA is of the year 2020. At the fag end of RA, my lord, when the stage was posted for arguments, they filed an application for under 6 Rule 17. That came to be dismissed, my lord.
To amend the plaint.
To amend the plaint, amend the appeal.
Appeal.
Why? Because, my lord, they have contested the suit before the trial court. They have not filed written statement. The amendment application runs into 12 pages, my lord.
and other LRs.
In order to fill up those lacunas, they need to file 6 Rule 17.
But appeal is pending anyway.
Appeal is pending. Appeal is of the year 2020, my lord.
Yes, sir. ಅಷ್ಟೇ.
May I have it on any other day, my lords.
Enter ಮಾಡಿದೆಯಲ್ಲಿ?
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಸ್ವಾಮಿ, I may be permitted to place on record, my lordships. I have filed up, they are developing and alienating the suitable property which has been decreed in favor of the respondent number 1, my lordships. I have filed application under Article 39 Rule 1 to restraining them from alienating the
before the first appellate court?
Post appellate court. That application was rejected, holding that there is an interim order operating against the first appellate court to proceed with the application, my lordships. Since that, my lordships, I want to modify the interim order.
Application code. They are going on with the construction?
Alienating, forming the layout, my lord.
Yes, sir. Will restrain you from not to alienate. When do you want?
Lords,
IA3 was filed, it was rejected, my lordships. Page number 10.
That's the matter. When do you want, sir?
any other day, my lord. Even tomorrow I will also work, my lord.
Even tomorrow ಆಗಲ್ಲ. Yes. ನಾಳೆ ಟ್ಯಾಕ್ಸ್ ಡೇ ಇಲ್ಲೇ ಇರ್ತಾರೆ, ಬನ್ನಿ. Tomorrow.
Interim order may be
Tomorrow, sir.
Interim order may be extended.
Interim order subsisting will continue to the next date of hearing. Yes.
Office may be directed to put up.
Ministry to put up the application. Idea, sir. Yes.
Sorry, my lord, serial number 52 interim order.
Interim order continue.
52.
52 na.
52 ಅಲ್ಲಿ ಅಜ್ಜನ ಆಯ್ತು.
Our care. Interim order will continue. Sir. Yes.
54.
I pay for petition.
Yes, sir.
JDR's writ petition. But in the execution proceedings, my lords, even before issuance of my lords notice, an application under section 151 came to be filed seeking for police protection. My lords, that is ordered, my lords, without even issuing notice to me.
Police protection for what purpose?
A decree, kindly see decree, my lords, which is available at page.
Suit for?
Suit was for, my lords, my suit was for injunction. My lords, they sought for counterclaim. My suit came to be dismissed. Their counterclaim came to be, my lords, decreed.
Correct.
Restrained the plaintiff, his men, servant, agents, or anyone else.
That is a cyclostyle order. Don't. Yes.
From causing any kind of disturbance to the peaceful possession and my lord's enjoyment of the written statement.
That's the decree.
This is the decree. Lords, now they have sought for police protection by way of my lord's an interim application. The trial court, my lords, without even issuing notice to me, my lords, on the basis of my lords the statement made by them, grants the police protection.
So what?
That is under challenge.
Decree ideal.
Decree there.
Yes. Anything else?
Now, my lords, the photographs what they have produced.
Anything else? ಅದು ಸ್ಟೇ ಇದೆಯಲ್ಲಿ
ಯಾವ್ದು?
ಇದು
ಆ
ಇಂಟರ್
particular police protection ex parte ಅದಾಗಿರೋದಕ್ಕೆ ಸ್ಟೇ ಇದೆ. ನಮಗೊಂದು ಅಪರ್ಚುನಿಟಿನೂ ಇಲ್ಲ, ನಮ್ಮದು ಸೇನು ಏನು ಇಲ್ಲ.
ಏನ್ ನಿಮ್ ಸೇ ಎಲ್ಲ ಆಗೋಗಿದೆ ಡಿಗ್ರಿಯಲ್ಲಿ?
ಅಲ್ಲ ಡಿಗ್ರಿ ಅದು that is insofar as my lord's written statement schedule property is concerned.
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅದೇ ಕೌಂಟರ್ ಕ್ಲೈಮ್ ಅಲ್ಲಿ.
Counter claim.
ನಿಮ್ದು ರಿಜೆಕ್ಟ್ ಆಗಿರೋದಕ್ಕೆ ಏನ್ ಮಾಡಿದೀರಾ?
ನಮ್ದು ಅಪೀಲ್ ಹಾಕಿದೀವಿ, ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಅಪೀಲ್ ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
Dismiss ಆಗಿದೆ.
ಆಮೇಲೆ
Dismiss ಆಗಿದೆ.
ಇನ್ನೆಂತ ಉಂಟಾ? ಇಲ್ಲವಾ?
Now my lords, my respectful submission before my lord says. But for granting my lords an order of police protection, at least show cause note or cause notice my lords.
ಯಾರಿಗೆ?
ನನಗೆ.
Not necessary.
Interference ಅಂತ ಹೇಳಿದ್ರೆ they should establish my lords.
For establish.
ಹೌದು, ಇಲ್ಲ ಅಂದ್ರೆ
establish ಏನ್ ಮಾಡ್ಬೇಕಾಗಿ? Police protection for the fruits of the decree.
No my lords, what in case my lords if it is executable decree my lords correct. Police protection.
ಏನ್ ಬೇಕಾಗಿ? ಅದರ್ವೈಸ್ ಡಿಸ್ಟರ್ಬೆನ್ಸ್.
ಇದರಲ್ಲಿ not to disturb ಮಾತ್ರ ಇರೋದು, ಅದಕ್ಕೂ police protection ಕೊಟ್ಟರೆ.
ಹೌದು, ಡಿಸ್ಟರ್ಬ್ ಮಾಡಬಾರ್ದು.
That's it.
See judgment of the coordinate bench. Judge Kumar Patil.
ಅದು ನೋಡಿದ್ದೀನಿ.
ನಿಮ್ಗೆ ಕೇಳಬೇಕು ಅಂತಿಲ್ಲ ಅಲ್ಲಿ.
ಇಲ್ಲ, ಅದರಲ್ಲಿ ಅವ್ರು ಹೇಳ್ತಾರೆ ಏನಂತಂದ್ರೆ ಅಂಡರ್ ಅದು ಇದೆ ನನ್ನ.
ಯಾವಾಗ? ನಿಮ್ಮನ್ನ ಕೇಳ್ಕೊಡ್ಬೇಕು ಅಂತಿಲ್ವೇ ಇಲ್ಲ.
ಫಾರ್ ಟೆಂಪರರಿ ಪೀರಿಯಡ್ ಕೊಡ್ಬೇಕು ಅಂತಿದೆ.
ಆಯ್ತು, ಹಿಂಗೆಲ್ಲ ಸೋತಾಗಿದೆ, ಇನ್ನೇನ್ ಟೆಂಪರರಿ? ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್.
That's become final.
That has become.
Dismissal has become permanent. Temporary injunction is problem.
ಇಲ್ಲ, ಇದು ಇದರ ಮೇಲೆ.
The petitioner is before this court. Petitioner, the judgment debtor, is at the doors of this court calling in question an order dated 23/2/2024 passed on application IA-1 of 2024 filed by the plaintiff. Decree holder heard so and so.
Defendant, counterclaim. Counterclaim.
Defendant, correct.
Okay.
They heard so and so. Facts in brief germane are as follows. The petitioner, the judgment debtor, is said to have purchased a purchased a subject property. A suit is instituted by the present petitioner in OS 508 of 2014 for injunction, injuncting the interference of the interference of the respondent in the peaceful possession of the petitioner. A counterclaim is registered by the decree holder, respondent, in the said suit. The suit in OS 508 of 2014 comes to be rejected while the counterclaim comes to be allowed. The counterclaim ostensibly is with regard to the counterclaim schedule property. The issue in the list, counterclaim schedule property. The judgment and the decree, the rejection of the plaint in rejection of the plaintiff's claim in OS 508 of 2014 is challenged by the present petitioner before the first appellate court in RA 66 of 2019. The appeal comes to be rejected on 25/8/2021. ನಿಮ್ದೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವ ಅವರು? ಕೌಂಟರ್ ಕ್ಲೈಮ್
ಕಾಮನ್ ಆಗಿ ಆಮೇಲೆ ಮತ್ತೆ
rejected, which would be that the relief sought by the plaintiff in the plaint comes to be affirmed. Rejection of the relief sought by the plaintiff in the plaint comes to be affirmed, and the decree, insofar as the counterclaim was concerned, also gets affirmed. The issue in the list is not with regard to the merit of the decree or otherwise. The decree holder files an application before the concerned court seeking police protection on the ground that the respondent decree holder is interfering with the peaceful possession despite the loss of the suit and the appeal. The concerned court, by the impugned order, grants such police protection to the decree holder by the following order.
Annexure A, page
17 and 18. The learned counsel for the petitioner is on the premise that he was not heard at the time when the order of police protection would be granted. The coordinate bench of this court in so and so court has laid down certain guidelines with regard to the grant of police protection, which one of the guidelines so laid is an ex parte police protection also can be granted if the situation so warrant. In the case at hand, it is not the suit is not at the nascent stage. The suit is rejected while the counterclaim is allowed. Therefore, the petitioner's counterclaim schedule property, if were to be counterclaim schedule property.
Yes, ma'am.
Counterclaim schedule property was if the counterclaim schedule property was disturbed by the plaintiff, it was the duty of the concerned court to have granted such police protection in terms of the law laid down by the coordinate bench as quoted supra. In the light of the order warranting no interference, as I do not find any perversity in the said order, the petition deserves to be rejected, therefore rejected. Interim order of any kind subsisting stands dissolved.
Lord, first ಅಲ್ಲಿ ತಾವು ಪಿಟಿಷನರ್ ಓನರ್ ಅಂತ ಹೇಳಿದಾಗಿದೆ. ಪಿಟಿಷನರ್ ಇಸ್ ನಾಟ್ ದ ಓನರ್ ಎಟ್ ಆಲ್.
ಹೂ ಇವರ
ಅವ್ರ ಓನರ್ ಎಲ್ಲ ಅಲ್ಲಿ
ಅದ್ ನಾನು ಮಾತ್ರ ಹೇಳಿದಿನ ಓನರ್ ಅಂತ ಹೇಳಿಲ್ಲ. ಎಸ್ Yeah, for stay.
1 to 3.
In a suit for partition, I filed application for impleading.
Who are you?
Agreement holder, my suit for specific performance is pending consideration before the very same court. Therefore, made an application.
When did you enter into agreement, sir?
Agreement is in the year 2011.
Long before the institution of the suit?
Please.
Yes, sir.
My suit for specific performance is pending consideration in the very same court.
Let both be taken together.
And an opportunity to contest the proceedings by filing. That's all, as a agreement holder.
So let both of them be taken together. If situation warrants, you will be let in later. ಅದಕ್ಕೆ ಸ್ಟೇ ಆಗಿದೆ ಈಗ.
ಅಲ್ಲ ಸ್ಟೇ ಆಗಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
Is covered by judgment, my lords, passed by the coordinate bench.
ಕೊಡಿ.
What the coordinate bench has stated is that, my lords, in a suit for partition, the agreement holder cannot seek for impleading.
That is correct. That is why I said he will not be let into the suit.
Please.
Yes. Yes, sir. Partition is between family members.
Correct, madam.
And you jotele iri pakkadale.
My apprehension is
don't go into the house.
Possible collusion between them. Not then, I may be in a.
Your suit
may not be in a position.
Your suit is still there, sir.
Still there in the very same court.
It will be there.
Honorable Madras High Court says.
ಅದು partition ಅಲ್ಲಿ. Madras High Court ಏನು?
Same set of facts. ಅದರಲ್ಲೂ agreement holder filed an application for impleading. That was allowed.
When did you institute the suit?
And subsequent to his suit.
Partition suit ಆದ್ಮೇಲೆ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ immediately
ಬರಲ್ಲ ಒಟ್ಟಿಗೆ ಇರಲಿ. Why did you keep quiet for 11 years?
There are certain assurances from the
11 years. Why did you keep quiet?
Last may kindly see.
According to you, 2011 is the agreement of sale.
And I have paid.
2022 is the suit.
Please.
Why did you keep quiet for 11 years?
Kindly see, I have made averments in my suit. They have assured that and in the statement of objection.
ಏನು assurance ಏನು?
ಅಲ್ಲ ಮಾಡ್ಕೊಡ್ತೀವಿ that is the assurance.
Yeah, we should have
go on taking time
correct
to execute this sale deed, and 25 lakhs has been received and statement of objection filed here, but they have not disputed my agreement. You will ask me kindly see.
ನಿಮ್ ಸೂಟ್ ಅಲ್ಲಿ 711 ಹಾಕಿಲ್ವಾ ಇವರು?
There is no such. But para number 5 of their statement of objection.
Sir.
We'll
ask the court to take the two together. That's all. No question of stay.
Stay better than dispose ಮಾಡಬಹುದು with an observation that both the suits may be clubbed.
No clubbing.
Otherwise, if no possible collusion between them.
That you are ಅದಕ್ಕೆ ನಿಮ್ದು ಜೊತೆಗೆ ಇರುತ್ತೆ.
Opportunity to contest their at least by filing WS.
Partition suit how can
say that I am the agreement holder.
Sir.
My right.
If sale deed had been executed and rights had been accrued or crystallized, it's a different thing. Yes.
If their suit in their suit they settle the issues.
ಅದಕ್ಕೆ ನೀವು ಜೊತೆಗೆ ಇರ್ತೀರಲ್ಲ ನಿಮ್ದು ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Then 50% ಈಗ ಡಿಫೆಂಡೆಂಟ್ ಗೆ ಇದೆ ಇವ್ರ ಸೂಟ್ ಅಲ್ಲಿ 50% my vendor has got 50% share.
All right.
Even if
your suit is still there.
Still there.
Yes. Anything else, sir?
The petition if necessary in the future at least.
Andre, you withdraw this petition and file necessary application at the relevant point in time if you want. Otherwise, I'll answer it. Not a problem.
Such a liberty to file.
File what?
If necessary.
File what?
Application
for what?
for come on record in the suit.
ಐದು ಅದ್ ಮತ್ತೆ ಇದನ್ನ ಅಲೋ ಮಾಡ್ದಂಗ ಆಗತ್ತೆ. Other things,
ನನಗೆ
if you want clubbing and other things, file application, let the court consider.
my right over the property as agreement holder, at least 50%,
ಆಯ್ತು.
3 acres of land.
Nobody has trampled upon your right now.
If they,
If they, ಅದ್ ಮಾಡಿದಾಗ ಮತ್ತೆ ಬನ್ನಿ.
colluding with each other.
Partition suit ಅಲ್ಲಿ you will not be let in.
And both the, at least, you ask me kindly observe that both the suits,
ಎರಡು ಒಟ್ಟಿಗೆ ಆಗ್ಲಿ ಬಿಡಿ.
ಆಗ್ಬೋದು.
The petitioner is before this court calling in question an order of the concerned court dated 27/6/2024 rejecting an application filed by the petitioner order 1 rule 10 seeking to implead himself as a party respondent in a suit for partition instituted by the respondents herein. The petitioner heard so and so. The petitioner claims to be an agreement holder from the hands of one of the defendants in OS
defendants 1 to 3.
Defendants 1 to 3 in OS 50 of 2022. The claim of the petitioner is on the strength of an agreement that was entered into in the year 2011. The suit for partition is instituted between the members of the family, the respondents herein, in OS 50 of 2022. After the institution of the suit, the petitioner appears to have woken up and registered a suit for specific performance in OS 149 of 2022. In the light of the agreement in subsistence between the defendants 1 to 3 and the petitioner, seeks to implead himself as a party respondent / defendant in additional defendant number 5 in the suit instituted for partition. The application comes to be rejected on the score that there is no warrant of any agreement holder entering into a suit for partition between the members of the family of the joint family properties. The concerned court rejects the application, the rejection of which is in tune with law as considered by the coordinate bench of this court in writ petition 37203 of 2015, wherein the coordinate bench has held as follows, para 4 in the end order. The petitioner is in the same position as was considered by the coordinate bench. The petitioner is an agreement holder of an agreement of sale executed between the petitioner and the defendants 1, 2 and 3.
My citation may kindly be referred.
1, 2 and 3, Kodi. 1, 2 and 3 before the 1, 2 and 3 in the suit for partition, i.e. 59
50 of
2022. The 50 of 2022.
Page number 13 in that.
One moment.
Similar
Madras High Court. Persuasive. ಅದು binding. Yes.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಈ ಕ್ವೆಶ್ಚನ್ ಡಿಸೈಡ್ ಮಾಡಿಲ್ಲ.
ಪರವಾಗಿಲ್ಲ. Yes. Anyway, I'll observe about that. So the petitioner, it is settled principle of law. In the light of the judgment rendered by the coordinate bench as quoted herein above, no fault can be found with the order passed by the concerned court rejecting the application for the entry of the petitioner as additional defendant number 5 in a partition suit. The learned counsel for the petitioner seeks to place reliance upon the judgment of the High Court of Madras in AR 1968 Madras 142, which according to the petitioner is on covers the issue. In the light of the judgment rendered by the coordinate bench being binding on an identical issue and not the persuasive value of a judgment rendered by a different high court, I deem it appropriate to follow the judgment rendered by the coordinate bench. Even otherwise, the petitioner cannot now contend that he would implead himself in a partition suit of the members of the family. However, the learned counsel submits that both the suit of the petitioner for specific performance in OS 149 of 2022 and the partition suit in OS 50 of 2022 is being considered by the same court. The only observation that can be made now is that the concerned court shall consider both the suits together, consider and decide both the suits together, not clubbing though, with the aforesaid observation without interference with the impugned order. The petition stands disposed.
56.
petitioner, my lord, waste time.
Fresh time, no grants time, yes.
Arbitration award, my lord.
ಇದ್ರಲ್ಲಿ ಇನ್ನೊಂದು MFA ಇದೆ, my lord.
Award came to be passed in my favor. His second 34 application dismissed. I filed execution petition before the commercial court. Commercial court issued an attachment warrant. That was challenged in MFA. MFA is still pending. And the petition was filed on the ground that the commercial court has no jurisdiction to execute the arbitration award. That is the only ground.
That is covered, sir. Sorry. Give it,
Pass
yes.
on my matter. Pass on the matter.
Vacating style time ಕೇಳಬೇಡಿ. Sundar, myself considered, sir.
Interim order ಇದೆ, sir.
Interim order?
Yes, ma'am.
Pass over ಗೆ?
Yes.
No, no. I'm vacating the, disposing the petition.
MFA pending ಇದೆ ಅಲ್ಲಿ.
ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ ಅಲ್ಲ. Yes, who's your senior?
On the way.
On the way ಇದ್ದಾರೆ.
Can you pass on?
ಅವ್ರಿಗೆ ಹೇಳಿ petition on the way ಇದೆ ಅಂತ. ಇದು ಬರ್ಬೇಕು ಈಗಲೇ, yes. Pass over. Next.
57.
I am appearing for petitioner, my lord. My lord, petitioner number 1 filed vacating stay, my lord. Today I filed the objection to vacating stay, my lord.
ಓ ಯಾಕೆ ಇಷ್ಟು ಲೇಟ್ ಆಗಿ ಹಾಕಿದ್ದೀರಾ? What is the suit for? Partition.
For partition and separate.
What is the order under challenge?
They file REA, my lord, they seek for 41 rule 5 ಅಲ್ಲಿ stay ಕೇಳ್ತಾರೆ FTP ನ. That has been rejected, my lord. This is the third round of litigation. The petitioner is my husband's brother, my lord.
FDP pending ಇದೆಯಾ?
FTP finalize execution ಆಗಿದೆ.
Conclude ಆಗಿ execution
First
ಹಾಕಿದ್ದಾರೆ.
ನಾನು partition.
ಹೇಳಿ.
Conclude ಆಗಿ execution ಹಾಕಿದ್ದಾರೆ. ಮತ್ತೆ OS ಮೆಮೊ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ ಫೈಲ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ, my lord.
ಏನ್ ಮೆಮೊ?
ಸೇಮ್ ಸೂಟ್ ಸೇಮ್ ಪಾರ್ಟಿನೂ ಸಹ OS 55/2024 ನಲ್ಲಿ ಅದು ಇವಾಗ ಮೀಡಿಯೇಷನ್ ಅಂತ ಹೋಗಿದೆ. ಅದನ್ನ ಮೆಮೊ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸಹ ಹಾಕ್ತಾ ಇದ್ದೇನೆ. ಅಂದ್ರೆ ಪುಷ್
ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
My lord, that suit was filed by her.
Please.
Anyway.
Petitionerದು
List on Wednesday, 3rd September.
lord ಅದರೊಳಗಡೆ INO
ಕೊಡಿ, ಎಲ್ಲ
captain
ಕೊಡಿ.
abeyance ಇದೆ.
ಅವತ್ತು ಟೈಮ್ ಕೊಡಲ್ಲ?
Please.
Yes.
Please. Interim order extended.
Interim order subsisting will continue to the next date of hearing.
Date.
Same stage.
Date, my lord.
3rd September. Yes.
Please. Grateful.
Before the petitioner, your lordships. My senior is online, lordships.
Modification of, in modification.
I appear for the petitioner in this case. This is a case to deal with in civil court allowing an application for appointment of an arbitrator under section 11, which is not permissible. Only the High Court can appoint an arbitrator under section 11 of the arbitration.
Now what is?
Now your lordships will go to page 25 of the petition. Very simple.
Secured interim order, not compliant.
Order, sir.
One minute. I will just
1 minute.
50% deposit ಮಾಡಿ ಅಂತ there was an interim order.
ಅಲ್ಲ, order is not sustainable at all.
One second.
Section 11.
No, that is not the question here.
What is the order? ಅದೇ order ಅಲ್ಲಿ ಇರೋದು.
ಅಲ್ಲ, execution proceedings. In the execution proceedings, my lord, they have now come up for the first time, and there is an order. The trial court says I cannot go beyond the award.
Oh, one moment. Arbitrator was appointed. One moment, sir. Why are you on VC?
Yes.
That's on merits of the case, my lord. They have not questioned the original award of the arbitrator. In the execution.
One moment, sir.
Sorry.
The arbitration is acted upon. Everything is done.
Acted upon. Award is passed. That was execution was filed before that court. That was transferred here because the judgment debtor is at Bangalore. At that stage, my lord, they come and file an objection, which is rejected, my lord, by the executing court. That order is challenged. They secured an interim order. They do not comply with the interim order. Now they want
what is the interim order?
To deposit 50% of the award.
Ellide?
Order, my lord, dated 13/12/2024.
13/12/2024. List the petition if office objections are complied.
Rajmala. In addition, the learned counsel for the petition director serve.
They have not complied with the order.
They have not complied with the interim order. That is the modification they are now seeking.
Yes, sir.
Yes, Your Honor. Now, your lordships, it's a very settled principle that I cannot go to the police station, file a section 11 and ask him to appoint an arbitrator.
Sir,
I cannot go to the.
Don't give me two rudimentary examples now.
Yes, Your Honor. I'll take Your Honor to page 25, which is relevant.
Who asked you not to raise that question earlier? Why did you suffer an order? Suffer an arbitration, keep quiet. If you go and sit in the police station and keep quiet throughout your life, nothing can be
I
done.
did not keep quiet. That is the point, Your Honor. I did not keep quiet.
Why did you accept his order?
I did not accept his order, Your Honor.
Why did you accept his order? Why did you go before the arbitrator, suffer an award?
Page 48, Your Honor.
And now you can't go back. Now 50% deposit, why have you not made?
I will just explain to Your Lordships. For 2 minutes, I will just take Your Lordships that I was not silent at all.
Come at 2:30.
Please, please, Your Honor.
Yes. Yes, next.
Application seeking impleadment is rejected.
For the respondent, kindly pass on, my lord.
Vacating order. Vacating interim order.
We filed an application for vacation.
In a suit for declaration, my lord, of a legal error, the petitioners were sought to be impleaded. In the suit, my lord, my vendor was impleaded. Kindly take the plaint, my lord. At page number 369.
Suit for?
Declaration. Declaration of the legal error. 373, kindly take page number 373, my lord.
Why are
my
you
vendor was impleaded as a party. Respond, defend number 22. His impleadment was made on an application made under Art 1 Rule 10. Subsequently, this order, the trial court, by exercising jurisdiction under Art 1 Rule 10, deleted my vendor. Page number 402, my lord.
Sumoto?
Sumoto. That order was assigned before this honorable court. Annexure C, my lord. Annexure E at page 403. This honorable court has set aside the order.
Later.
Later.
ಏನಾಯ್ತು ಆಮೇಲೆ?
ಆಮೇಲೆ my vendor has allotted sites to us and it has executed the sale deeds.
Now why are you here?
We have the allottees in respect of the sites formed by my vendor.
All right.
And we are in possession, we are the necessary parties. If my vendor were to be the party.
Art 1 Rule 10 rejected. Yes, sir.
In Annexure E, my lord, their vendors are already of parties, they have already cross-examined me.
They are allottees, sir.
It's the subject matter, survey number 28. Survey number 28 is not the subject matter of acquisition at all. It is.
Your residents, your allottees of what survey numbers?
Composite various survey numbers. One such survey number was belongs in respect of.
One such, are you claiming only 28?
Yes.
Then 28 is not the
subject matter. No, not only 28.
Come to the suit,
kindly see the sale deeds executed, my lord.
Come to the suit schedule properties.
Yes, schedule. Plaint. Suit schedule property illa.
Okay.
Declaration of the office, who holds the office, inferior office under the village office of Arbitration. That was the issue before the trial court. One of the borrowers under the
vendors idaralla alli bidi.
Vendors, they have not cross-examined. They have colluded. That is my allegation in the writ petition. Post for arguments now. After 1 year, they have purchased the property. Kindly see the findings recorded by this court. Suit 2024, they want to come on record. What they were doing for so long. This on court,
yes, sir.
While allowing the writ petition, after deleting my vendor as the party at page 411.
The vendor is back into the fold now.
No, he is not contesting the suit at all. That is our grievance. That is our grievance. No, he is not. If the allotment is made and my vendor is not left with any interest and it is conveyed to us, I am the successor in the estate. Am I not entitled to come on record, my lord?
There was 12 acres, my lords.
No, survey number 28 is not a part of the.
No, survey number 28 was part. Can I just take a minute, my lords? I can
relax.
just catch
yes.
411, my lord. Page number 411.
Ruben.
Kindly take the 411, the findings recorded by this court while reversing the judgment.
Page
411.
411.
Yes. Para number 4. It is to be noticed that the petitioner claims right through the sale deed dated 3/10/2001, which eventually can be traced to the rights of the office holder. The question as to who is the legal representative of the office holder is a matter that is being decided in the present suit. It is also not in dispute. But if the suit records a finding relating to either of the branches as being the legal representatives of the office holder, the rights that flow to refund number 22 would be affected either adversely or his right would be affirmed. The court having impleaded him on 14/12/2018, the court finds that the order striking off from arraying as a party may not have been necessary considering the stage of the suit as well as nature of the issue. The question as to the right of defendant number 2 as regards the properties purchased by him is also a matter that could be determined while final adjudication is concerned. It would be appropriate to avoid multiplicity of proceedings and also ensuring that the defendant number 2 is bound by the proceedings that is to be continued as a party in such proceedings. This finding has attained finality. If
Yes, sir.
thereafter, my lord,
I think ಕೇಳಿದ್ನಲ್ಲ ಅವರು
one more fact I have to place on record. All these purchasers have filed suits for injunction. The society and also the plaintiffs.
All of you.
Yes, the suits are pending. If this suit goes uncontested for any reason, by way of collusion or otherwise, my interest will be in jeopardy.
Yes.
Lords, there was 12 acres of land, my lords, which was subject matter, my lords, of proceedings under the Karnataka Village Officers Abolition Act. Now, my lords, there was an order passed by the Tahsildar. Then in the statutory appeal before the district court, my lords, an order was passed that the Baravardar is one Mr. Timrai alias Bia, there is no dispute. The only dispute was with regard to, for the purpose of regrant, who are the legal heirs of Baravardar, because there were two sets of parties, my lords, who were seeking for saying that we are the legal heirs and the other branch is not the legal heirs. So the issue, my lords, with regard to whom it has to be who is the Baravardar, my lords, has attained finality. It is only with regard to the status of who are the legal heirs. The district court directed that a suit may be filed by either of the parties with regard to only the status with regard to who are the legal heirs of a particular person. With regard only after that, then you can again, whoever gets decided as a legal heir will be able to move the Tahsildar to get suitable orders. This order, my lords, has attained finality till the Supreme Court. Now a suit has been filed only with regard to status of as to which branch is a legal heir. Now in the proceedings, my lords, that took place under the Village Officers Abolition Act, Aircraft House Building Cooperative Society was one of the parties. Please, my lords.
Yes.
Aircraft House Building Cooperative Society was one of the parties in the suit. They claimed they were parties, my lords, in the regrant proceedings all along. Now, my lords, their interest is with regard to survey number 28. Now, since they were not made parties to the suit itself originally, because, my lords, it was only between the two branches. That because the only thing as
anyway, they are sought to be impleaded.
Now, my lords, they had sought to be impleaded, which was opposed to. And now finally, my lords, court said,
this court said you impleaded them.
This court said only for this reason, because they will be bound by that order. Now, what has happened is this: this property was not our cases; it was not subject matter of acquisition for Aircraft House Building Cooperative Society itself, and they have not filed any. They have not. These people are claiming they have filed injunction suits as against us, the owners of the property, and there is a dispute. Now they want to implead in a suit pertaining to only status, my lords, and it was at the stage of cross-examination. They had cross-examined at that stage, my lords. Aircraft House Building Cooperative Society is impleaded. Now every of the site holder, whether he has an interest or not, they have a separate suit pending. They have to, my lords, make out their case. Now they want to come and implead in this case, which is just only for status with regard to who is the legal heir, not with regard to the property. If the property is an issue, I understand.
I will only observe that the findings in this suit will not come in the way of the injunction suits.
Please.
Over.
Please.
That's all.
Please.
Idಕ್ಕೆ stay ಇದು ಒಂದು ವರ್ಷದಿಂದ.
Stay ಇದೆ.
Yes. The petitioner is before this, petitioners are before this court calling in question an order of the concerned court which rejects the application filed by these petitioners on Order 1 Rule 10 of the CPC, seeking their impleadment into the proceedings. They heard so and so. Facts in brief, germane, are as follows. A little history to the present impugned order is necessary to be noticed. It transpires that a tussle between the office bearers are the two legal heirs of
Timmaraya alias Bia.
two legal heirs of two claimants under the Village Officers Abolition Act was looming large throughout. This leads to institution of a suit in OS 161 of 2020. 2014, only insofar as who are the legal heirs of both the branches who were claimants. 15, I think 2015, only insofar as who are the legal heirs of the two persons claiming under the Village Officers Abolition Act.
One person. Who are the legal heirs of Timur alias Bia?
Who are the legal heirs of Timaraya?
Alias Bia, the Baravardar.
Baravardar. Timaraya alias the Baravardar.
Should be restricted only to Bia.
This is only for this purpose, sir. I am not answering the suit. Yes. Only to gather certain facts I am trying. Yes. In the said suit, an application comes to be filed by the vendors of the present petitioners who claim to be the allottees of sites. The application was initially allowed and was suo motu deleted by the concerned court. This becomes the subject matter of the proceedings at the hands of the coordinate bench in writ petition 5976 of 2021. The coordinate bench by the following order disposed the said petition, permitting the defendant number 22, the vendor of these petitioners, to be on record in the said suit. The order of the coordinate bench reads as follows, page 410 to 413. After the vendor of these petitioners go back into the suit, the petitioners file application in the suit under Order 1 Rule 10, seeking to implead themselves on the score that if the vendor would not protect their interest as allottees of the sites from the hands of the defendant number 22 would be put to jeopardy. The application comes to be rejected on the score that they are neither proper nor necessary parties. It is therefore the petitioners are before this court in the subject petition. The learned counsel appearing for the learned senior counsel Ruben Jacob representing the respondent submits that all these petitioners have preferred suits for injunction against whom?
Against the plaintiffs in the suit. Against the two branches.
Against the two branches or the plaintiffs in this suit, as the case would be. And those injunction suits are pending adjudication before the competent courts. The apprehension of the learned counsel for the petitioner is that in the event the vendor of the petitioners would not evince interest in the suit and or collude with the parties to the suit, their interest would be put to jeopardy. And the suits that are pending for injunction would lose their significance. The learned lose their significance. In the light of the aforesaid circumstance, as also the admitted situation that the petitioners have instituted several suits against the plaintiffs in suit in OS 2015 another? OS 161 of 2015, I deem it appropriate to dispose the petition without disturbing the impugned order with an observation that any order passed by the concerned court in OS 161 of 2015 will not come in the way or would bind the injunction suits pending before the competent courts instituted by the plaintiff.
I will, if I am not impleaded, my lord.
No, impleading I am not allowing at all.
No,
my
respectful submission, this honorable court has recorded a finding that my vendor is a necessary.
He is already there.
He is not cross-examination. He is not contesting.
That is the injunction suit hakidiralla, independent suit.
Injunction suit, it is a injunction simpliciter which will determine only the quantum of possession.
No, even injunction suit title also can be gone into. No
by respect, how the petitioner.
No, this. ಮತ್ತೇನು ಹೇಳಿದ್ರಿ ಹೂ ಅಂತ ನೀವೀಗ ಅದಕ್ಕೆ ಮುಂಚೆ?
No, if
this finding in this will not come in the way of injunction.
Impleadment of the petitioners before the trial court will not have any bearing on the suit for injunctions filed. That could be the proper.
ನಿಮ್ಮ ಇಂಪ್ಲಿಮೆಂಟ್ ಅಲೋ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿಲ್ಲ.
I have mistaken. I am sorry. No, I would reiterate. In fact, my lord, the judgment of this court was brought to the notice of the trial court.
That is what your vendor is already in, sir.
Order impugned.
That is why I said you have filed your injunction suits. The vendor, if it does not contest and anything happens, that would not bind the injunction suits, sir.
It is now the injunction suit will not decide the title of the parties. No, it is these properties in respect of which the allotments are made are purchased by the society and thereafter allotted to us. If my vendor was a party and he sells and allots the suits to the petitioner.
Petition suit
I
independent
am
ಆಗಿದೆ.
successors in the state.
No problem. Yes.
Why I should not be impleaded?
What were you doing for 14 years?
No, I don't notice. I was not knowing about the
Suit is only for status. Who is the legal heir? ಅಷ್ಟೇ. Property ನ issue
status or otherwise.
The learned counsel for the petitioner at this juncture would submit that if the petitioners would not be permitted to be impleaded into the suit in OS 161 of 2015, it would cause grave prejudice. Therefore, I deem it appropriate to notice the relief that is sought in the said suit. Elli the prayer?
Let's, prayer is for status.
Prayer elli.
Prayer, one second. Plea, 369 is the plea. 369. 386. I think prayer ಹಾಕಿಲ್ಲ ಅನ್ಸುತ್ತೆ.
Volume 2.
ಅಲ್ಲ ಏನಾದ್ರು ಕೊಟ್ರಪ್ಪ prayer ಎಲ್ಲಾದ್ರೂ ಇದ್ರೆ ಕೊಡ್ರಿ ಸೂಟ್ ಪೇಪರ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲಾದ್ರೂ ಎಲ್ಲಿ ನೋಟ್ ಮಾಡಿದ್ದಾರೆ ಜಲ್ದಿ ನೋಡಿ.
The prayer missing. Prayer page is missing.
Prayer miss ಆಗೋಗಿದೆಯಾ?
ಅಲ್ಲ ಅವ್ರ prayer.
ಅದು ಎಲ್ಲಿ ಹಾಕಿಲ್ವಾ ಇಲ್ಲಿ?
ಹಾಕಿದೀವಿ that page
It is recorded in, they have that page, only that page is missed. The plaintiff, entire plaintiff they have produced, ಅದೊಂದು page miss ಆಗಿದೆ. Para 7 at page 39 ಅಲ್ಲಿ the relief has been recorded by the trial judge. Copy ಇದೆನಾ? ಕೊಡಿ. ಕೊಡಿ. It has nothing to do with the property.
The prayer that is sought by the plaintiffs in suit 161 of 2015 reads as follows. Prayer and a paragraph of its prelude ಅಂತ ಹಾಕಿ. Page 19. ಇದೊಂದು ಆಮೇಲೆ ಇಸ್ಕೊಳ್ಳಿ. The prayer of the plaintiff in the said petition is for a declaration as to who are the legal heirs of the person Bayana, person Baya alias Timmaraya, ancestor of the plaintiffs. In this said suit, the vendor is already permitted by an order of the concerned court, and suits, plethora of them are preferred by the allottees from the hands of the vendor plethora of them preferred by the vendor for injunction which are pending adjudication before the competent courts. In the light of the aforesaid observation, in the light of the aforesaid prayer that the plaintiffs have sought before the concerned court, the order of the concerned court which rejects the impleading application filed by these petitioners is required to be noticed.
Starts at
dated 2/12/2024 is required to be noticed.
please.
The order reads as follows.
Page 39 ಅಲ್ಲಿ finding ಇದೆ. Point number 1 ಅಲ್ಲಿ.
Number 1.
Read page 38 and 38 to 40. I do not find any warrant of interference with the order refusing to permit these petitioners to implead themselves into the party, into the suit which is for the purpose as quoted herein above. While making it clear that any order that is passed in these proceedings, even it be against the vendor of the petitioners, would not bind the court before whom the injunction suits are pending adjudication. The concerned courts would consider the same as independent on the rights of these allottees from the hands of the vendors. It is with the aforesaid observation, without disturbing the impugned order, sustaining the impugned order, the petition stands disposed. Yes.
My lord said plethora of suits filed by the vendor.
Plethora of suits filed by the allottees.
Allottees, petitioners.
Petitioners. Suits filed by the plantors, the petitioners, plethora in number.
The suit was to be disposed of by March 24.
Adhe order is already. Kodi.
Time limit may be given to dispose it of.
Allondondu para barkodi. A coordinate bench of this court had already directed the suit to be concluded within an outer limit of 6 months from the date of receipt of the said order, which was passed on 6th October 2023. In that light, I deem it appropriate to infuse finality into the proceedings with a direction to the concerned court to dispose OS 161 of 2015. ಅದ ಇಲ್ಲಿರೋದು ಇಂಪ್ಯೂನ್ ನೋಡ್ ಅದೇ ಅಲ್ವಾ 161 of 2015 with an outer limit of ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಈಗ
Evidence, arguments.
outer limit of 4 months if not earlier. Yes.
Grateful.
Next.
60.
I appear for the respondent.
Respondent has filed an IA for vacating.
Ah.
The interim order was in fact granted after hearing the respondent was on caveat, my lords. Your
Howda.
lordship may kindly see the order
Where is
dated
the order?
18/12/2024.
18, I am there. Yes.
Learned counsel for the caveator respondent, it is on his submission, submits that a water channel runs adjacent to the property of the respondent. It is from this channel that the petitioner wants to drain water into her land. He submits if the petitioner is allowed to drain water to the land of the respondent would suffer enormously. The petitioner and the respondent are closely
Again,
related.
settlement ಆಗ್ಲಿಲ್ವಾ? ಆಯ್ತು, you maintain status quo. We'll decide, direct this seat suit to be
that's all.
concluded.
My only humble submission is this, my lords. First of all, on the guise of this interim order, they're coming and removing all the crops in the property. my lords.
Water channel, which
That
is
have
a
also
widow.
produced as
He is-
annexure R3.
The petitioner is a widow. He is none other.
Why she can't remove crops?
No, lords. He is none other than my husband's brother. He is having a land above my land, my lords. From his land.
ಅದಕ್ಕೆ
water
ಸೆಟಲ್
channel-
ಮಾಡ್ಕೊಳ್ಳಿ.
ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ನಾವು ರೆಡಿ.
I'm ready, my lord. They don't turn up.
ಅವ್ರು ನೀರ್ ಬ್ಲಾಕ್ ಮಾಡಿದ್ರೆ ನಮ್ ಕ್ರಾಪ್ಸ್ ಒಣಗೋಗುತ್ತೆ. They are blocking the water. One suit is only for permitting the water flow. Trial court granted an interim order. In spite of there being police protection, I could not harvest the crop. I had to obtain police, I have to approach the court and then harvest. Thereafter, the appellate court reverses on a flimsy ground.
Then we'll continue the injunction granted earlier.
No, my lords.
Or
In fact,
you settle the matter.
my lords may I make a humble submission. If my lords may kindly peruse annexure R2 and R3 photographs, my lord, it's not in dispute that there existed a water canal. We ourselves are saying that let the water canal, they can utilize the water from the water canal. But unfortunately, what they do, my lords, taking this honorable court's order, they come dig up the property of the respondent, create one more water canal.
No.
Please, I'm sorry. My lords may kindly peruse annexure R2.
Right.
There's already an existing water canal. In fact, the dates are also there, my lords. This honorable court granted an interim order on 18/12/2024.
ಅದಕ್ಕೆ it's better if both of you remove the bund between the two canals and use both the canals.
My lords,
Settle ಮಾಡ್ಕೊಳ್ಳಿ.
the second canal is not even required, my lords.
ಅದಕ್ಕೆ
In fact, this is in the property of the respondent.
You're
In
all
fact, if
brothers and sisters.
sister-in-law, my lords.
My husband is no more, my lords. He is my husband's brother. There was a partition. The property originally belonged to my father-in-law. Partition
Solid.
between
Parties to
two
the list.
shared it.
This court on 8/12/2024 had passed the following order. The parties were directed to explore the possibilities of a settlement as well in the said order. Till date, the parties have not sat across to explore the possibilities of a settlement. Therefore, the parties shall explore the possibilities of a settlement by the next date, list the matter on 12th September. Interim order subsequent.
We'll try, honestly, my lords, if it is referred to mediation also, let us try.
Therefore, the parties are referred to, parties are directed to refer to mediation, are referred to mediation. Parties are directed to appear before, ಯಾವತ್ತು ಹೋಗ್ತೀರಾ? 29th? Appear before so and so mediation on 29th at 3 PM.
Please.
List the matter on 12th September.
In the meantime, if I may request, my lords, let them not interfere with the property of the respondent
In the
and remove the.
in the
interim order.
meantime, interim order subsisting will continue to the next date.
Also, an observation may be made, my lords. They're going on removing the crops, my lord.
She's a lady.
My lord, the lady has a son. That is the problem.
Oh.
If the lady was alone, there was no problem, my lords. The son is the one creating a ruckus in the property. He's an adolescent creating a ruckus.
Adolescent.
Yes, my
Placement
lords.
of
My lords, at
Yes.
least let that observation be. Let them
No,
not
yes,
be.
yes.
Let
Next,
them
next.
not remove the crops and ಅಷ್ಟೇ.
Yes.
ಅಲ್ಲ, it's an observation ಅಷ್ಟೇ ನಾನು ಕೇಳ್ತಾ ಇರೋದು. Or let them be directed.
No,
my lords,
sir,
let-
you are asking for an observation which nullifies the order itself. No, sir. Yes.
Or let them at least not do so, my lords. Please.
Yes.
Much obliged.
Chilamba?
61, Lord.
Finally, this is a partition suit wherein I am the defendant.
Yeah.
Suit
yeah.
is-
What
suit-
is challenged?
It is a application filed by the defendant for amendment of plaint has been allowed on the second time. When a matter reached the stage of PW5, evidence of plaintiff, I have cross-examined PW1, 2, 3, and 4. Evidence is commenced.
What
I
is
have-
the reason for allowing it?
My lord, the application at page number 81, my lord, where the affidavit says the earlier advocate not carried out all these things before in the plaint. Page number 84 may kindly be looked into. 84 onwards. In the affidavit, my lord, they want to change entire plaint itself. In the IIP launch go through, it's delete everything and incorporate some new things.
Tell the application.
Application at page number 81. 81 onwards. Annexure E.
Proposed amendment.
Amend 5A to 5G and continuously everything.
5A, 5G after para 5. 5B, 5A to 5G.
And delete item number A to D shown in print schedule
Delete.
at page number 84.
Delete item number A to D shown in the plain schedule.
Print schedule. And
You are the defendant, right?
I am the defendant.
Ah.
And 3, delete item number E to G. And delete item number H to item number H. And 5, delete item number 1, I to J. 6, item number K to delete number M to everything in the plain schedule. My lord, they have cross-examined PW1, PW2, PW3, reach the stage of
First application of the amendment.
first application. This is the same application. First, in the first instance, the honorable trial court rejected the application. There is some factual error. Matter reached.
Where is the first order rejecting the application?
Please, my lord. That is at page number Annexure G at page number 98.
80?
Page number 98 onwards. There is some factual error. I conceded. ನಾನು object oppose ಮಾಡಿಲ್ಲ
ಅಲ್ಲ ಇದು ಯಾವುದು ಜಸ್ಟಿಸ್ ಕೃಷ್ಣ ಕುಮಾರ್ ಅವರ ಆರ್ಡರ್?
ಅದು ಹೈಕೋರ್ಟ್ ದಿಸ್ ಆರ್ಡರ್.
ಅದು satisfied.
ಅದು ಸ್ಯಾಟಿಸ್ಫೈಡ್ ಮಾಡಿ ರಿಮಾಂಡ್ ಮಾಡಿದ್ರು. ನಾನು ಅದಕ್ಕೆ ಅಪೋಸ್ ಮಾಡಿದೆ ಬಿಕಾಸ್ ದರ್ ಇಸ್ ಸಮ್ ಫ್ಯಾಕ್ಚುಯಲ್ ಎರರ್, ಕಂಪ್ಯೂಟರ್ ಮಿಸ್ಟೇಕ್ ಆಗಿತ್ತು ಏನೋ ಆಗಿತ್ತು. ಆಫ್ಟರ್ ರಿಮಾಂಡ್ allowed the application.
Your lordship sees, in the proposed amendment, what I have sought in para 5A to 5G, what I have stated is, my adoptive father and mother, that is Narayan and C. Lakshmi Devi, they have taken me into adoption, that is the second plane into adoption. And the biological parents are C. Gopal and C. H. Saroja. That's what I have stated here. Then in the proposed amendment at para 5B, I have stated that during the lifetime of my adopted father, he was allotted a site by the VDA, CITB. That is site number 75, measuring about 15 to 40 feet. And a sale deed also has been executed in his favor on 1/7/2000.
You did not know all that?
No, your lordship sees, this is in relation to the counterclaim set up by them.
Oh.
They had set up a counterclaim. For that, I am giving this explanation. Then I have also stated in para 5C, M. Narayan had mortgaged the property in favor of Mysore Housing Board and secured a loan rupees 10,000. Thereafter, he has discharged that loan. Then he has taken another loan from Bharat Cooperative Bank Limited for rupees 20,000. And he has put up the construction of the scheduled property. In para 5D, my own brother, that is Deve Gowda, has sworn to an affidavit and declaration dated 3/7/1967 for the first class magistrate Kolar, stating that site property bearing number 75 is the self-occupied property of M. Narayan. It's in this context. And in para 5B, what I have stated is, during the lifetime of M. Narayan, he has executed a registered will dated 23/1995, whereby he has bequeathed the site as property number 75 in my favor. There under the will, He has clearly stated that he has taken me into adoption when I am 9 months old baby.
All these have happened long ago, before the institution of the suit itself.
Your lordship sees,
Yes,
all the amendment what I am seeking is,
yes.
it is in relation to issue number 4. May I just pass on this issue?
They have changed the entire nature of the suit itself.
Suit change ಆಗಲ್ಲ.
Ah,
ಇಲ್ಲ ಏನು ಆಗಲ್ಲ ಇದರಲ್ಲಿ.
ಏನು ಆಗಲ್ವಾ?
Suit will not change actually. See, I am the adopted son.
Correct.
It is in that context only I have brought about this amendment. Whether the plaintiff proves that the second plaintiff is the adopted son of plaintiff number 1 and DCT Narayan. It is in this context I am producing the will dated 23/1995 to prove this issue.
Why you did not produce it earlier?
Lordship, see, the burden of proving issue number 4 lies on me itself.
That's all right. Why you did not produce all that earlier?
Lordship sees the earlier counsel.
That's the problem. Counsel. That
Not
cannot be
that
the
I am
reason.
taking some unfair advantage against the other side by producing these documents.
Yes, sir.
The amendment is only in respect of relation to proving issue number 4. That
Yes.
burden of proving issue number 4 is lies upon me once again.
No problems.
And your lordship says he has set up a counterclaim in the written statement claiming the self-acquired property of my father. It is in that context I have brought out this amendment. And your lordship sees the schedules were not properly arranged.
When
All
was-
schedules were
When was the written statement filed?
The written statement filed, my lord. 8/1/2018.
Written statement along with counterclaim.
Yes.
No,
Yes,
Your Lordship,
date
these
was not
schedules-
required.
8/1, could you,
Please.
8/1/2018.
Please, my lord.
Issues framed on?
Issues framed on
26 June 2019. After that, COVID came, all these problems were there.
When was the first application filed?
No, this is the amendment of these of one
The
only
first
application.
application.
ಅಲ್ಲ, ಯಾವ್ದು concede
ಅದು
ಮಾಡಿ.
ಅಲ್ಲ, ಅದು
application.
the honorable trial court considered and passed the order rejecting the application.
ಅಲ್ಲ,
That came before this
Oh,
honorable.
rejecting the application.
ಹೌದು, ಅದರಲ್ಲಿ ಫ್ಯಾಕ್ಚುಯಲ್ ಎರರ್ ಇತ್ತು. That's why I have not contested the writ petition.
What is
I
happening
myself
is,
agreed to remand the matter.
the body of the order,
Is
so
different.
far as my first application for amendment is concerned, court has agreed. Later on, that got mixed up with some other facts. And the court has dismissed the application. That was challenged in the High Court by filing a writ petition that has set aside. That's set aside. ಆಯ್ತು.
I have not contested. I agreed. There is some mistake in the
There was a mistake.
factual error.
The
Factual
court had
error.
agreed in all points. Finally, while passing the order,
ಅಲ್ಲ, if you want to agree now, fine. Otherwise, I will pass the order on merits.
This matter.
ಇದು amendment allow ಮಾಡಕ್ಕೆ.
In my lord, there is this, my lord, this is after commencement of evidence,
ಅದೆಲ್ಲ, that time.
they have due diligence, they have
So,
partiality.
that's all right. If you are agreeing, then I will pass. Otherwise, my judgment itself is there.
No, my lord, there are so many several judgments.
Your
over,
mind considering everything is there, sir. I think last month. Due diligence.
The Honorable Supreme Court held in several cases, my
No,
lord.
I'm only asking you, are you agreeing to the amendment?
No, my lord, it is, because these are,
yes.
lordship may kindly,
No, because earlier this application was, it had come up before this court and you have agreed for the amendment.
no, I have not
That
agreed.
is reconsideration.
reconsideration.
These are to both the parties.
He filed a writ petition, fixed that there is a factual error in the trial court order. I said, let it be remanded.
ಅಷ್ಟೇ.
And I may rely
No,
on
no,
the.
and one
So wait, sir.
submission,
Yes.
no, one submission is, the schedule properties, what I have described in the plain schedule, is not properly arranged. I have clean ಆಗಿ arrange ಮಾಡಿದ್ದೀನಿ ಅಷ್ಟೇ.
ತುಂಬಾ ಕ್ಲೀನ್ ಆಗಿ ಮಾಡ್ಬಿಟ್ಟು.
ಅಷ್ಟೇ, the reason is I have not changed the survey number, so extend nothing. Everything
Anything, yes.
remains as the same. Boundaries ಸ್ವಲ್ಪ ಮಿಸ್ಟೇಕ್ ಆಗಿತ್ತು, boundaries correct ಮಾಡಿದೀವಿ. Because tomorrow if it goes for final decree proceedings, there will be once again a problem.
Correct.
That's the reason why I've arranged
That's why I
everything.
asked. If he has no objection, fine. Otherwise, in law, it is difficult.
My lord, there are so many judgments. I mean,
The petitioner is before petitioners. The
Only one
petitioner
petitioner.
defendant is before this court calling in question an order dated 17/12/2024 passed on IA IA 24 of IA 24 in OS 276 of 2017 registered for partition and separate possession. The petitioner, the respondent is the plaintiff
Sorry,
or the second plaintiff before the concerned court, the petitioner, the defendant. The suit is instituted for partition and separate possession. The issue in the list does not relate to the merit of the matter or the merit of the claim of the plaintiff or the defense of the defendant. What has driven the petitioner to this court is the allowing of an application filed under Order 6, Rule 17 by the plaintiff seeking amendment of the plaint by the concerned court. The application was initially answered by the concerned court, which was challenged. Initially answered rejecting the amendment, which was challenged before this court in writ petition 1450 of 2024. A coordinate bench of this court on 17 January 2024 disposed the petition by the following order, page 107 to 110. The matter was remitted back for consideration afresh. The consideration afresh has happened by the impugned order. It is allowing the application for amendment. It is therefore the petitioner defendant is before this court. The learned counsel appearing for the petitioner submits that the suit was instituted in the year 2017. The counterclaim along with the written statement was filed in the year 2018. The issues were framed on 6/6/2019, after which and long thereafter, after 5 years thereafter, the application comes to be filed by the plaintiff, a plaintiff seeking amendment of the plaint. The reason rendered in the application is that the earlier counsel had erred in bringing in these amendments. The learned counsel submits that the amendments by their very nature would change the relief sought, boundaries and all other things in the plaint. The learned counsel for the respondent would on the other hand refute the submission in contending that the application for amendment became necessary because the earlier counsel who was representing the plaintiff had not brought in all the facts or not described the schedule appropriately, and therefore it is only that amendment that is sought. He would admit that on the basis of the issues already framed, evidence was in progress at the time when the application was preferred seeking amendment of the plaint. He would nonetheless seek dismissal of the petition. I have given my anxious concerns, the afore narrated facts. The issue now relates to allowing of an application under Order 6, Rule 17 of the CPC. Therefore, I deem it appropriate to notice the order so passed, page 33 to 37. The order is answering an application filed by the plaintiff. The application reads as follows. Page 81 to 91. And the first blush, the submission of the learned counsel for the petitioner that there is nothing changed would have become acceptable. And but on a deeper delving, it is seen that the stage at which the application is preferred and the nature of the application is amending the plaint in its entirety. Evidence had been let in terms of the pleading that was made earlier. The evidence now is sought to be erased by way of the amendment, and the amendment being allowed at the hands of the concerned court. That too at the stage when it was when PW1 was being cross-examined by the present petitioner. The submission of the learned counsel for the petitioner that it does not alter anything is noted only to be rejected, as all the factors that are now tried to be brought in the amendment were all facts which are prior to the institution of the suit, which the plaintiff was at every time aware. The action of the plaintiff in keeping quiet for about 7 years and then bringing out the said amendment only to counter the counter claim, only to counter what was said in the counter claim. That too after 5 years after filing of the counter claim is clearly hit by the proviso to Rule 17 of Order 6, which mandates due diligence both to the plaintiff and the defendant in seeking amendment of the plaint or the written statement as the case would be. The jurisprudence is replete with the orders passed by the apex court and various high courts, all of which are considered by this court in so and so court, where considered this court, where applications for amendment should not be permitted to be allowed for the asking, that too of the nature that is sought in the case at hand. Therefore, the petition deserves to succeed. The order dated so and so stands quashed. The concerned court is at liberty to regulate its procedure and take the suit to its logical conclusion. Next.
Judgment debtors writ petition challenging the order of attachment on the ground that no valuation was made before attaching the property, no assessment of value was provided for by the decree holder. And secondly, my lord, I have also stated in my application that I am ready to pay the decretal amount at 10 lakhs per month. Court has rejected even that.
Yes, sir.
Lord, their case is that, my lord, they are paying 10 lakh per month. Say the judgment, the suit was filed in the year 2020, my lord. 2024, the execution is filed, my lord. Subsequently, my lord, the court granted time, my lord, subsequently by month by month. They have paid 15 lakh, my lord. Thereafter they tracked, my lord, which led me to file an application for attachment of property in the name of the decree holder, my lord. That, on that basis, my lord, the court was pleased to pass the 10 lakh have already deposited. It's my investment amount, my lord. It is 1.5 crore, my lord. My investment, my lord, because I have to invest in separate.
Correct.
Please, I am interested only in money, my lord.
I am not asking for any concession, my lord. I pay per month 10 lakhs and close the already 30 lakhs ಕೊಟ್ಬಿಟ್ಟಿದ್ದೇನೆ. In another 30 lakhs ಕೊಟ್ಟಿದ್ದೇನೆ. 1 crore 46 lakhs.
146.
Yes, but I have paid 15 lakhs in trial court, 10 lakhs here, 25 lakhs. Another 125 lakhs I have to pay. 1 crore 25 lakhs. Every month 10 lakhs, Lord.
Every month.
Lord, in 10 months.
Bank EMI.
Lord, I agree, Lord, but I am not seeking concession. I'll pay the entire amount.
What is this?
Lord, concession in the sense I want installment.
That is the concession you are asking.
But I'll pay the entire interest, my lord, whatever that is ordered.
We'll grant you some time. Yes. Not you ask him. Not that.
Is 3 months time.
3 months ಅಲ್ಲಿ ಕೊಡ್ತಾರೋ ಕೊಡಲ್ಲ.
Lord, in his affidavit itself, he has stated by December end, he would completely pay the entire amount, my lord.
December end.
Yeah, this is December, my lord.
25 December.
25th December. This is statement, my lord. Statement.
But they didn't agree, my lord, at that time.
One
because
nimsha,
I would have paid. That is in the application.
You would have paid. You would have paid.
In the order itself, my lord.
At that time,
in the order.
I would have
paid then.
My lord, 10 lakhs per month, my lord, every month. That's what I have stated. They didn't agree at that point of time. Court rejected.
ಅದಕ್ಕೆ ಅವೆಲ್ಲ agree ಆಗ್ಬಿಡ್ಬೇಕು.
The court refers, my lord, to that.
Now till December we will grant time. You conclude.
Till April.
ಈಗ ಹೆಂಗೋ ಈಗ ನೀವು ಒಂದು ನಿಮಿಷ ಅಫಿಡವಿಟ್ ಎಲ್ಲಿ ಅದು 10 lakhs per month.
Para 9 of the order itself, my lord. Page 17.
Application ಅಲ್ಲಿ.
ಒಂದು ನಿಮಿಷ. Para 9 of the order. Agreeable pay by way of installments and therefore
within outer limit of
31/12/2025. ಯಾವತ್ತಾಗಿದ್ದ ಆರ್ಡರ್ ಇದು?
It is December, my lord.
Last December.
Please.
ಪರವಾಗಿಲ್ಲ. ಅದೇನು ಅವ್ರು ಅಗ್ರಿ ಆಗೋದ್ ಬೇಕಾಗಿಲ್ಲ. ಇಲ್ಲಿವರೆಗೂ ನೀವು 10 lakhs per month ಇಟ್ಕೊಂಡಿದ್ದೀರಲ್ಲ ಅದು ಕೊಟ್ಬಿಡಿ. No.
Till March.
No. It is your submission 31/12/2025 ಅಷ್ಟ್ರಲ್ಲಿ ಕೊಟ್ರೆ ಕೊಡಿ. ಇಲ್ಲಾಂದ್ರೆ dismiss it and permit execution.
In fact, I have challenged that order. The judgment in the appeal, my lord, appeal is pending before this court.
ಅಲ್ಲೇನ್ stay ಇಲ್ಲ ಅಲ್ವಾ?
I'll stay ಇಲ್ಲ. But I have said I'll pay the money. Therefore, till March, your lordship may grant me time.
It is your case, outer limit 31/12/25.
At that time, yes, my lord. They didn't agree.
At that time, we time ಏನ್ difference ಇಲ್ಲ.
They didn't
10
agree
lakhs
to-
per month ಇಲ್ಲಿವರೆಗೂ ಆಗಿದ್ರೆ ಏನಾಗ್ತಾ ಇತ್ತು?
They didn't take, I would have paid, my lord, every month I
ಎಲ್ಲಿದೆ
would have.
ಕೊಡಿ? Where is it?
My lord, I have-
Where is the money?
My lord, I have.
You would
to
have paid,
earn-
where is the money?
My lord, every month.
ಆಯ್ತು,
my lord,
every month 10 lakhs ಎಷ್ಟಾಯ್ತು ಈಗ? 1 month 10 lakhs ತೋರಿಸಿ. ಸುಮ್ನೆ ಅದೆಲ್ಲ.
ಇಲ್ಲ, ಆಲ್ರೆಡಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೇನೆ ಇಲ್ಲಿ.
ಎಷ್ಟು
pursuant to the
ಮಾಡಿದ್ದೀರಾ?
order of this court.
ಎಷ್ಟು ಮಾಡಿದ್ದೀರಾ?
15 lakhs.
ಇನ್ನೊಂದು 50 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡಿ. I will grant you 6 weeks time, deposit another 5 lakhs, 50 lakhs.
ಅಲ್ಲ 50 lakhs, 25 lakhs I'll deposit.
No, no, sir.
In 6 weeks.
No, no. This court, on 17/1/2025 had passed the following order. Deposit of 15 lakhs in terms of the order was made, subject to, was made a condition precedent for grant of an interim order. The interim order is extended from time to time and 8 months have passed by. The petitioner has only deposited 15 lakhs out of the claim of 1 crore for 25 lakhs. That out of the claim of 1 crore 46 lakhs, out of which 25 lakhs is now paid. Therefore,
30
what
lakhs,
remains
30
to be paid is 1 crore 25 lakhs.
30 lakhs. 30 lakhs is.
Even the interest gets accumulated.
15 plus 15.
30 lakhs is paid. What is to be paid is 1 crore 20 lakhs. Huh?
Yes. 1 crore 10 lakhs, 16 lakhs.
1 crore 16 lakhs, apart from the interest from 17/1/25 till date. Therefore, the interim order shall stand extended subject to the condition that the petitioner would deposit another 35 lakhs before this court on or before 24th September 2020.
My lord, first of all.
ಇಲ್ಲ.
First of all.
1st October,
No,
on or
first,
before
second.
26th of September. Yes. In the event the petitioner would not deposit, the interim order would get automatically vacated with, yes,
Please.
Much.
without any indulgence of extension being shown. Yes, next. Subject to the aforesaid interim orders. I heard that, yes.
Respondent has filed application for early hearing,
Suit for,
recovery of money.
what is the order under challenge?
My lord, the order under challenge is directing ex parte direction given to the petitioners to furnish security. My lord, according to the plaintiffs, suit for recovery of money allegedly advanced to petitioner's husband, my lord. The husband died on 11/9/2024.
ಕೊಟ್ಟಿದ್ರು.
My lord, according to the plaintiffs, it is 41 lakhs. 2019 and 5 lakhs ಕೊಟ್ಟಿದ್ವಿ, ಆಮೇಲೆ ಏನೋ 10 lakhs cash ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
Your husband.
Husband ಗೆ ಕೊಟ್ಟಿದ್ವಿ ಅಂತ plaintiffs. But the defendants have denied specifically that such money has been advanced. First defendant is the wife. The husband died on 11/9/2024. First defendant is the wife and second defendant is the son. My lord, what happened? They have sought for attachment before judgment. They have filed an application. And on that application, this order has been passed. In fact, the property stands in the name of mother of the first defendant and the first defendant. They have produced a joint development agreement that has been cancelled without producing the cancellation deed, standing in the name of the petitioner's husband.
It's ex parte
they
order,
have- ಹೌದು, ex parte order. Ex parte order. My lord, the difficulty is the respondent has not got any asset from the husband, my lord.
Okay.
Except the borrowing that he has left, there is nothing.
Yes, sir.
Lordship,
Let
kindly.
the court hear both of you and then pass orders.
Lordship, only one submission. They have produced the document, joint development agreement, Your Lordship. Kindly take the in page 41, joint development agreement. The Hirani, he invested the 37 by the husband of first petitioner and father of second petitioner. 37 lakhs out of 69 lakhs, he sold the property and entered into the joint development agreement. He developed the building. Now they are selling that building for 17 crores. That is the reason I have moved. It is there, he invested and he got the share for 2 floors. Now they are telling cancellation. There is no whisper word in the cancellation of, the thing is they have to go for the bank loan. That is the reason they cancelled that joint development agreement. It was in the name of the first petition.
Lord, there is a huge borrowing on the building itself. That statement
Let
that
the court
he
hear
had-
both of you and pass orders. It's an ex parte order.
Yes, my lord.
Now
Will-
they're enter into the agreement, they taken 10 crores and after that 7 crores.
No, I'll direct the court to pass orders on, by within 4 weeks.
Please.
The petitioner is before this court, calling in question an order of the concerned court which allows which by an ex parte order dated 19/12/2024 in OS 9036 of 2024 directs attachment of the property before appearance of the respondent. Therefore, the order impugned is an order passed ex parte without hearing the present petitioner, the respondents. The plaintiff institutes a suit for recovery of money before the concerned court. While issuing notice to the respondents, the concerned court directs attachment of the property as a security to the claim of the petitioner plaintiff of 41 lakhs. The passing of the ex parte interim order is what has driven, ex parte order of attachment is what has driven the petitioner to this court, petitioner defendant to this court in the subject petition. In the light of the order being ex parte, I deem it appropriate to direct the concerned court to hear both the parties and pass necessary orders on any application filed or even an order for attachment of the property prior to the rendering of the judgment. On the short score of the order being ex parte, I deem it appropriate to set it aside and direct the concerned court to hear both the parties with an outer limit of 4 weeks from the date of receipt of the copy of this order and pass necessary orders in accordance with law. It is, you don't alienate the property till then. Yes.
My respectful submission is, there is a problem, my lord. There is a huge bank loan. There is already an agreement. What my learned friend says is right. There is an agreement. I am not disputing that fact. My respectful submission is, let the application be heard and disposed of. my lord. Let there not be
With
an
an outer
order.
limit of 4 weeks.
Yes.
Yes, from the date of receipt of the copy of this order.
There is an interim order not to alienate.
4
4 weeks.
4 weeks ಅಲ್ಲಿ order ಇದೆಯಲ್ಲ. Don't alienate till then. Yes. Till the consideration of the application, the parties, the present petitioner shall not alienate the properties.
Please.
Properties to the
But
tune
there is-
of 41 lakhs.
My lord, the difficulty
ಬೇರೆ ಏನಾದ್ರು
is,
ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ಅದು ಏನಾಗಿದೆ,
To the tune of the 41 lakhs of the claim.
Mother is not even a party to the list. She is
Till
one of-
till
she
the
is the one-
consideration, it is for the court to pass necessary orders in accordance with law. Next.
64 dispose, 65.
Great.
Respondent.
Picketing stay.
Please.
ಏನು suit,
Suit for partition.
application,
Application for appointment of commissioner.
ಈಗಲೇ
My lords,
Decree
I
ಆಗೋಗಿದ್ಯಾ?
intervene.
Yes, not yet.
No, no.
When the matter is posted for judgment,
ಹಾ
they moved a writ petition before this honorable court or obtained interim order.
ನಂದ coordinate bench.
No.
ಹಾ.
My lords, I make a submission before your counsel.
Yes, sir.
Apologies, my lords, unable to come before your counsel physically. This case is for the partition suit. And we had filed an application under.
Suit for partition.
Please.
It's a suit for
amendment?
partition by the defendant.
Not
See,
amendment.
respondents.
Appointment of.
Court commissioner.
No.
Appointment of?
Refer the document to the expert, which is not at all a suit document.
It is a suit
ಸುಮ್ನೆ
document. my lords. They have filed an affidavit.
Track the proceedings ಅಷ್ಟೇ ಇದೆ.
No,
Yes.
no, my lords. My lords, we don't have a original documents with in our custody. And it is a forged document on an affidavit. She has come before the honorable court for the relief of suit.
Because it is not in her custody, it is forged.
No, no, no. It is not with us. That is a problem. We have filed a complaint regarding
Come,
that.
come.
I'm a
When do
mother of
when do you appear before the court?
afternoon, my lords, today.
Come, sir. Pass over.
Great, my lords. Okay.
Yes, next.
66.
For the response in this case, petitioner, suit for injunction, my lord. I am the owner of the suit schedule property.
My vendor purchased the property in the year 2002. I have purchased the year 2010. I have been in possession, peaceful possession. The respondent father, they have sold the property, 1 acre, 3 guntas. The expiry order, emergency notice has been issued. Against that order, I have challenged before this honor.
Both of you go back now.
I'll work with marital.
After taking an interim order, my lords,
Huh.
now they have encroached upon the land of the respondent, they are putting up construction. That is the grievance, that is why I have filed this application.
Ali, we'll vacate this, we'll send you back to the court to hear
have
both of you and
consulted-
pass orders.
Now, it's
I
an
have
expiry order,
consulted-
so far application, I mean, the notice is
ನೀವು
not
ಒಂದು
served on to
application
us.
ಹಾಕಿದಿರಲ್ಲ ಏನಾದ್ರು?
So far, notice is not served on to us. To the address that they have given, notice will never serve to us.
Now that you are here,
Yes, my lords.
you appear there.
One submission, page number 72 may be kindly be produced, 72. This is the adverse, my lords, that we have applied for with the survey department. That document, my lords, kindly
ಅಲ್ಲಿ
produce.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಸರ್ ಎಲ್ಲ.
After
No,
after
I just
filing the
submit,
suit,
my lords. What exactly is the,
after filing the suit, collision with the survey department, without my notice, they have.
Collusion.
ಹೌದು.
Yes.
that document, my lords, it
ಮೂರು-
says.
1 acre
They have encroachments, what has
ಇಲ್ಲ
happened.
ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಸರ್.
No,
the-
until then, let them maintain status quo, my lords. They are putting up construction.
No, my lord, interim order may be extended.
No,
because one-
status
one-
quo will be extended, yes.
No, my lord, 1 acre, 3 guntas, I am in 2000, ಇವಾಗ ಅವರು, they sold the property.
ಯಾಕೆ ಸರ್ವ್ ಆಗಿಲ್ಲ ಅವ್ರಿಗಿನ್ನು?
Sarvagiri, same address, they appear before the station also. That is in page number.
ಸ್ಟೇಷನ್ಗೂ
ಆವಾಗ ನಮ್ಗೆ
ಕರ್ಸ್ಬಿಟ್ಟಿದ್ದೀರಾ?
Stationally, we have not filed the complaint against them.
ಸ್ಟೇಷನ್ಗೂ ಕರ್ಸ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಆವಾಗ
So
ನಮ್ಗೆ
the
ಗೊತ್ತಾಯ್ತು.
complaint, they are disturbing my possession.
My lords, we undertake, let them restrict to whatever the property they have conveyed with lords. Will file an undertaking. Let them not
2002
outstretch their
sale
boundaries, my
ಮಾಡ್ಬಿಟ್ಟು
lords,
ಇವಾಗ
and to put up
encroach
construction on
ಅಂದ್ರೆ
my land.
After lapse of 23 years, now they are telling I have encroached 2-3 guntas of the land.
Will represent, my lords, I'll just file all
The
this application.
petitioner,
Let there be
don't
status
argue
quo.
the suit here, sir. The petitioner is before this court, calling in question an order of the concerned court dated 25/3/2025 by which no temporary injunction is granted, but an order, temporary injunction is not entertained and notice is issued. This court, in order to protect the interests of the plaintiff, the coordinate bench of this court, in order to protect the interests of the plaintiff, had granted temporary injunction that was sought before the concerned court in terms of the order dated 3/4/2025. The 2025, the respondent has now entered appearance and projects that on the strength of the interim order or misusing the interim order, construction is being put up encroaching upon the property of the defendant, in the property of the defendant. Since the application is still pending before the concerned court, i.e. the application filed under Order 39 Rule 1 and 2, I deem it appropriate to direct the concerned court to consider the application under Order 39 1 and 2 after hearing both the parties and pass necessary orders in accordance with law. In accordance with law, till the in accordance with law, an outer limit of 4 weeks from the date of receipt of the copy of the order. In the light of the interim order subsisting at the hands of this court, I deem it appropriate to continue the same with slight tweaking, that the parties to the list shall not interfere with each other's possession till the application is decided by the concerned court.
One submission.
Let them not put up construction on property which they are doing it, my lords.
My property.
Each other's possession.
Each other.
Yes.
And one submission, my lord.
Yes, sir.
Now, the suit has been transferred to care, number has been changed, 1091 of 2025.
ಬರ್ಕೊಡಿ. Yes. Ordered according.
And leave,
Let both-
case is
All
posted on-
all contentions projected before this court shall remain open to be
Let them be
considered,
an order of status
to
quo,
be
my lords.
considered before the concerned court.
Let them order of status quo until then, my lords. Otherwise, they are putting up. in a
ಇಬ್ರಿಗೂ
rocket speed.
injunction ಇದೆ ಸರ್.
Into-
Both of you shall not interfere.
ಆಮೇಲೆ one submission, my lord. Matter is posted on 15/10/2025.
ಹಾ.
ಅವತ್ತು
The petitioner is at liberty to 1510 ಇದೆಯಾ?
15/10 ಇದೆ. ಯಾಕಂದ್ರೆ new case number ಆಗೋದಕ್ಕೆ
Petitioner shall
What is the case?
file an application seeking advancement of the proceedings in the light of the order passed, in the light of the subject order which has directed the concerned court to dispose the application within an outer limit of 4 weeks. Next.
ಬಟ್ ಅಲ್ಲಿ ಅವರು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ, WS ಏನ್ ಹಾಕಿಲ್ಲ, ಸರ್ವ್ ಮಾಡ್ಬೇಕಲ್ಲ.
Survey ಮಾಡಿಲ್ಲ ನಮ್ಗೆ. We'll do it.
ಇದಕ್ಕೆ expert ಆಗಿ.
ಇನ್ನೂ ಒಂದು ಬರ್ಕೊಳ್ಳಿ. Since the party, the defendant is represented by counsel before this court, it is fixing ಮಾಡೋ ಡೇಟ್ ಅವ್ರು ಮಾಡ್ಬೇಕಲ್ಲ.
ಅವರು objection ಹಾಕ್ಬೇಕು ಅವರು.
ಕಾಪಿ ಬಂದಿದೆಯಾಗಲ್ಲ?
ಇಲ್ಲ, copy ಏನ್ ಕೊಟ್ಟಿಲ್ಲ.
ಪೆಟಿಷನ್ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಈ red petition ಕೊಟ್ಟಿದ್ದಾರೆ. OS not given.
The petitioner shall, the concerned court shall take up the matter, advancement bada, concerned court shall take up the matter on 29th of August and conclude the proceedings within 4 weeks thereafter. No separate notice be issued to the defendant, since the defendant is already represented before this court. It is for the defendant to to appear before the concerned court on the said date. Yes.
Until then, let them not put up.
Adala, that order will be there. Yes.
Right.
67.
I appear for petitioner, my lord.
Amendment.
4 to 9, my lord.
ಏನ್ amendment?
Main prayer ಮತ್ತೆ interim prayer ನ amendment ಕೇಳ್ತಿದೀವಿ, my lord.
Any objection?
My lord. My lord, the entire petition may be taken up for disposal, my lord.
ಅಯ್ಯೋ amendment ಏನ್ ಹೇಳಿ
Main prayer amendment
ಅದಕ್ಕೇನಾದ್ರು
ಆಗ್ಬೇಕು.
objection ಇದೆಯಾ?
My lord, my humble submission is, my lord, neither the main prayer nor the prayer that they want to amend now are maintainable before this honorable.
ಎರಡೂ ಇಲ್ಲ.
ಎರಡು maintain ಆಗಲ್ಲ.
Petition ಇಲ್ಲ.
ಹಂಗಲ್ಲ.
ಏನ್ what is the prayer?
Prayer is to stay the proceedings of the civil court pending disposal of the case before the running case before the land tribunal, main prayer. Interim prayer to stay the proceedings
Land
of the
tribunal.
land tribunal matter, Swami, ಇದು.
ಹಾ.
Section
ಅಯ್ಯೋ.
under section 132 of Land Reforms Act, the civil court jurisdiction is barred.
Land tribunal matter pending ಇದೆಯಾ?
Pending ಇದೆ annexed queue, my lord. My lord may kindly look into the annexed queue.
Yes,
It
sir.
is- My lord, what is pending before land tribunal is, my lord, in fact, the entire case of petitioners is that when application before land
If it is
tribunal was.
pending there,
No, my lord, it's disposed of. Form 10 is issued way back in 1980.
now what is pending now?
No, I have filed an application for amendment. Modification of the earlier order passed by the land tribunal in 2008 itself, my lord. So it is still pending. In this regard, I would like to invite the honorable court to look into annexed queue. It is the endorsement given by
ಏನ್
the.
invitation ಬೇಡ ತಾಳಿ. We'll hear it. Yes. This
My
the matter
application may
on
be allowed.
29th.
Obliged, my.
Yes.
68. Petitioners.
ಮಾಡಿದ್ರೆ
ಅದರಲ್ಲಿ ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಕು ಬಾಡುವ ಅನ್ನೋದು ನೋಡ್ಬೇಕು ಅಷ್ಟೇನೆ. The reason why I am submitting this is, it's a suit for partition is filed by the sister in which the present plaintiff is also a party. Suit for partition is dismissed. That is taken up in the appeal is pending. The plaintiff goes to the trial court and says that the suit for partition is pending. During the interregnum of that suit pending, injunction should be granted that they should not interfere with the possession and alienate.
ಡಿಸ್ಪೋಸ್ ಆಗಿತ್ತು ಆಲ್ರೆಡಿ.
Suit dispose ಆಗಿದೆ, appeal pending ಇದೆ. No, it's when a suit is filed for injunction, for partition, every person is a plaintiff and defendant.
Yes.
Where is any question of maintaining a suit for injunction? It's just that there is one more addition to the docket. More, nothing. Kindly have a look at page 26. I'll just take your lordship to page 26. That is the plea.
ಇಲ್ಲ ಆಯ್ತು ಅವರು. ಎಸ್ ಮೇಡಮ್.
My lords, they're complete strangers to this suit, your lordship.
Who?
1 to 3, they've nowhere stated who are they.
ಯಾವ
How are they
suit?
related to
Strangers to what suit? Injunction suit?
Injunction suit, my lords. So they're
Who has
causing
filed the
interference.
injunction suit?
We have filed injunction.
Who are
suit.
you?
We are the plaintiff, we're the co-sharers, your lordship. This is an ancestral property.
Huh.
So they're all complete strangers, Swami. So they're
Now,
before.
which is the partition suit?
OS 882 of 2008, page 26, para 8 in the plaint, they have said, what is the cause of action? If this kind of causes of actions are there, then there can be any number of
Straining.
injunction suits. Injunction application.
ಅವ್ರು ಆಗ್ಲೇ terrified ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ, wait.
No, my lords, they're just the
Oh, you are
strangers to
not,
the.
all right, sorry,
No,
yes.
No, my lords, they're strangers to the suit, to the property, your lord. They just creating the ruckus, they're beating up the plaintiffs, your lords.
Beating, ಅದಕ್ಕೆ injunction.
No, my lords, they have no
Police complaint
rights
ಕೊಡಿ.
to interfere into our property, my lords.
Now, which is, how did you get this property out of a partition suit?
No, my lords, it's still in the name of my mother, my lords.
Which is the suit
I-
for partition page ಯಾವುದು ರವಿಶಂಕರ್ sir?
Lords, page 26, para 8. And the judgment, my lords, may I just pass it on, my lords. This is the judgment.
Same plaintiff?
Yes. Lords, he is also a party because it's a suit for partition.
Correct.
He was also one of the parties.
Plaintiff or defendant does not matter.
Yes.
Nagaraj.
second defendant in
Yes,
the suit.
second defendant. What
Now
happened to
that the first appeal is pending, they'll have to file an application for injunction before the,
separate suit ಹೆಂಗ್ ಬರುತ್ತೆ? The injunction suit, of course you can.
not even
Not
injunction.
not in the teeth of a partition suit, but injunction independently ಹಾಕ್ಬೋದಲ್ಲ?
Cannot be, my lords.
Independent.
Section 41H says that an injunction suit can be maintained only in the event simplicity or injunction can be sought for. Here is a case where
ಏನ್
there is a-
ಕೇಳಿದ್ದಾರೆ?
Lords, they say that they are the joint owners of the properties.
That's the reason. Yes.
Once they say that the joint owners, they will have to ask for the relief more than the injunction which they are seeking. This would just be an interlocutory application, my lords, in a suit for partition.
Yes, we'll take it at 2:30. We'll continue it. We'll pass orders at 2:30.
Please.
Adjournment sir ಬೇಕಾದ್ರೆ ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್.
Page wise adjournment,
ಸನ್ಮತಿ ಸರ್ ಒಂದು ನಿಮಿಷ.
page 13, 69 to 72.
71, my lord.
Number 71, my lord.
71 vacating stay ಇದ್ರೆ ಕೇಳ್ಬೇಡಿ.
The council is out of.
ಹಾ ಕೊಡಿ. ಯಾವುದು ಅದ? 1ನೇ ತಾರೀಕು ಆಗಲ್ಲ. 71.
My lords, I oppose the adjournment
And next
because
week, any
he
date,
made
my
a
lord.
same submission on 2nd of June.
Then wait.
Yes. Please, my lord. 70, my lord.
Wait sir. Objection ಇದೆ wait.
71 is my.
Mine is 74.
ದಯಾಲು 70.
Still 70, my lord, I got some throat problem.
Opposition ಇದ್ರೆ ಈಗಿಲ್ಲ. When the matter is called, yes.
Page 14, 73 to 79.
73, my lords.
73 ಏನು?
Kindly have it tomorrow, my lords.
Tomorrow? No, tomorrow, yes.
74, my lord.
1 minute. I'm calling one by one, yes. 73, list after 2 weeks, next.
74.
74, vacating stay ಇದೆ.
I am for responding of 1 month.
Vacating stay.
Writ petition, one more writ petition is there, my lord.
ಇದು that same between the same parties.
ಹೌದು.
ಅದು ಟ್ಯಾಗ್ ಮಾಡಿ. Yes. 75.
74 date may be fixed, my lordship.
74 of 2 weeks. Yes, 75.
Date may be fixed, my lordship.
Interim order may kindly be explained. 74.
Interim order ಇದೆಯಾ? List after 2 weeks, yes.
74 all interim order.
76.
74 all interim order extend.
ಎಲ್ಲರೂ ಒಟ್ಟಿಗೆ ಹೇಳ್ಬೇಡಿ.
Interim order extend.
ಆಯ್ತು, ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಯಾವ್ದು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ.
ಹಾಗಾದ್ರೆ ಈಗ ಹೇಳಿದಿರಾ ಅಂತ ಮಾಡಲ್ಲ.
Sorry.
ಮತ್ತೆ ಬಿಡಿ. Yes. No date, sir. If you want adjournment, list after 2 weeks. Yes.
Page
Wait, sir. Page wise, 97.
15, 80 to 87.
Serial number 83, my lord.
80?
83, my lord. In the, regarding the same scheduled property in the Supreme Court, amicable settlement is being proposed, my lord.
Last time ಅದನ್ನೇ ಹೇಳಿದ್ರೆ. ಅಂತದ್ದೇನಿಲ್ಲ. Wait, let the respondent, you are for the petitioner. Let the respondent come.
85.
81?
Or 81.
83.
85, my lords.
83 ಹೇಳಿದ್ದು. ಇವ್ರು ಶ್ರೀಕಾಂತ್ MP ಅವರು ಮತ್ತೆ ನಿಮಗೆ ಗೊತ್ತಿರಲ್ಲ ಏನು. Yes, list after 2 weeks. Yes.
85, my lords. Short
80?
adjournment. 85, my lords. Short adjournment. I have to
In
take
this
my
case,
mother
my
to the
lord,
hospital, my lords.
There is
Interim
arrears
order
of.
ಇದೆಯಾ?
I have to take my mother to
Interim
the
order ಇದೆಯಾ?
ಇದೆ, my lords.
Objection ಇದೆಯಾ?
Short
Check,
objection.
my lord. Here, in arrears of rent of more than 15.5 lakhs is due, my lord.
Wait. Well, I'll adjourn it when it is called. Yes.
Page 16, 88 to 93.
88, my lord. Your lordship may kindly get
88 to
2 weeks time may be granted.
80?
88, my.
Up 2 weeks, yes.
89,
Huh.
there are 2 other connected matters between
Number
the same
code.
parties and it may be clubbed.
Tag the petition along with so and so. Interim orders ಎಲ್ಲಿದೆ continue ಮಾಡಿ. Next.
Page 17, 94 to 99.
94, my lords.
Appearing for the respondents, 94 serial number.
My lord. In there,
We are ready with this matter and
There is
we have
another
challenged the
connected matter
Supreme
with-
Court joint compromise here.
lords,
for this
another
court.
connected matter with the same parties, that is writ petition number 2652 of 2020.
Tag the petition along with so and so. 10th September. Yes.
Interim order.
My lords, in this matter, they have sought for 3 reliefs, interim reliefs, not to alienate, not to interfere. And taking that advantage of the order, they are getting into the position of our property.
Right, then list on 3rd September. Yes. 97?
weak accommodation, my lord.
You have the respondent.
Yes, my lord.
Objection?
Yes, please, my lord, I have to. The money that is
Next,
deposit.
next. Objection idra when it is called, yes.
Look, they don't have a say here. I have to.
That's all. When it is called, we will consider it, yes. Next.
Page 18, 100 to 107.
112
107 ಏನಿದು ಇಷ್ಟೊಂದು ಇದೆಯಲ್ಲ? Oh, that.
My lord, I appear for the petition, my lord. My lord.
All these connected matters, huh?
Yes, my lord, it is connected matter. My lord. Kindly be.
Yes, 112 ಯಾರ ಕೇಳಿದ್ರಲ್ಲ ಏನು?
Page 21, 110 to 116.
112, 2 weeks. 2 weeks, yes. Any other matter?
114. 114.
114 also 2 weeks, yes. Next.
Page 22, 117 to 121. Page 23, 122 to 129. Page 24, 130 to 135.
Plus 131, my lords.
Ah.
Just to be kept along with lords, WP number 18905.
Tag the petition along with so and so, yes.
Next is 22nd.
22nd.
That is there, connected matters.
Tag the petition along with so and so. ಅದು ಬರುತ್ತೆ ಬಿಡಿ.
Page 25, 136 to 138. List number 2.
Serial number 1, my lord.
Page 1.
List number 2 ಅಲ್ಲಿ.
Orders
Orders and ಬೇಡ.
Page 2, 7 to 9.
Serial number 8, my
Number
lord.
1, my lord.
Serial number 1, wait, sir. Yes.
Serial number 8, my lord.
Yes.
Lordship may have this matter after 2 weeks.
8.
Interim
List-
order may continue.
18th.
Serial number 10, my lord.
18th ಅದು ಮೇಡಮ್? 18th September. Yes.
Interim order may continue.
Serial number 10, my lord. Serial number 10.
Yes, sir.
Therefore, petitioner, my lord.
Yes.
For a week's stay, my lord.
18th September. Yes.
Page 4, 13 to 16. Page 5, 17 to 24.
Serial number 19, my lord.
Ah.
We have received statement of objection yesterday.
19th, same day.
Any day. Interim order.
18th September, yes. Next.
Page 6, 25 to 31. Page 7, 32 to 38.
May I
please your lords?
ಎಲ್ಲ I'll post them all on 4th, 4th, 11th or 18th. All 3 dates, yes. No, tax councils, nobody need be there. Will because those are not dates given by me. Yes.
May I please your lords?
Matter, my
Item
lord.
number 36, your lords. May be posted after 2 weeks, your lords.
ಆಗೋಗಿದೆ, yes.
My lord,
Second
one
list, Second list is it?
Second list, your lord.
All
Lord,
right.
one matter, my lord, for tomorrow, my lord, one matter, my lord.
Why?
Not judgment, the trial court fixed the date for judgment of Friday, my lord.
Ah.
Lordship may kindly. Tomorrow, my lord.
ಏನ್ matter?
My lord, FTP proceedings, my lord. Respondent number 1 has executed the registered release deed in favor of the petitioner, my lord. For that reason, I filed the application under section 151 of CPC to dismiss the FTP proceedings, my lord. In spite of the registered release deed, my lord.
When was it released? Register ಆಗಿದ್ದು ಯಾವಾಗ sir?
December, my lord.
Release date.
December 2024, my lord.
Anyway, ಕೊಡಿ, yes.
Tomorrow, my lord. Tomorrow, my lord.
One ಏನು sir? One pass over, then take it at 2:30, we'll close it. But tax councils won't be there. That will be 4th.
Requesting for tomorrow, my lord,
ಮಾತ್ರ
kindly.
4th.
Kindly tomorrow.
ತಗೊಳ್ಳಿ ರುದ್ರಪ್ಪದ ಮೆಮೊ ತಗೊಳ್ಳಿ.
Madam,
Tomorrow,
Tomorrow, 27 and 34.
ಯಾವ್ದು ರಿಮಾಂಡ್,
My lord, 27 and 34,
all that tomorrow ಹಾಕಿ.
please.
ಅದು ರಿಮಾಂಡ? ಅದೆಲ್ಲ ಹಾಕಿ.
Serial number 28 also, it has to be remanded back.
Number 33.
33? ನಾಳೆ ಬೇಕಾ? ಅದೇ ನಾಳೆ ಬೇಕಾ?
Tomorrow also.
What is the matter?
Tax matter, my lord.
ಅದು ಗೊತ್ತು ಸರ್. ಅದು ಬಿಟ್ಟು, can it be disposed? Otherwise already 120 matters are there. That is why.
Next week.
28th or 4th.
28.
Serial number, list 2, serial number 3. That's the matter I mentioned yesterday, my lord, Facebook's matter. Mr. Blatter is logged in, he is leading us in that matter.
Serial number 3.
Yes,
Meta platforms.
that's right. That's the Facebook's matter, which I mentioned yesterday, Mr. Blatter is, before that, my lord, leading us in this matter.
Before that, may I make one request?
Mr. Blatter is on.
List number 2, seal number 3.
Yes, before that, may I make
One second. Give it 10 minutes. I'll just regulate, and 3 o'clock I'll take the matter.
3 o'clock.
Datar sir, we'll take it at 3 o'clock.
Yes, bro.
Yes.
May I make one request, please? Serial number 12 in second list yesterday.
ಇವ್ರ್ದಾ?
ಹೌದು. ಅದಕ್ಕೆ objections ಹಾಕ್ಬೇಕು ನಾನು ಅವ್ರ affidavit ಗೆ. ಅವ್ರ affidavit, it is not in my lord's consonance with the earlier directions issued by this court. ಅದರಲ್ಲಿ ಅವ್ರು ಹೇಳ್ತಾರೆ petitioners against ಮಾಡಲ್ಲ ಅಂತ. ನಾನೊಂದು objections ಹಾಕ್ತೀನಿ. ಆಮೇಲೆ
Petitioners against ಮಾಡಲ್ಲ ಅಂತ ಆಯ್ತು. You are interested in petitioners.
my lords, my interest is to protect the entire my lords temple and my lords the
PL ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ, ಅದರಲ್ಲಿ prayer ಅಲ್ಲಿ ನಮ್ದು ಅದೇ ಇದೆ. ಅದಕ್ಕೆ ಹೇಳಿರೋದು ನಾನು objections ಹಾಕ್ತೀನಿ to point out the conduct of this petition, this respondent. ಅವರು he makes allegation, my lords, I thought let me not put it, my lords, before this court. My lords, he provided platform to make comments against this court also. And my lords, ಅದು ಅದಕ್ಕೆ ನಾನು objections ಹಾಕ್ತೀನಿ. ಅದಕ್ಕೆ ನಾನು objections ಹಾಕ್ತೀನಿ ನಾನು.
If my affidavit is not proper, I have filed a application for.
And what is that on this court also?
Lords, may kindly recollect, my lords, initially my lords granted permission to my lords to hold protest.
Yes.
Then my lords, by looking into the conduct of the protesters, my lords granted interim order of stay. ಅದರ ಬಗ್ಗೆ comment in this platform. ಅದಕ್ಕೆ ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ನಾನು.
No, my lord, they themselves have submitted in the, before the OS suit court ಮುಂದೆ ಹೇಳ್ತಾರೆ, who has made those allegations ಅಂತ. Whatever they have produced here, that has been made by defendant number 12 in this, respondent number 12 in this writ petition, and they have clearly said, ನೇಮ್ ಮಾಡಿ ಹೇಳಿದ್ದಾರೆ ಯಾರು ಅದನ್ನ ಎಲಿಗೇಷನ್ ಮಾಡಿದ್ದು ಅಂತ. Now because they doesn't want to
ultimately,
if my affidavit ಅಲ್ಲಿ ನಾನು petitioner ಅಂತ ಹೇಳಿದ್ದೇನೆ, all the undertakings necessary I have given, I will not defame ಹೇಳಿದ್ದೇನೆ, ಕೋರ್ಟ್ ನ ಕಂಟೆಂಪ್ಟ್ ಮಾಡೋದಿಲ್ಲ ಹೇಳಿದ್ದೇನೆ, everything I have given.
But he is not going.
ಮಾಡಿ ಯಾಕೆ ಮಾಡ್ತೀರಾ?
He is not doing. He is providing platform to others to defame.
Why that? Why that even?
Even I have stated in
In that affidavit you say you are in your platform ಅಂತ ಹೇಳಿ.
ಹೇಳಿದ್ದೇನೆ ನಾನು interviews ಅನ್ನು ನಾನು I will be very cautious by when
ನಿನ್ನೆ
I
ಮಾಡಿದ್ದಾರೆ.
posting the interviews ಅಂತ ಹೇಳಿದ್ದೇನೆ.
ಮತ್ತೆ ವಾಪಸ್
ನಿನ್ನೆ
ಎಲ್ಲಿಗೆ?
ನಿನ್ನೆ ಏನು?
ನಿನ್ನೆ ಏನಿಲ್ಲ, ಅವ್ರದ್ದು let them produce it.
That is what I want to produce it.
My lord, I have
My lords, trial court ಅಲ್ಲಿ
stay vacation application is
ತಾವು
pending, my lord.
ತಾವು ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ ರಿಟ್ ಅಲ್ಲಿ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಆರ್ಡರ್, ಇದು ಸೂಟ್ ಅಲ್ಲಿ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಆರ್ಡರ್ ಆಯ್ತು. Advocates went to serve the my lords hand summons. This person is there, my lords, he is posing threat also. ಅದನ್ನ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದೀವಿ ನಾವು. I want to bring it on record.
ಆಯ್ತು, Friday I'll take it.
Yes, please. ತಾವು
ಅವ್ರನ್ನ ಹಾಕ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ, ಅದನ್ನ ಹಾಕೋ ವಿಷಯ ಎಲ್ಲಿ ಏನಾದ್ರೂ ನನ್ನ ಮೇಲೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನನಗೆ.
ಅಲ್ಲ, ಇವ್ರು ಒಬ್ರೇ ಮಾಡ್ತಾ ಇರೋದು. ಇಡೀ ತಾವು ಈಗ್ಲೇ ಬೇಕಾದ್ರೆ ಯೂಟ್ಯೂಬ್ ಓಪನ್ ಮಾಡಕ್ ಪರ್ಮಿಷನ್ ಕೊಡಿ ನನಗೆ. ಇವ್ರದ್ರಲ್ಲಿ ಎಕ್ಸೆಪ್ಟ್ ನಮ್ಮ ಮೇಲೆ ಬಿಟ್ರೆ ಬೇರೆ ಏನಾದ್ರೂ ಕಂಟೆಂಟ್ ಇದೆಯಾ ನೋಡಿ.
ನ್ಯಾಷನಲ್ ಚಾನೆಲ್ ರಿಪೋರ್ಟ್ ಮಾಡ್ತಾ ಇರೋದನ್ನ ನಾನೊಬ್ಬ ಯೂಟ್ಯೂಬರ್ ಮಾಡಬಾರ್ದು? ಅಲ್ಲಿ ಸ್ಟೇಟ್ ಚಾನೆಲ್ ಇಲ್ಲಿ ಎಲ್ಲ ನಾನು ಏನು ಮಾಡಿಲ್ಲ. ಐ ಆಮ್ ದೇರ್. SIT ತನಿಖೆ ಆದಾಗಿಂದ ನಾನು ಬೆಳ್ತಂಗಡಿ
ಅಲ್ಲೇ
ತಾಲೂಕು
ಇರೋದು.
ರಿಪೋರ್ಟ್ ಮಾಡ್ತಾ ಇರ್ಬಾರ್ದು ಅಂತ ಹೇಳಿದ್ರೆ ಈಗ ಮಾತಾಡಬಾರ್ದಾಯ್ತು, ಇನ್ನು ನಾನು ಇರ್ಲೂಬಾರ್ದು.
ನಾನು ಅದನ್ನ ಹೇಳ್ತಾ ಇಲ್ಲ. My lords,
no, affidavit of undertaking is filed. We'll take it.
I'll file objections. My lords may post this on Friday, my lords.
All right, Friday plenary hearing.
Please, interim order to continue.
Friday I'm going to close it. ಮತ್ತೆ time ಕೇಳಂಗಿಲ್ಲ.
Yes, please. My lords, in the connected matter, my lords, my friend Subramanya appears, wherein it appears.
And no comments making, otherwise don't violate the orders. Why do you want to violate the orders?
ಮಾಡೋದಿಲ್ಲ ನೋಡ್ ಅವ್ರು ಯಾರು ಯಾವ ಇಂಟರ್ವ್ಯೂ ಆಗಿದೆ ಅದು ಇನ್ನು ದಟ್ ಇಸ್ ಆಲ್ರೆಡಿ ಡಿಲೀಟೆಡ್.
ಇಲ್ಲ
ಈಗ ಇಲ್ಲಿ
ಮೊನ್ನೆ
ಮಾತ್ರ ಏನಾಗ್ತಿದೆ ಹೇಳಿದ್ರೆ
20ನೇ ತಾರೀಕಿಗೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದಕ್ಕೆ ಜಡ್ಜಸ್ ಮೇಲೆ ಹೇಳ್ತಾರೆ ಪ್ಯಾಂಪ್ಲೆಟ್ ಹಚ್ಚುತ್ತೇನೆ ಅಂತ ಇವರ ಪ್ಲಾಟ್ಫಾರ್ಮ್ ಅಲ್ಲಿ ಜಡ್ಜಸ್ ಫೋಟೋ ಹಾಕಿ ಪಿಕ್ ಪಾಕೆಟರ್ಸ್
ಯಾವ ಜಡ್ಜಸ್
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನ ಜಡ್ಜಸ್ ಮೇಲೆ ಹೇಳ್ತಾರೆ. ಆಮೇಲೆ ತಮ್ಮ ಮೇಲೇನು ಅದು ಬಿಡಿ, ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ನಾನು. ಕಾನೂನಿಗೆ ಬೆಲೆನೇ ಇಲ್ಲ ಅಂತ ಮಾತಾಡ್ತಾರೆ.
All that should stop.
it has been deleted. ಇದು ಯಾವ ವಿಡಿಯೋ ಬಗ್ಗೆ ಮಾತಾಡ್ತಾರೆ?
ಅಲ್ಲ ಡಿಲೀಟೆಡ್ ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಮಾಡಿದ್ದೆ ಯಾಕೆ?
It is the interview of the other person. ಅದಿದೆ, that is there. ಅದಕ್ಕೆ ನಾನು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಇಂಟರ್ವ್ಯೂ ಮಾಡಿ ನಾನು ಪೋಸ್ಟ್ ಮಾಡುವಾಗಲೂ I'll be cautious. If any person is passing such comments, I'll not post that. ನಾನು ಅದನ್ನ ಆಲ್ರೆಡಿ ಸ್ಟಾಪ್ ಮಾಡಿದ್ದೇನೆ. ಇಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್
Friday will
I'll file interim order to
List 2 serial number 13.
ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಮೈ ಫ್ರೆಂಡ್ ಸುಬ್ರಹ್ಮಣ್ಯ IPS my lords ಅವರಿಗೆ ನಾನು ಕಾಪಿ ಸರ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಅಫಿಡವಿಟ್
ಮಾಡ್ಬಿಡಿ, ಅಫಿಡವಿಟ್ ನೆನ್ನೆ ಹೇಳಿದ್ರು ಅವರು.
Yes please
ಮೇಡಮ್.
List 2 serial number 13, my lords. My lords, I intend to file objections, my lords. I'm awaiting the signed copy of the objections, my lord. The
These two I will not take except those
wherever I believe that matter is urgent to tomorrow, my lords.
order will be extended. ಮಧ್ಯಾಹ್ನನೇ ಮಾಡಿದ್ದೀನಲ್ಲ ಮೇಡಮ್. ಇವತ್ತು ಟ್ಯಾಕ್ಸ್ ಡೇ ಅಲ್ವೇ ಅಲ್ಲ?
My lords,
ನಾಳೆ ಬೇಡವಾ ಅದು?
My lords, 13, serial number 13. I will appear for the respondent, my lords. Kindly have it next week, my lords. I'm awaiting the signed copy of the objections, my lords.
ಆಯ್ತು ಸರ್, ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿ, ಪರವಾಗಿಲ್ಲ. Yes.
Your lordship.
The 28th or 4th.
Your lordship.
Interim order will continue.
List 2 serial number 17, your lordship. This matter is with respect to APP charges.
No individual things except those are to be remanded. ಮಾತ್ರ ನಾಳೆ ಹಾಕಿದೀನಿ. Otherwise everything will come on 4th.
My lord,
4th or 11th.
Just
Interim
small
orders will be there.
My lord, list
there will be extended.
A fresh matter, your lordship. It is already covered by the judgment in 20016. It may be disposed of accordingly, your lordship.
No, not like that. Not dispose of in the mentioning stage. Yes, call the cases. Why this rush now?
My lord, list 21, this is for the demolition. Today it was posted. You can have it on tomorrow.
CPC ಇದೆ.
ಆಯ್ತು.
ಟ್ಯಾಕ್ಸ್ ಮಾತ್ರ ಜನ. Yes.
List 1 continue.
Continue ಮಾಡಿ.
List number 1. Bill number 77.
For the rest. Seek for past home, let's see, is an election in the other court. This is the matter with the challenge of commissioner report in FDB proceedings. 400 respondents.
Suit is of the year 91, my lord.
I will hear list on 3rd September. Same stage.
That's interim order.
Interim order subsisting will continue till the next date. Avat pass over ಕೇಳಬೇಡಿ. Yes. Next. 78 करते मतलब? Yes.
Number 68. Sorry.
78.
For the petitioners, my lords.
Ah.
My lords, we are only seeking injunction order against respondent number 1 to 3 who are the complete strangers to the property. They're not the co-owners of the property, my lords. So they're not even stating how they have the rights over the property. Property hatra matra bandbittu alli they are trying to build apartments, my lords.
Your property hatra bandu they are trying to build
No,
apartments.
they're trying to interfere.
Who will
into-
build apartments with your sunne band hinge?
No, we've produced the photographs, your lordship. They bring bulldozers and they're trying to
Anything-
threaten the petitioners, my lords.
How are you the owner of this property?
We are the co-ownership, your lordship, the
ಎಲ್ಲಿದೆ?
joint owners.
Partition is already affected.
No, it is not affected, it's still pending, my lords.
Yes.
But I will also have the share over the property. So
ಅದು
because,
ಆಮೇಲೆ ಡಿಟರ್ಮಿನ್ ಆದ್ಮೇಲೆ
my lords,
ಡಿಟರ್ಮಿನ್ ಆದ್ಮೇಲೆ
determine ಮಾಡೋ ಮುಂಚೆನೆ they will just change the nature of the.
who is changing?
The strangers, my lords.
Strangers will change the nature of your
So
property.
they are interfering into our property, my lords.
Yes.
Without any rights and interest. Let them state they will not interfere into our property and we do not have any objections regarding that, my lords.
First you have to establish your right.
We are the co-owners, my lords. We have joint ownership because this
Joint
property-
ownership ಎಲ್ಲಿದೆ?
Because this property belongs to my mother, your lords. So ultimately, all of
Yes,
us
sir.
will have rights over the property.
Lords, there is a joint development which is executed by the other defendants in my favor. Lords, it is the whatever development work was carried out because the joint development said that they will have to clear the property and then they will have to compound the property before we execute the formal documents. So that is essentially the understanding which is in place. suit filed, my lords, for partition once it is dismissed and the matter is at large before the dishonorable court. Question of
RFA.
filing- Yes, there is an RFA which is now pending. Now the RFA number 674 of 2017. My lords, page number 40 in the compilation of documents which I now gave it.
You seek appropriate orders
In
there.
that, my lords, this is a docket explosion which they are, not something which is unheard
No,
of.
you
This
should
is why there is
seek
bar
orders
association.
there. 670, it's a suit. RFA is filed by you.
Please, my lords,
Yes.
for the partition suit. It
Whatever,
is not filed
all
by me.
incidental reliefs will be there only.
Your lordship, there is no interest over the property of them, your lordship,
The
without
joint
any interest.
development agreement yaar matradu?
No, we have not entered into such a joint.
Who has entered?
The difference, the other.
Who has entered?
Other respondents, namdu ide Swami, adralli property, so that, apart from us,
RFA le ಒಂದು application ಹಾಕಿ.
no, they cannot enter into a joint development agreement when it is a joint, partition suit is
You have
still.
lost the suit, madam. It is still pending adjudication.
It
There
is pending.
yes.
At the time of pending adjudication, they cannot get into.
That is why you should seek relief
But
there,
till-
not
till
filing.
I seek and relief, they will change the nature of the suit because
You
they're all
would file an
developers, my lord.
application there.
They're all developers. At least
No.
on merits, the application may be decided before the trial court, my lord.
What on merits? What has happened now?
Now,
Emergent notice is ordered. Then they
And-
come before this honorable court, injunction is granted. I have no difficulty, my lords. Let the
Where
trial
is-
court decide, but the injunction cannot continue, my lord. Because the suit itself is not maintainable.
Oh, idu.
and no
my
reasons are
order.
assigned in the application, my lords.
For what?
For issuing the emergent notice and.
ಅದಕ್ಕೆ reason ಯಾಕೆ ಬೇಕು emergent notice issue?
My lords,
Yes.
it may be sent back to trial court, but until then interim order may be
Status quo ಅಂತಿದೆ
operating,
ಇಲ್ಲಿ.
my lords.
Coordinate bench is granted.
Yes, my lord. That's the reason why I said, my lords, in a matters of
We'll
this
direct
nature.
the court to consider it in 2 weeks.
Please, my lords.
Yes.
Until then.
Status quo may not be continued, my lords. The
No,
reason
2
is only
weeks.
this.
Already.
I understand, my
already-
lords, but if your lords were to consider this, lords, the kind of suit which has been filed, it's absolutely an abuse of the process of court. There cannot be a multiplicity of the proceedings in respect of the same subject matter. When they are admitting to the fact that there is an earlier suit filed and they filed the case, the cause of action which they have pleaded is that because there is a suit pending, these people should not have dealt with the property. That's a reason, my lords, that is one reason which is to be assigned before the coordinate court where they'll have to seek for injunction.
No, my lords,
There
there
is, right or wrong, there is an order unless I vacate it.
2 weeks, my lords, is, I will not say anything.
2 weeks ಅಷ್ಟೇ.
Very well. Because the Supreme Court says that the possession of one co-owner is the possession
No,
of
no
another
problem.
co-owner.
That's
And
correct.
question of granting injunction against a co-owner is unknown to law.
we are asking against the 1 to
But
3, my
whatever,
lords.
2 weeks I will continue.
Very well.
The petitioner is before this court calling in question the order of the concerned court which declines to grant temporary injunction while issuing emergent notice. The coordinate bench of this court, in order to protect the interests of the petitioner, albeit temporary, granted an interim order on 7/4/2025. The interim order reads as follows. It was at a stage when the respondents had not been represented. The learned senior counsel who now represents the respondent defendants would vehemently oppose the grant of the continuance of the interim order on the score that the very petitioner had filed a suit for partition.
The party to this partition.
The very petitioner was defendant number 2 in a partition suit instituted, and the partition suit gets dismissed. The dismissal of which is called in question before this court in RFA 674 of 2017. The present suit is preferred seeking injunction against the other co-owners of the property, which is not even entertainable, is a submission of the learned senior counsel. In the light of the application pending before the concerned court, I deem it appropriate not to enter into the merit of the claim or the merit of the claim of the parties, and direct the concerned court to dispose the application filed under Order 39 Rule 1 and 2 in the subject suit with an outer limit of 15 days from the date of receipt of the copy of the order. The coordinate bench has granted an interim order of status quo which is in operation till today. In the light of it being in operation, I deem it appropriate to continue the same for a period of 2 weeks from the date on which the order would get uploaded on the website. The concerned court shall hear both the parties and pass necessary orders. In the pass necessary orders, but yavatide next alli?
4/9.
4-9.
Please, 4-9, my lords.
Pass necessary on or before the 4-9 andre in 15 days, correct?
20th of.
On or before the 20th of September 2025, as the council should submit that the next date of listing before the concerned court is on 4-9-2025. It is made clear this court has not considered the merit of the claim of the petitioner. Merely because the interim order is continued for a period of 2 weeks from the date of receipt of the copy of the order, it does not mean that the concerned court should grant an interim order without adhering to law. The application under Order 39 Rule 1 and 2 shall be answered strictly in consonance with law.
My lords, the status quo may be continued till the orders has been passed, my lords. Please, my lords.
No,
if
this itself is, yes, next.
No, until
On or
the
before
passing of
20th
orders,
and
my
30th.
lords. 20th vargu badru status quo may be operating, my lords.
Further orders, the concerned court is at
Not
liberty
2
to
weeks,
pass.
my lord. At
The
least till
concerned court is at liberty to pass necessary orders on the date of its listing on 4-9-2024.
Please.
But is bound to complete the proceedings qua Order 39 Rule 1 and 2 before the 20th of September. Yes, next.
59.
Lord, in this case, I am for the respondent 4 and 5 before your lordship.
69.
69.
I'm appearing for petitioner.
Then adjournment ಕೇಳಿದೆ objection ಇದೆ.
ಅಲ್ಲ ಇದಕ್ಕಲ್ಲ.
ಅಲ್ಲ,
Next
ಅಲ್ವಾ?
one,
ಇನ್ನೊಂದು
70.
ಇದೆಯಾ?
70.
It's a suit for partition. My lord, I have filed application seeking amendment of my lord the plaint to add my lord 6 joint family properties. My lord, the Impleading order, my lord, is passed stating that there is a delay. That is all the matter, my lord.
My lord, this is my application filed for vacating the stay.
Correct.
Let me convince your lordship. So far as vacating the stay is concerned, my lord, the present
Suit for
Partition.
suit for partition.
What is the
present petition
application?
Before your
Application
lordship.
to add 6 joint family properties that were my lord inadvertently my lord missed out while
Suit ಯಾವಾಗಿಂದ?
filing of the suit 2006.
2006.
I was arraigned
ಯಾವಾಗ
as
amendment ಹಾಕಿದ್ದು?
2023. I was arraigned as defendant number 3 in the suit.
When?
When the suit was
Initially.
filed, initially I was arraigned as defendant number 3.
What were you doing for 17 long years?
My lord, the plaintiffs, my lord, collude with other defendants. They enter into a compromise. That, my lord, made me file an application seeking transposing as a plaintiff. My lord, my application came to be allowed, my lord, only in
Correct, you are transposed as a plaintiff.
Transposed. Thereafter, my lord,
When
the
was
matter
that allowed?
My lord, it was in 2017. When the matter was, my lord, at the stage of cross-examination, my lord, while, my lord, I was giving necessary instructions for the preparation of cross-examination, I came across, my lord, these properties which were left out. I only sought to add these properties by virtue of amendment, my lord.
They are not joint family properties?
They are the joint family properties.
Joint family properties.
We are all, my lord, the family members. That is also not in
Partition linear ಇರ್ತಾರೆ sir.
Alla, in 5 and 6, my lord, they are not family members. They are appearing for.
May I make one submission, my lord? So far as the amendment sought for by the present petitioner before your lordship was the defendant number 3 in the earlier suit. Later on, she transferred herself as plaintiff number 3. Later on, she knows pretty well that these properties have been already bequeathed, already been partitioned. There is a disposition right in the year 1995 itself. There was a release deed. There was a registered party, registered will in the year 1995. Again in the year 1996, there is a registered will. There was gift deed. All these documents is aware of by this petitioner. She was the signatory to all the documents that was marked in exhibit P1, D1, D2, and D3. She is the signatory of all the documents. She cannot say that she was not aware of these properties. She is well aware of it. It was done in the year 1995 itself.
If I were,
Release deed was executed. Bill was executed in the 1995. In 1996, there is one more will, and again in the year 2002, there was a gift deed. All these documents have been marked before the learned trial judge. The learned trial judge has gone through entire documents. In all these 4 documents, she was the signatory. She was aware of all this one. She cannot say at the last moment and in the year 2023 that she was not aware of it. She is aware of it. On the score only, the learned trial judge was dismissed his application. In fact, may I just draw your lordship's attention to in page 82, the observation of the learned trial judge while dismissing the application for amendment. May I just request your lordship to kindly permit me to read
Page
82. In page 82,
my lord, if I were to be aware of those, my lord, instruments, I would have sought, my lord, additional inclusion of additional paragraphs
My lord,
or additional
I would
prayer also.
directly take your lordship.
That is not so, my lord. Even in the impugned
All
order,
right,
nothing
we'll
is
hear it.
forthcoming.
List on 28th. In preliminary hearing. Yes.
Interim order may kindly be.
Interim order subsisting. We'll continue to the next date. 28th. Yes.
70.
Appear for the.
Is also mine. Not here also I filed an application for vacating
That is,
stay.
What's the suit for?
Suit for my lord, the plaintiff filed the suit.
Suit for?
For permanent injunction. The permanent injunction.
Injection? All right.
Restraining the defendant from interfering with the possession. And the defendant files the counterclaim to declare that he has got an access to his land on the land of the plaintiff. The court made the injunction absolute. Then my application was rejected, against which I preferred MA, my lord, and I did not get an order before summer vacation. My lord, they wanted to put up the.
MA is pending still?
Pending.
Yes, my lord.
We'll send it there.
The relief is only, my lord.
In fact,
No, one
this,
minute.
this
One
petition
minute,
is unwarranted
My
for the
lord.
simple reason, my lord. Just because he has not able to obtain an order of stay in before.
First appellate court.
Second, first appellate
My-
court, he has rushed to the Supreme Court seeking for a stay scope.
We'll direct the court to consider it.
That
Yes.
is what
And
the
at the
prayer.
same time, I just make one submission, my lord.
That is what the
Here is a case where this property belongs to me. I'm a widow before your lordship. My lord, may kindly appreciate.
that is a
All
management.
the properties have been apportioned between the three brothers. I'm the wife of the last son, Janardhan Reddy.
Who is
Jagannath
Janardhan Reddy?
My lord, Jagannath Reddy.
Your lordship.
Jagannath.
Your
I'm
lordship,
sorry.
No, no.
Yeah, all the portions have been apportioned to the extent of 15.5 quarter guntas of land. And
15.5 quarter.
sorry, 15 quarter guntas
All
of
right.
land. All the three persons have already apportioned, they have got mutation entered in their name. Now, this second.
ಆಯ್ತು ವಿಲ್ ಸೆಂಡ್ ಯು ದ ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಹೋಗಿ ಅಲ್ಲೇ ಹೋಗಿ ಎಲ್ಲ ಮಾಡಿ
ಸಿಗ್ಲಿಲ್ಲ ಅಂತ ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು enter
ಮಾತಾಡಕ್ಕೆ ಬಿಡೋದಿಲ್ಲ.
ನಿಮಗೆ ಹುಷಾರಿಲ್ಲ ಅಂದ್ರಲ್ಲ ಅದಕ್ಕೆ ಅವರೇ ಮಾತಾಡಿದ್ರೆ
70, page number 70.
ಯು ಸೆಟ್ ಕೆಮ್ಮು ಮಾತಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ಅವರೇ ಮಾತಾಡಿದ್ರು
Page number 70, my lord.
ಹಾ.
Your lordship, photographs, my lord.
ಹಾ.
It is only the access to me to approach the main road. That is why anyway, this is a matter to be decided on merits. My prayer is only direction to the trial court to dispose of MA. In the meantime, status quo order granted by this court.
May just,
be
may
extended.
just,
2 weeks ಅಷ್ಟೇ
may
no
just-
more than 2 weeks it will continue. I will direct the first appellate court to decide it in 2 weeks.
What happens? One
may-
submission.
may
No,
just-
what happens is,
What happens? Nothing will happen.
they would put up the compound. I cannot have an access to my land.
ಅದೇ ಎರಡು ಅವ್ರು ಡಿಸೈಡ್ ಮಾಡೋವರೆಗೂ ಅಲ್ಲಿ ಕಂಟಿನ್ಯೂ.
Justifiable, my lord, what I submit is till disposal of the application.
No, no, no.
Not till disposal of the MA. Till disposal of the
may
MA.
just draw your lordship's attention to page 82
If rather.
of the order of the impugned order. May just request your lordship.
ಈಗ injunction is refused. Who is the plaintiff?
I'm the plaintiff, my lord.
Injunction is granted.
Please. And it was considered after hearing both the sides. It's not that.
ಕರೆಕ್ಟ್ ಅದಕ್ಕೆ ಅಪೀಲ್ ಹಾಕಿರೋದು.
ಹಾಕಿದ್ದಾರೆ, MA ಹಾಕಿದ್ದಾರೆ.
Lordship,
ಇಲ್ಲಿ may just request your
lordship-
lordship to kindly permit to
lordship
para-
could see the
level
photograph.
in page 82, the observation of the learned trial judge. May just, it takes only 1 minute. That is,
merits,
in
my lord.
page 82, para 11, my lord.
ಹ್ಮ್.
So also,
Sole also.
7.
ಹಾ.
So also, in support of the defense, the defendant number 2 has produced the document like rough sketch, registered settlement deed dated 1/2/2002, mutation extract so and so, RTC extract for the period 2004-5, RTC so and so, copy the notice dated so and so, issued to town planning authority Anekal, notice dated so and so, issued to the Tahsildar and notice dated so and so. Para 12 may be important.
ಈಗ ಅದನ್ನ ಓದ್ಬೇಡಿ. ಐ ವಿಲ್ ಸೆಂಡ್ ಇಟ್ ಟು ದಿ ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್.
On peruse, may just how the learned judge has traversed
That
each
is
and
on
every
merits.
That is
document.
pending before appeal, sir.
That's true.
Don't argue the appeal here.
Status quo is concerned, he may be.
2 weeks.
vacated.
If your lordship.
Maximum
could-
2
no, no,
weeks,
If
yes.
lordship,
Vacated,
no, no,
my
1 minute.
2 ವಾರ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀನಿ ಅಲ್ಲಿ
If your
ಮಾಡ್ಕೊಳ್ಳಿ.
lordship could see the photograph, my lord, that is only the access to me to the main road.
Hey, ಅದಕ್ಕೆ
ಕಲ್ಲು
ನಾನು
ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ ಅಲ್ಲಿ?
ಅದಕ್ಕೆ ನಾನು
ಅಲ್ಲ.
permit.
ಕಲ್ಲು ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ ಮಧ್ಯದಲ್ಲಿ?
Swami,
ಕಲ್ಲು ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ದಾರಿನೇ ಇಲ್ಲ.
it is my property, but it's not his property.
Oh.
It is my property. That's what I said. Rasa Reddy has got 3 sons. All the 3 sons have divided themselves. Everybody was given 15 quarter guntas of land. ಅವ್ರವ್ರ ಶೇರಲ್ಲಿ ಅವ್ರು ಇದ್ದಾರೆ. He cannot come into my land because it is his property. Let him enjoy. I'm not coming in his way. He should also not come in my way. That's the reason why the learned trial judge in para 12 has made very clear. ಒಂದೆರಡು ನಿಮಿಷ ಒಂದು
ಇಲ್ಲ ನಾವು 2 ನಿಮಿಷನೂ ಇಲ್ಲ. Yes, the petitioner is before this court. ಬಿಟ್ರೆ ಸೂಟೆ ಮುಗಿಸ್ಬಿಡ್ತೀರಾ ಇಲ್ಲಿ. The petitioner is before this court. No, is before this court calling in question an order of the appellate court in MA 28 of 2023 insofar as it declines grant of declines stay of the order of granting of temporary injunction in favor of the plaintiff, the respondent. The petitioner is the defendant in OS 560 of 2022. OS, the respondent, the plaintiff. The concerned court grants a order of temporary injunction in terms of its order dated 27/10/2023. The order of injunction was in subsistence throughout, and the present petitioner files an appeal in delay. Files an appeal in MA 28 of 2023. The matter was posted on 13/6/2025, on which date the appellate court only issues notice to the respondent but does not
we entered caveat there.
reject ಮಾಡಿದಾರ ಅದನ್ನ.
ಅಲ್ಲಲ್ಲ, we entered.
Where is the order of the first appellate court? Yeah, where is the order?
Page 20 minute annexure A
73.
ಅಲ್ಲ, ನೀವು annexure ನೀವು ತರ ಹಾಕಿರಿ ಸರ್, ನಾನಲ್ಲ.
1 ನಿಮಿಷ ಆಯ್ತು ಈಗ. Yes. For arguments in the main appeal 19/2/2024.
My lord,
address
one submission, my lord. The present petitioner was the appellant before MA 28 of 22. He was not prepared to argue the matter. He simply dragged on the matter. Now
the appellate court.
Two appeals.
The appellate court does not grant stay of the order of injunction, but direct ports the matter for hearing on the appeal itself. This is what is called in question in the subject petition. In the light of the matter pending being at large before the appellate court in MA 28 of 2023, there is no warrant of interference with the order that is passed by the appellate court at this juncture. The coordinate bench of this court had granted an interim order of stay.
So, status quo.
Interim order of status quo in respect of the petition schedule property till the next date of hearing. The said order of status quo is in subsistence even today. In that light, I deem it appropriate to dispose the petition with a direction to the appellate court to conclude the proceedings in appeal as it is arising only out of an order of injunction granted by the civil court with an outer limit of 2 weeks from the date of receipt of the copy of the order. In the light of the order of status quo being granted and subsisting even today, I deem it appropriate to extend the same for a period of 2 weeks from the date of receipt of the copy of the order. All other contentions of both the parties shall remain open to be urged before the appellate court in the appeal proceedings, ordered accordingly.
No, my last time kindly.
Here, let my lordship should not seek for adjournment because he's seeking adjournment from time to time.
In the it is made clear that the order that is now granted will continue only for a period of 2 weeks and not any day later. The concerned court is at liberty to pass necessary orders in accordance with law.
Yes.
My lord, till disposal, my lord.
No, sir.
71.
Beda, I told you, 3 o'clock matter.
71 I am appearing.
So there is one matter from, I have just passed that over. ಇನ್ನು ಎರಡೇನಾ ಇರೋದು? ಕರೆದು ಬಿಡಿ ಒಂದು ನಿಮಿಷ.
71.
I'm for the petition, but kindly have next week, my lord.
Lord, suit for ejectment.
Convenience for the council.
The suit is for ejectment 2018, the suit is filed 2019, the written statement is filed. Lord, he files a suit in 2018 saying that I am a tenant of this property. Please protect my possession for a forceful dispossession. That is his injunction suit. We file a suit for ejectment. Then he files a written statement saying this, yes, I am a tenant. I am paying this. They had agreed to extend this lease for innumerable number of years. Therefore, I have done some interiors. Therefore, this suit should not be entertained. That is his plea. Lord, then the PW1 is examined. It is posted for cross-examination. He then files an application saying that you will have to summon certain documents. That application is rejected. That is in December 2024. So he holds the court from 17/6/2024 to 17/12/24 on one application. Then the next hearing comes is on 1/3/2025. he files an application filing additional written statement, which is unknown procedure. He can either seek for an amendment to the written statement. Otherwise, under Order 8 Rule 9, it is not permissible. Now, that application has been rejected. The reason is he seeks to raise a plea that he is in adverse possession of this property. Mutually destructive pleas cannot be raised. That's the only contention. Lords, now it's a suit for ejectment. Lords, there is already a direction of this honorable court, which is noted even in the order sheet, saying that the suit is to be disposed of within a period of 1 year. After that, 1 year is spent only in considering applications.
Yes, sir.
My lord, in this matter, I am appearing for the petition, my lord, kindly have next week.
No,
my
no,
under
sir.
proxy council, my lord.
Proxy council, ಆಯ್ತು. List the matter next week. Don't extend the interim order.
Please.
Proxy councils get no extension of interim order. Yes.
28 ನಾವು ಮಾಡ್ತೇವೆ, my lord.
Well, proxy council, why are you worried?
Some inconvenience.
No, he has taken the risk of a proxy council. He shall bear that risk. Yes.
Some inconvenience to the.
No, sir. Yes. Proxy, I have made it clear, not today. Proxy councils, I'm not going to extend the interim order. You take an interim order and send someone into a get it extended. No. Yes.
72.
Defendant number 3 is the petitioner. Not a suit for declaration filed by the respondent number 1 to 6 or the plaintiff.
ಏನ್ stay ಆಗಿದೆ?
Proceedings are stayed.
ಕಾರಣ?
Application filed by the plaintiffs in the
26/9.
Order 26/9.
appointment of a court commissioner to demarcate the property in a declaration.
Lord, declaration and for
ಆಗ್ಲಿ ಬಿಡಿ.
injunction. Declaration and for injunction. My lord, the application filed for appointment of commissioner. The trial court, my lord, allowed. The present petitioner, my lord, though he filed written statement, he has not chosen to file any objections to the said application. And application considered, my lord, after conclusion of the trial only. And so far as, my lord, except filing the written statement, has not chosen to examine before the trial court also.
ಎಲ್ಲ ಮಾಡ್ತಾರೆ.
ಇಲ್ಲ ಆಗಿದೆ.
ಇಲ್ಲ, evidence ಆಗಿಲ್ಲ.
ದಯವಿಟ್ಟು ನೋಡಿ.
ಇಲ್ಲ. Kindly turn to ink page number 82.
28.
Please.
This number 2, seal number 3.
Interim order may be extended.
That will be it.
Please.
28. Yes. Yes, sir. What's urgency? Yesterday you moved the matter saying that it is urgent.
Lord, we informed the officer that writ petition is filed, don't take any coercive steps. Now he's called and said that there is no stay, so we are going to proceed with.
Yes, Datar sir.
Yes, may it please your lordship, my lord.
Yes.
Lord, the petitioner is a company based in Ireland. Now, my lord, there is a category called online information data access and retrieval services, wherein my companies in Ireland, advertisements are issued by clients in India, and these advertisements are put on Facebook and other papers. Now, under GST, if I'm a non-resident and I render services to businesses in India, then the Indian entity has to pay duty on reverse charge mechanism. So if tomorrow X Limited issues an advertisement on Facebook, this is up to 2020. After 2020, the law is changed. We're only concerned with 2017 to 2020. At that time, if an Indian company places an advertisement on my platform, Indian company being a registered GST has to pay the GST on what is called reverse charge mechanism, RCM. No problem on that. And we have been doing so. Now, the only way the Irish company will be liable is if I take advertisement from central government, state government, or any person who is not a taxable entity in India. Now, I told the officer, all my clients are businesses, all are things. Now, what he has done is he has passed an order saying that you have not issued an invoice giving the GST number of the client. I don't have to issue invoice at all in the first place. Now, my submission is this. First, my lord, on jurisdiction, there are two matters pending before your lordship, because this is a DGGI case, and there is a board notification that these can be handled only by Bangalore West.
Give that order.
It can be done only by Bangalore West. It's done by Bangalore East. This is one point which I have taken.
Uber and Nest.
The other point, which is
which are the matters pending and interim orders granted.
Yes.
I'll just explain as far as the jurisdiction issue is concerned.
sir,
if I may
let
just
him finish.
supplement what Mr.
Yes.
Datar says. The notification issued by CBIC says that the jurisdiction where the show cause notice is issued by DGGI, then the order can be passed by Bangalore East. Here in this case, the order is passed by Bangalore West Commissioner.
So it is
That's the first
B
point.
horse jurisdiction.
That's the first point on jurisdiction.
Hmm.
The second point is bunching of show cause notices, which Mr. Datta can.
Yes, but on
Bunching of show cause notices is
That
covered.
is covered also in favor of the SC. As far as Karnataka is concerned, of course, other high courts have taken a divergent.
Different view.
No, sorry, Madras High Court has followed the Karnataka view.
Madras, yes, Madras has followed.
Yes.
Madras has followed. Yes. No, Lord. And these are
Yes.
the 2 points common to all, but my point is since I'm an Irish company, the point is I can't be made liable to pay duty because I'm not a taxable entity at all.
Yeah, Jeevan Nerel ke, huh?
Under section 14.
Respondent
Central
1
tax.
is union. Respondent 1 is union, 2 is DGGI, and 3 is jurisdictional office.
2, 3.
Madhu ಯಾರಿಗೆ? GST.
2 is DGGI.
DGGI,
That's a
yes.
different department.
Yes, identical orders are passed. Heard the learned senior counsel Arvind Datar along with learned senior counsel Sur Narayan. The learned senior counsel is on our project's twin submissions. One with regard to the bunching of assessment years in a single show cause notice, which the learned senior counsel would submit that plethora of cases. The coordinate benches of this court have granted relief, and the Madras High Court has followed the same. While the learned counsel for the respondent submits, other high courts have taken a different view. Be that as it may, since the order is passed by coordinate benches of the court, either granting interim order or final relief agidi yargaru?
Final
Interim order of bunching assessment, different assessment years into one show cause notice being granted by the coordinate benches. I deem it appropriate to grant the interim order as prayed for only on this solely on the said ground. The learned senior counsel would project yet another ground that the person who has jurisdiction to issue the notice has not issued the notice, inasmuch as the person, the authorized officer of West Ad.
Alla, adu
Bangalore East has
show cause notice is issued by DGGI. Answerable to Bangalore West, Commissioner Bangalore West. Bangalore West ali, this is a registration has to be taken with the Bangalore West. All over India jurisdiction
Does
is
not
Bangalore
become
West.
without jurisdiction.
No, it is. If my lords kindly see page
My lord, as per the
534.
notification.
I think e ground mele we have granted stay.
On this
Right
ground also,
state.
this court has granted stay. On this ground also.
Which jurisdiction also?
Yes, that is the order in Uber and Nest which have just passed on.
My lord, their contention is.
I
Of course,
will
department
hear
will
it and
file a
dispose it.
counter those
No, I
cases.
just clarify. My lord. The notification contemplates registration for the purpose of, my lord, providing this kind of, only this service.
It's only a temporary reprieve, but will answer the issue.
So that doesn't authorize them
No,
to
we will,
adjudicate. That's the-
we will bunch all the bunching cases and consider it.
Lord, I want to mention one more thing.
ಅಲ್ಲ, ಆ bunching ಬೇಡ, ಆ bunching on that ಬೇಡ. ಈ OIDR ಸರ್ವಿಸ್ ಇದೆಯಲ್ಲ, ಅದನ್ನ ತಾವು
ಆಯ್ತು, ಸರಿ.
ಅದ್ರ ಜೊತೆ.
The
Lord, I
learned
want-
senior counsel submits that even on the other ground, the coordinate bench has granted an interim order in the case of Uber India Systems Limited. The order granted by the coordinate bench reads as follows. The light of the Justice Pandit or the
12th February 2025.
on 12/2/2025 mark ಮಾಡಿದೆ. In the light of both the issues being answered, albeit by way of an interim order by the coordinate benches of this court, I deem it appropriate to grant the interim order as is obtaining in those cases in the case at hand as well. ಅದರಲ್ಲಿ one Union of India ನೀವಾ? Union of India Madhu?
ಇಲ್ಲ, 2 ಮಾತ್ರ.
Learned counsel Madhu N. Rao accepts notice for the second respondent. Learned counsel Jeevan Nerelgi, 1 and 3 na? Jeevan?
Please.
1 and 3, registry to print their respective names in the cause list. List the
Lord,
matter
one, my lord, the lordship permission. Apart from this technical grounds, there is a very serious jurisdictional issue because if there is a non-resident supplier of services, he cannot be made liable under section 14 unless the Indian client is a non-taxable entity. If the Indian client is a taxable entity, that's the most important point, my lord, under section 14, apart from Uber and other cases.
Will
Because
list it on
all
11th
non-resident
September.
suppliers,
On bunching, Karnataka has followed Madras High Court of Frightened Industries.
Oh, ಆ ತರ ಆಗಿದೆ.
Way round.
Other way around.
Way round.
ಅದನ್ನ correction ಮಾಡ್ತೀನಿ. Yes.
We have followed the Titan judgment.
Which high courts have taken a different view?
Bombay has
taken a different.
Bombay has taken a
And
different.
Delhi.
And Delhi has
Delhi
taken a
High
different.
Delhi has taken a different view. Will
Whenever we tell about suppression, but for natural, we have to issue for 5 years at once.
Right.
It's only in case of non-suppression, we can issue 5 notices separately.
3
into
notices. It is 3 years.
3 years. Even if for 3 years, if it is more than 1 year for us, we have to allege suppression. The moment we allege suppression, it has to be more than
Reckoned from.
If there is, because
my lord,
that judgment was-
We'll
my lord,
see, we'll-
unfortunately, what's happened is
we'll hear it.
suppression, no suppression, all notices are issued under section 74. That's the unfortunate part.
All right, that we'll
Section
see.
70 is working
We'll take it on. We'll take it on 11th, sir. 11th September.
My lord, in
But I
those-
only wanted to
my
mention
lords
that
are
I've got a
connecting this
larger
with those
jurisdiction,
two
I'm a
matters.
non-resident, and I've got a larger jurisdictional issue, my lord, not on
All right,
technicalities.
on 11th, we'll hear you on that. Yes,
My
tag
lords
this, we're tagging this with this.
This may
Justice
be
Pandit
on-
or order.
Because in those matters, I think pleadings are complete. Here, my lord, pleadings are.
ಮಾಡ್ಬಿಡಿ
That's
ಅಷ್ಟೇ.
only on jurisdiction aspect. As far as the merits is concerned on the OIDR issue, the facts will be slightly different. So
All
let
right,
it be
no
independent, my lord, let them file counter.
List this, one ನಿಮಿಷ. List this petitions along with this, not tagging but in seriatim.
Yes.
Great.
Deeply. Apply, sir.
Yes.
On continue.
Hmm.
Bill number 73 to 77, adjourned 78.
Yes, Shyam Sundar sir.
76 not.
ಎಲ್ಲ ಮಧ್ಯಾಹ್ನ ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ. ಆಗಿದೆ ಇದ್ರೆ. ಇಲ್ಲ ಅಂದ್ರೆ ಅದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ. ಎಸ್.
79.
78 ನಿಮ್ದಲ್ವಾ?
ಇಲ್ಲ 78.
ವಂದನಾ PL ಅಂದ್ರೆ ಯಾರು?
I'm sorry, my lord, I am 78. I'm sorry. My lord, there is one legal questions, my lord, that may have to be, my lord, that calls for, my lord, some law to be laid down. My lord, that's the reason, my lord, I am proposing this. Your lordship sees, my lord, the first court's order.
What is your proposal, sir?
My proposal is this, my lord, my lord, before I propose it, I'll just show to your lordships, my lord, page number
So
99.
before you propose it ಅಂದ್ರೆ he will oppose it. Correct ಆಗಿ ಹೇಳ್ಬಿಡಿ ಅಲ್ಲಿ.
On a legal question, my lord. I'll show, I'll not take more than 2 minutes. Your lordships will kindly see, my lord, page number 98, the first, my lord, court's order.
ಈಗ why are you here?
I am here, my lord.
Barring that proposal.
My lord, ಅದು the wrapper is, my lord, proposal for law.
ಅದೇ ಒಳಗಡೆ ಏನಿಲ್ಲ. ಕೇಸಲ್ಲಿ ಏನಿಲ್ಲ ಅಂತ ಅರ್ಥ.
ಇಲ್ಲ ಇದೆ ಕೇಸಲ್ಲಿ.
ಹೇಳಿ.
Your lordship sees, my lord, page number 98. Under order 39 rule 1 and 2, an injunction is prayed. My lord.
You are the plaintiff?
No, I was the defendant.
All right.
An injunction is prayed.
Granted.
No. What the learned judge, my lord, the first instance court would do is, this is what, my lord, the learned judge would do. IA under number 1 filed by the plaintiff under order 39 rule 1 and 2 CPC is hereby allowed ಅಂತಾರೆ. Actually ಮಾಡಿಲ್ಲ ಅದನ್ನ. ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ, both the parties are directed to maintain status quo. My lord, maintenance of status quo is never an order under order 39 rule 1 or 2 because both are order of restriction.
ಅದರಲ್ಲಿ ಏನು law lay down ಮಾಡಬೇಕು?
ಅಲ್ಲಲ್ಲ, ಈಗ this order of status quo is necessarily passed either under section 94 of CPC or under 151. If it is an order passed either exercising powers under section 94 of CPC or under 151, then, my lord, an appeal under order 41 will not lie. A regular appeal court, my lord, would entertain this appeal. My lord, would go a step ahead and, my lord, pass even more an excessive order what was not even granted. What the learned, my lord, appellate court would entertain, first of all, entertaining the appeal was not, my lord, permissible because it was not an order passed under order 39 rule 1 and 2. Now the appellate court would say, my lord, junk all my contentions, and my lord would say, no, he is entitled for
The contentions were of that kind.
no, my lord, very strong contentions. All that, my lord, I said is this.
Like you said, contentions.
I was damned, my lord, without a proper, my lord, appreciation of my case. My lord, the case is, my lord, in 2 lines is this. A lady was granted an alternative site because her lands were acquired by the state, my lord, a state authority. Thereafter, that acquisition itself, my lord, was dropped, was quashed. And the alternative site which was granted, my lord, also restored back, because, my lord, that became redundant, because the alternative site itself was.
Yes.
Now, what the lady would do, she would, my lord, accept the land acquisition as, my lord, final, yes, her lands are not acquired. But she would still say, the alternative site which was granted also is mine, and she would sell it to, my lord, the defendant.
After restoration?
After restoration also, she would tell, and, my lord, the plaintiff would go and buy it. And, my lord, as against me, say, no, I have purchased it from a lady. We tell to the court, look, he could not have the right to something excess than what his predecessor entitled could not have had. Then, my lord, the learned judge, both, my lord, at the first instance and the second instance would not, my lord, appreciate this argument on the count that whether the lady was actually having rights to alienate the property which was given to her as an alternative site, and that eventuality itself had lapsed.
Okay.
Well, our case was that alternative site was purchased by me by my predecessor. My predecessor entitled, my lord, has
Dates ಹೇಳಿ sir.
dates. Right. The first order, my lord,
Order ಅಲ್ಲ. Acquisition date.
The acquisition of right, my lord, your lordships, my lord, my
Acquisition, allotment of site, quashing of acquisition, restoration of the site.
Yes, my lord.
4 dates you give me.
Yes, I'll right away, my lord, I'll give.
Yes.
My lords may kindly have, my lord, I'll just take your lordships to that. Sometimes, my lord, these are
if you're on the
least part, my lord,
iPad, if you're on the iPad, you can't do it.
I have to make a honest confession. The least part we read, my lord, is the list of dates, my lord, I would have been prepared by the briefing lawyer.
Oh, the briefing lawyer is not read.
My lord, page 118. Good.
Page ಬಿಡಿ sir, date ಹೇಳಿ 4.
Dates.
4 dates.
My lord, the dates.
Yes,
notification, my lord, was 11/11/96. 1976.
96 or 76?
1976, my lord, the acquisition notification.
11/11/1976.
Yes.
Land is lost.
The land is lost.
Acquisition cost when?
Yeah, acquisition was quashed, my lord. Hello, one nimsha. Acquisition was quashed, my lord, on 7/6/1987 in writ petition number 14.
Adela, not necessary. Date, only date. Yes.
1417.
When was the alternate the allotment of site restored?
Allotment of site, my lord, she was, my lord, she continues, my lord.
Restore ಆಗ್ಲೇ ಇಲ್ವಾ?
ಇಲ್ಲ.
That allotment was never withdrawn?
In fact, our, my lord, contention.
Straight question, don't beg the question.
Yes.
Was the allotment withdrawn or not? Because it was a land loser's allotment.
Yes.
Land is again back to the fold of the loser.
Yes.
So the land is not lost. Whether the house still, the site or house, whatever it is, remains with her.
She creates, my lord, a patra called Supardu Patra, which was never granted to her.
When?
My lord, she
2000.
1/8/2000.
1/8/2000.
Executed by CMC.
CMC, my lord, could not have executed that because, my lord, by then the eventuality of acquisition of
all
her
right.
land
In
was
this
lapsed.
story, who are you?
I am, my lord, the one who actually has rights on this alternative site.
How
property.
did you get?
I got it, my lord. My lord, my predecessor in title had this from 1963. I purchased it from, my lord, one Faiz Unnisa, my lord, who in fact had taken the land, my lord, the site by way of a sale deed. My lord, I hold a valid sale deed.
That was a site that was allotted to the lady on the score that she was a land loser.
Yes.
How was it purchased by you then?
I had purchased it long ago, my lord, overlooking my rights. Simply, my lord, the CMC one finder said, yes, some property is available here, and the naman keldange is an alternative site and the torsbittu. She started, my lord, administering her my lord, the rights over the property. In fact, my lord, which was never there. I have been, my lord, the rightful owner of the property, and my lord, the titles flows from 1963.
Yes, Harish.
Lord, first outside, Lord, the writ petition is filed on 6/1/2025.
6/1/2025.
2025. Lord, late because there was a construction is almost done. Now at the fag end of this has been listed many times. It has been urgent. Now I have put up the construction. I have put up a hospital. It is about 90% complete. And only interior works and plastering is to be done. That is one aspect, my lord. Next is, my lord,
You give a gold card to him in the hospital, all treatment free.
that can be considered.
These arguments, my lord, I have constructed something in a property, though it does not belong to me, because I have.
That we'll see. We'll direct the concerned court to pass orders after hearing both of you.
Yes, my lord. That would be more than sufficient for me, my lord. All that the
Till
learned
then,
judge
my
has
lord,
to do.
the construction cannot be stopped. That is my request.
Alle, the court will decide on that. Not a status quo. 39(1) and 2 application, let it be answered in accordance with law.
Yes. That would suffice, my lord.
That my respectful submission is because I may be permitted to complete it because ultimately if he succeeds.
No. After completion, you will say patients are there.
Yes. Equities, my lord, will come in picture.
Now the thing is, my lord, it is almost complete.
Almost, patients have not entered.
Patients have not entered. The hospital is
Or they can patiently wait.
That my respectful submission, my lord. So far as that is, I will also argue on the merits, my lord.
You don't argue the suit here, sir.
So far as that issue is concerned, the second defendant has filed an application on order 13 seeking vacating of the temporary.
Please do that. Let it be heard.
That has been rejected. That has never been questioned.
39(1) and 2 status quo is not an order on 39(1).
Yes.
39 Rule 4 application is filed by the defendant number 2 has been rejected.
You are the defendant number 2?
Yes.
Yes, my lord.
Why did you file 39(4) if it was not 39(1) and 2?
That has rejected.
Why did you file?
Both the applications were considered together. Both the applications were considered together.
39(1) and 2.
39 Rule 1 and 2
Now,
and as well as 39 Rule 4 because an ex parte order was passed.
Status quo is ordered by on an application under 39(1) and 2.
Yes.
First temporary injunction was granted. Ex parte
parte
temporary injunction got granted. After their appearance, after hearing the parties, 39 Rule 1 and 2 is application is partly allowed. Then the application for vacating the stay is dismissed.
What happened before the appeal?
In the appellate court, my lord, the appellate court, my lord, would grant something even more than what was, my lord, granted.
What is granted, you tell me?
The appellate court grants an absolute injunction, temporary injunction, in favor of, my lord, the defendant, respondent.
Status quo ಆಗಿದೆಯಾ?
ಇಲ್ಲ,
injunction ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಇವರು ಇವಾಗ ಅದನ್ನೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
No, what did the coordinate bench do here?
It is first time before.
This is coming up your lordship.
Preliminary. That's the reason.
Office objections comply ಮಾಡಕ್ಕೆ you have taken 7 months.
That is what I'm.
ಅದಕ್ಕೆ hospital has come up.
6/1/2025 the
If you had complied with 1 week ಅಂದ್ರೆ hospital would not have come up.
10 months ಆಗಿದೆಯಾ?
7 months ಆಗಿದೆ.
I did not know, my lord.
Then if you take, then better hospital comes there.
ಇಲ್ಲ ಬೇಡ, my lord. At least
you are
now,
not diligent at all.
No, my lord. We are diligent, my lord. I am instructed to say, my lord, my lord, the petitioner, my lord, he was ailing.
He was ailing.
ಹೌದು ಏನೋ ಏನಾಗಿತ್ತು? My lord, he is a cancer patient. My lord, I wouldn't make, my lord.
You should make the hospital come up first.
In fact,
free
my
treatment.
Hello, my lord. I know.
It's good to have that
seconds,
option.
My lord, I would cite an incident. Now, my lord, one lady from my village, he was diagnosed with advanced stage of cancer, and the doctor said, "You'll not live for more than 1 or 2 weeks. Go home." She lived 18 years more, and she would always say,
if that is the apprehension, then let it be so.
If had she, my lord, gone under a treatment, perhaps, my lord, she would not have survived.
Yes, sir.
That is the reason, my lord.
39(1) and 2 is answered, sir.
Yes.
39(4) is rejected, 1 and 2 is answered, partially allowed.
Yes.
Then the status quo order is granted. It is in the nature of an injunction.
No, my lord, the status quo order, my lord. If it was an order,
that was the language of the order may be different.
My lord, if it was an order of status quo, that wouldn't have my lord, my learned friend's client could not have, my lord, stretched, my lord, his limbs to such extent to, my lord, complete the entire.
You are permitted, sir.
My lord, my humble submission.
By indolence, you are permitted.
My humble submission, my lord. The appellate court could not have, my lord, entertained when it is seemingly not an order either falling under 39 Rule 1 or 39.
ಈಗ ಇಲ್ಲೇನು order ಏನು ಆಗಿಲ್ಲ ಅಲ್ವಾ? Will direct the court to decide the suit itself. Suit is of 2020 ಯಾವಾಗಿಂದ? 24.
Sorry,
Since cancer patient ಅಂದ್ರಲ್ಲ, will direct the court to decide the suit.
Please.
My lord, let my learned friend's client not climb equities. Because, my lord, once the hospital comes up, my lord, he will say, no, my hospital, as your lordship rightly, my lord, remarked that patients are there, then malingering patients will become, patients will not sometime leave the hospital.
There may be benign patients also. Why do you say everybody will be malignant? Ashram,
Lords may kindly say, my lord, within 6 months, let the suit be disposed of. And my lord, my learned friend's client shall not, my lord, go on improving, my lord, the status. Because, my lord, in
So-
6 months, my lord, nothing will happen. My lord,
where is this?
Shivamogga.
in Shimoga, my lord. In a
Hospitals illa alli.
You-
Build a beautiful
Shivamogga-
multi-speciality
my lord,
hospital.
Shimogadalli, the best of the hospitals, the Megan Hospital. ಇದೆ.
Megan is old, sir. British era is now converted into a college now. It's a very old hospital.
It's a government college.
If your lordships, my lord, are saying that, my lord, the suit be disposed of, my lord, in 3 or, my lord, 6 months, then, my lord, my learned friend should also, my lord, holistically wait. Why should, my lord, my learned friend?
That order consent court will pass if there is anything. Yes. Status quo agidre, how did you construct, sir?
There was the status quo, Millard, that the application, the MA is allowed and injunction is granted.
Oh, in
But
the first.
They challenged, my lord, the status quo order.
Appellate court granted injunction.
Right, the appellate court, my lord,
All
appreciates
right, will
the
direct.
facts.
The petitioner is before this court calling in question an order dated 26/6/2024 passed by the trial court in OS 228 of 2024 and the order of the first appellate court dated 19/10/2024 passed in MA 20 of 2024. The petitioner is the second defendant, the respondent, the plaintiff. The plaintiff institutes a suit in OS so-and-so seeking injunction,
Oh, yes.
seeking injunction against the respondent defendants. As observed here in above, the petitioner is the second defendant. The trial court by an order, the trial court initially grants temporary injunction of restraint against the respondent. The defendant files an application under Order 39 Rule 4 seeking vacation of the order of temporary injunction. After hearing the parties, the application filed under 39(4) comes to be rejected and the application filed by the petitioner under Order 39 Rule 1 and 2 comes to be partly allowed. Partly allowed would be granting an order of status quo and not a complete restraint or injunction. This is called in question by the present,
Plaintiff question. Plaintiff.
the
First respondent.
plaintiff calls in question before the first appellate court on the score that the injunction ought to have been granted and not an order of status quo. The first appellate court answering the appeal grants an order of injunction against the respondent. The second defendant before the suit and the appeal is before this court calling that in question. The learned counsel appearing for the petitioner, learned senior counsel appearing for the petitioner would take this court to the documents appended to the petition to demonstrate that right and title over the suit schedule property was long before the plaintiff had secured the right and title over the suit schedule property in the manner that it has flown, which according to the learned senior counsel is in accordance with law, and would submit that the concerned court ought not to have granted a status quo, and status quo would not amount to an order under Order 39 Rule 1 and 2. And if it would not be an order, the first appellate court should not have entertained the appeal as the appeal was not maintainable. On all these scores, he would seek to project the order to be set aside and the suit and the concerned court to decide the suit itself. Per contra, the learned counsel PM Harish appearing for the petitioner, plaintiff would vehemently refute the submission to contend that the lady,
My vendor.
the vendor of the plaintiff was conferred this site by the state on account of acquisition of her property in terms of a notification dated 11/11/1976. On being a land loser, the site was granted. The acquisition was challenged and the acquisition comes to be set aside. But the proper site another. The site that was granted to her was not restored. The grant of site was not revoked or restored back to the hands of the state, as the acquisition itself is set aside. On the petitioner, then the vendor of the plaintiff sells the property to the plaintiff. Yavata sale?
LDD is not.
To the plaintiff, and owing to certain disturbance from the hands of the present defendants, the suit is preferred. The suit is at large before the concerned court. What is now operating is an injunction against the respondents granted by the First Appellate Court. The reason so rendered by the First Appellate Court or the trial court, as the case would be, is to protect the interest of the parties in the balance of convenience, directing parties to maintain a status quo. Therefore, the will continue the status quo and direct the suit to be concluded.
So far as the
ಅಲ್ಲ ಇವತ್ತಿರೋಂಗಿರ್ಲಿ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ
ಅಂದ್ರೆ ಅದೇ ಹಾಸ್ಪಿಟಲ್
ಅಲ್ಲಲ್ಲ ಏನ ಬೇರ್ ಶೆಲ್ ಏನ್ ಇಟ್ಕೊಂಡಿದಾರೋ ಹಾಗೆ ಇರ್ಲಿ 6 months Milord, if it doesn't open an hospital Milord, it is not going to result in a catastrophe.
You come this side.
Kindly see the
If 6 months Milord, these are all Milord wealthy hospitals. If it doesn't open for another 6 months, it's not going to be a catastrophe.
Kindly see this photograph. It is, what is the stage of it?
Dispute that is how the.
Then you don't claim equities later.
That may be done.
Yes. In the light of the First Appellate Court granting.
I just Milord proposes. If Milord, if they want to complete and open Milord hospital, let them Milord do it with the permission of the court at least.
That's what I'll pass that.
Greatly obliged.
In the light of the order of the First Appellate Court subsisting even today, which was granted on 19th October 2024, and the petition itself being preferred on 6th January 2025, and the same languishing before the court without complying with the office objections. The construction of the property has progressed. In the light of such progression, the only relief that can be granted now is that the concerned court shall hear the parties and dispose the suit itself with an outer limit of 6 months.
Greatly.
In the outer limit of 6 months, the construction that would come up or further construction that could be taken up, the parties are at liberty to move the court for completion of construction or completion. But
99% almost.
Then 99% ಹೋಗ್ಬಿಟ್ರಿ.
Plastering ಆಗ್ಬೇಕಷ್ಟೇ.
ಪರಲ್ಲ, yes.
Plastering and interior.
So and so, the injunction is continued. Further, the parties are at liberty to file necessary application before the concerned court seeking appropriate reliefs at in the interregnum if need arises. The suit shall be concluded with an outer limit of 6 months from the date of receipt of the copy of this. Yes.
79.
Milord.
ಇದು ನಿಮ್ದೇನಾ?
Equities.
Now your lordship has
ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲಲ್ಲ ಇಲ್ಲಿ ಹೇಳ್ಬಿಟ್ರೆ Milord, if I lose the suit Milord, obviously Milord, he is the complete beneficiary.
You are confident?
ಅಲ್ಲಲ್ಲ. If Milord, if Milord uses the suit Milord, he should not
he
feel shy.
loses the suit ಅಂತ ಹೇಳಿ, if I lose the suit ಅಂತ ಯಾಕೆ?
He should not feel shy to invite that order. Let him not claim equities.
The concerned court, while drawing up a decree, shall also consider the issue with regard to claiming of equities of the person who would lose the suit.
Greatly obliged.
Yes.
79.
Might appear for the petitioner, not respondent. But my respondent has given the list of properties that has to be included in the partition suit. My facts are this, my application for impleading was rejected. Against it, this.
Who are you?
I am the joint family member. He says, there was already a partition. I said, the last occasion, that there was no partition, and on partition deed, that was not acted upon. Then your lordship suggested them to include those properties, for which I have no objection for including those properties which they say that there was a partition. The list is given to me today. My petitioner's wife is expired. Day after tomorrow or Saturday, it may be taken up.
29th. Yes. Reason it.
I can't say anything.
Senior counsel ಯಾಕೆ ಬರಕ್ಕೆ ಹೋದ್ರು? Yes, ಇರ್ಲಿ. ಅಂತ ಮಾಡಿ.
I was not knowing this reason.
ಇಲ್ದರ್ ಕಾಂತರಾಜ್ ಸರ್ ಇಲ್ದರ್ ಬರ್ತಾನೆ ಇರಲ್ಲ. ಮಾಡಿದ್ದೆ.
ಹೇಳಿದ್ದೆ ತಾನು, ಇವ್ರು ಹೇಳಿದ್ದೆ ನಾನು.
It's all right. No problem.
ಹೇಳಿದ್ರು ತಾವು ಬಂದಿರೋದು ನಮ್ಗೆ.
ಇಲ್ಲ, ಆ ತರ ಇಲ್ಲ.
We have no say in the matter.
Yes. Reference proceedings, my lords, for deposit of the compensation
Why?
has been converted into proceedings for enhancement as well.
Under the new regime, my lord, under the 2015 Act,
Yes.
the distinction vis-a-vis the old act is, my lords, that an earlier enactment, if there is a dispute with respect to the compensation, I was supposed to deposit it. If they do not claim.
Correct.
Now under the new regime, my lord, if there is a dispute with respect to compensation, under 77 clause 2, it says that I should deposit if they, I'm sorry, my lords, I'm really sorry. Under the new regime, my lords, if they claim enhancement, I am duty bound to deposit the amount before the reference court. So therefore, my lords, I have deposited the amount. Now, one application was filed at the fag end of the proceedings when the matter was posted for judgment, seeking
1817. Order 18 rule 17.
Recall Madi. And then they said that he may be permitted to lead evidence on the enhancement as well. That application was withdrawn without seeking any liberty. Thereafter, the same application was filed again, and it has been now allowed. Now, essentially, what happens is in a proceedings where compensation is to be withdrawn by adducing evidence, the same matter has been converted into enhancement proceedings as well. So
All right.
That is
not permissible, is what you say.
Well, ideally, my lord, there has to be two distinct proceedings as it existed.
You serve on the respondent.
Yes.
Petitioner to serve on the counsel for the respondent. Petitioner to serve on the counsel who represents the respondent in the trial proceedings. Lest the matter on 10th September. Further proceedings before the concerned court shall remain stayed till the next date.
81 adjourned, 82.
Respondent number 182, my lords. The respondent have made an arrangement of 2 lakh, my lords.
2 lakhs, 32
my
lakhs
lords,
they are supposed to deposit.
The rest
1
of the
minute,
amount, my lords, are praying time to deposit, my lords.
The last week itself they had.
2 more weeks to comply in its entirety. Yes, madam.
32 lakhs has to be deposited, my lord.
Lords, it has already been deposited the half of the decretable amount.
Now, what is the order that is in challenge?
My lord, the
Memo of
order
calculation.
Please, my lord, if the executing court continues the stay even when they have not deposited the
I will
entire
vacate
amount,
this
my
stay.
lord. That is, my
It's
lord,
all-
it is-
I'll vacate this
My lords,
stay.
in timely we have deposited before the DB bench, my lords.
DB bench.
Yes, my lords.
DB bench ಯಾವುದು?
This is an commercial appeal, my lords. It has already been deposited
bench
before the
ಅಲ್ಲ?
division bench, my lords. They claim here only for the interest amount of that decree.
The entire amount is in deposit there?
My lords.
But the decretal amount is 51 lakhs plus interest, my lord,
Correct.
which is coming up to 77 lakhs. They deposit 50% of only the principal amount, which is what is under challenge. They should have deposited.
Then what is
32
this
lakhs.
petition about?
25 lakh.
Now, when
and
the
all
appeal
it
is
already
pending,
deposited.
how can the execution go on?
My lord, the executing court grants as conditional stay. That condition has not been deposited.
Oh, that's all, is it?
And the executing court, in spite of bringing that to the notice of the executing court, the stays continue.
We made.
How
they
much
made
had to be
the-
deposited, madam?
For the DB bench, the same, my lords.
How much had to be deposited?
Lord, annexed to G, my lord, all my calculations.
How much
are
is that?
forthcoming. The 32 lakhs is what they have to deposit, and they have undertaken before this court on 2/7 that they will deposit the amount. The order
But,
passed by this court on 2/7.
What we have deposited before the DB bench, the DB bench has accepted our deposited, my lords.
ಅಲ್ಲಿ ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್?
25 lakh and odd, my lords.
25 lakhs.
And 66,000 something.
Anyway, you have not complied with the order. Conditional stay was granted.
Depositing 2 lakh now.
2 lakhs ಇಲ್ಲ madam.
My lords, praying for a
Executing
week's
court
time,
granted stay on what condition?
praying for a
On
week's
what
time
condition?
To deposit the,
50%?
please, my lords.
50% of the decretal amount?
Yes, my lords.
50% of the decretal amount
Total
comes,
amount has been complied. Only they are asking for interest amount, my lords.
decretal amount is complied?
Decretal amount, it is already been, decretal.
Yes, deposit.
one principal amount we have deposited
Where?
in the 50%.
Where?
Divisional bench, my lords.
Before the DB?
Yes, my lords.
Which order was first?
My lord,
No, DB order or executing court, sir?
order. Initially 50% stay is granted.
No, now after the stay granted, the executing court grants stay.
The appellate court grants a stay subject to 75% deposit, my lord. They don't even deposit 50% within time. At
Lords,
annexed G,
in
the
time,
executing court,
before that
while,
we have.
the appellate court.
Yes,
while
we'll
extending
vacate the stay before the
My
executing
lords,
court.
in timely we have deposited, my lords. Only they are seeking for that part of the interest amount.
That is the finding of the executing
Yes,
court.
anything else?
Praying for a week's time to, I will deposit
The whole thing. 50% deposit should be there, otherwise will vacate the executing court's interim order. Yes. This court on 2/7/2025 had passed the following order. The learned counsel for the petitioner submits that before the division bench in the appeal, 25 lakhs is paid. The order of the executing court is granting an interim order of stay subject to the condition that 50% of the decretal amount should be deposited.
75%, my lord. No, my lord, untimely we have deposited.
75%. 75%. The
Division bench order is 75%.
The-
Such untimely we have deposited.
1 minute,
my lords,
madam.
that
2 weeks time is
75%
granted.
is not included.
Within 2 weeks ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಮಾತ್ರ.
We have complied. We have complied with.
Fif- wait, 15, at least 50% you take now.
Is there?
1 minute, madam. 50% of the amount is not deposited. The learned counsel for the petitioner submits that what the division bench directed was 75%. If it was not to be deposited, if 50% is not deposited within 2 weeks, there is a dispute with regard to the deposit. The dispute is pending before the division bench. The case before this court is the continuance of the continuance of the interim order by the executing court, notwithstanding the fact that the petitioners have not deposited, the judgment debtors have not deposited 50% of the decretal amount, which is 50% of 51 lakhs.
50% of 77 lakhs.
50% of
77
decretal amount is 77 lakhs. 50% of the decretal amount, i.e. 50% of 77 lakhs. The learned counsel for the respondent judgment debtor seeks time, yet again. Finally, list this matter on 1st September, on 3rd September in preliminary hearing. In the event the interim order, the deposit of 50% is not made as directed by the executing court, the stay granted by this court will be constrained to vacate the interim order granted by the executing court.
My lord, the deposit we have undertaken to deposit as per Annex to G, my lord. My lords, I got the decree.
2 lakhs,
DD.
better, madam.
My
Yes.
lords,
Get
for a
everything.
week time, my lords, we'll deposit it.
Deposit the whole thing. Yes. Next.
83, my lords, I pay for petitioner.
For
They
the
no
decree
time
holder,
ಕೇಳಿದ್ರಲ್ಲ
my lords.
ಇದು.
Decree holder, it's a calculation issue. But they are claiming that as soon as they deposit some money, the principal goes down. I am saying, my lords, that it is only after the entire interest is set off that the principal will go down. That is the short point.
That's rudimentary.
Allah, the issue is this.
Is that not rudimentary, Shrikant? What is this?
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ನಾನು ಹೇಳೋದಕ್ಕೆ ತಾವು ಒಂದ್ ನಿಮಿಷ ಕೇಳ್ಬಿಟ್ಟು then
ನೀವು ಹೇಳೋದು ಕೇಳಿಸೋದೇ ಇಲ್ಲ VC ಇದ್ರೆ. Yes.
whether I am audible now, my lords?
No, you are not audible at all. Nobody is able to hear you. Yes.
Annexure AJ, my lords, page number 296 is my memo of calculation. 297, my lords, is will show, my lords, as to how I calculated it.
Yes, sir.
When, my lords, as and when it was paid, my lords, the interest as on that day, my lords, was calculated, my lords, amount was paid. And for the remaining amount, my lords, the interest was again calculated and the same was being paid. The annexure A, my lords, page number 299 is their memo of calculation.
Yes.
But the executing code at 302, my lords,
Yes.
last paragraph would say the memo of calculation filed by JDR no doubt shows that he has paid rupees 10 lakhs so and so, but JDR is not specific what was the amount paid towards principal and what was the amount paid towards interest. My lords,
ಅದು ಡಿವೈಡ್ ಮಾಡಿ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಹಾಕಿ.
ಅಲ್ಲ ಹಾಕಿದ್ದೇನೆ, ಅದನ್ನ ಅವ್ರ ಮೆಮೊ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತೀನಿ ಅಂತಾರೆ. ಹೇಗೆ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತೀನಿ ಅಂತಾನು ಹೇಳೋದಿಲ್ಲ. I have explained as to how I calculated. Court says no, you have not said.
All right, wait.
But the issue is this, my lords, according to them also, I am due to pay them, my lords, certain sum. What they say, my lord, and what is also awarded, my lords, I have to.
Then what is the transaction about?
An arbitration award.
Arbitration award.
They succeeded. They went till the Supreme Court. They got one portion of the award set aside. That has now attained finality. They have paid a substantial portion. In my memo of calculation, about 3.9 lakh is due. How they calculate it, my lords, is some paid at page 299, my lords, is their memo. What they do, my lords, is, if your lordship will please see, as soon as some sum is paid, they straight away deduct it from the principal and they say new principal, which cannot be done. The entire interest has to be knocked out first, and only thereafter the principal gets.
It is in anticipation of, my lords, the period when I will complete the.
Who gave you, who gave you this method of calculation?
My lords, my lords, we paid, my lords, what was.
You paid, how does the principal come down without interest getting cleared?
Lords, the total sum which was, my lords, available on that day was paid up. Lords, may kindly.
Now what did the court do?
Lords,
the
Honorable Court accepted my memo. Thereafter, I have filed an application praying that he be directed to disclose his assets so that I can take further steps. It is pending at that stage.
Oh, disclosure of assets.
Disclosure of assets.
Disclose, sir.
To settle the controversy, my lords.
Settle the controversy and ದುಡ್ಡು ಪೇ ಮಾಡ್ಬೇಕಷ್ಟೇ.
ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೇನೆ.
ಹೇಳಿ.
299 ಅಲ್ಲಿ, my lords, if you lords kindly see on the left hand side, my lord, what is to be paid, my lords, is arbitration cost of 43,000, advocate fees, my lords, of rupees 30,000, my lords, cost, which is about 10,000. So totally it is about 77,000. What they, my lords, say is that I had to pay them 3,35,000. Lords, what I will, my lords, straight away say is that I'll pay, my lord, these admitted portions. That is 87,000, my lords. I'll pay up. My lord, there is no.
3,35,000 plus.
Out of that, 87,000, my lords, is what is to be paid.
The total amount ಎಷ್ಟಿದೆ Manu?
Lords, total amount as of today is 3,92,048 rupees.
ಈಗ ಎಷ್ಟು ಪೇ ಮಾಡ್ತೀರಾ ಅದರಲ್ಲಿ?
ಇವಾಗ 1 ಲಕ್ಷ, my lord, there is no difficulty because 87,000, 1 lakh, my lord, I'll definitely pay. My lords, rest what will remain, my lords, even according to them, as on today is about another 3 lakhs. My lords, I'll pay, my lords, some amount and close it off. I can pay, my lords, another 50,000.
Some amount ಇಲ್ಲ. Critical amount.
I have paid, my lords, my lords, what they say.
All right, now you pay 1.5 lakhs.
I would, my lords,
now, yes. There shall be an interim order of stay. What is prayed? Of further proceedings before the concerned court, subject to the condition that the petitioner would pay 1.5 lakhs to the respondent in the next 4 weeks. List the matter on 24th September. And
Great.
ಅಷ್ಟಾರು ಬರ್ಲಿ.
Please. Close ಮಾಡ್ತೀವಿ ಅದರಲ್ಲಿ ಏನು
ಮಾಡಿ. Yes. Next. Rajeshwar.
84.
Plaintiff's writ petition, my lords, temporary injunction ex parte granted, vacated. Then, my lords, I filed an appeal. Interim order was granted by the first appellate court. Now it has been dismissed, my lords. On the ground that there's a dispute as to identity of the property, court commissioner is to be appointed. That's what happened was in 2021 against the vendor of the second defendant, who is the first defendant in the suit. I filed a suit for temporary injunction not to interfere. I had the benefit of an order of temporary injunction in that case, my lords. During the pendency of that case, my lords, the first defendant sells the suit schedule B property in favor of the second defendant. On 4/3/2024, I have taken an order of police protection, my lords, that he should not put up any construction. He proceeds to put up construction by saying that his property is different, my property is different. Then I file a suit for declaration that the schedule shown in his sale deed is imaginary, it does not exist, therefore the sale deed is not binding, and the construction activity which is taking care.
We'll take it on 3rd.
Proceeding with construction even now, my lords, in spite of my lord's order.
Why, sir?
I am not done. Even they filed the continuation of, contempt application, contempt application also. I filed in detailed objection to the section, my lord. I am not done anything here. Further, ನನ್ನ ಏನಾಗಿದೆ ಸೊಮ್ಮೆಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗ್ಬಿಟ್ಟಿದಾರಲ್ಲಿ. ನಾನು ಪ್ಲಾಸ್ಟಿಂಗ್ ಎಲ್ಲ ಮಾಡಿರೋದಕ್ಕೆ ನೀರು ಅದು ಇದು ಕ್ಯೂರಿಂಗ್ ಆಗಿ ಮಾಡ್ಕೊಂಡ. ನಾನು ಅದು ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ನಾನು
ನಿಮ್ದು ಹಾಸ್ಪಿಟಲ್
ಅಲ್ಲ ಮನೆ ಕಟ್ಟಿದೀನಿ ಕ್ಯೂರಿಂಗ್.
From day one, construction is going on in violation of the court order.
All right, yes. Let's the matter on 3rd. Interim order subsisting will continue to the next date of hearing. The learned counsel for the petition now alleges despite the grant of the interim order construction, the respondent is continuing with the construction. Learned counsel submits that he has stopped construction from the date of the interim order and has filed detailed objections in the contempt petition, and would undertake that he would not continue with the construction during the subsistence of the interim order.
Preliminary hearing.
Same stage. Yes. Preliminary hearing illa. It will come in vacating stay, little above preliminary hearing. Yes. 80? Yeah, where is he? Interim order ತಗೊಂಡ್ಮೇಲೆ ಮಾಜಿದ್ ಬರದೇ ಇಲ್ಲ.
I appear for the second respondent in this matter, my lord. Ejectment suit came to be decreed.
Where is he? Video? Yes, Abdul.
My lord, sir, I took permission, my lord, that my mother is ill. My lord, sir.
Permission was not granted. Yes.
My lord, Monday I call you, my lord. I will give you the judgment of Jolly Varghese, my lord.
Jolly?
My lord. Monday I call you, my lord. Director, my lord. My mother is little ill, my lord.
In this case, my lord, it is ejectment suit. One submission, let me be permitted.
Really, sir.
Here, an order of attachment of movable warrant has been issued. Delivery warrant has been executed. I have taken possession. Appeal has been preferred. It has been dragged. Finally, it came to be dismissed for non-prosecution. After the delivery warrant was issued and taken possession, application has been filed for restoration of the appeal. That came to be dismissed. Again, another application came to be filed for restoration. They remained absent. That also came to be dismissed. When an attachment of movable warrant has been issued, my lord, they preferred another writ petition.
What happened to that?
They volunteered before this honorable court to deposit 25% of the amount, 15,65,303 is due. Madil Adantamon trial court munde hakamuttu execution proceedings has been dragged. And finally, by executing the movable warrant, I couldn't secure my money. Arrest warrant came to be issued.
1 minute. List tomorrow at 2:30.
Please.
Thank you, my lord. Thank you.
ನಾಳೆ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು
ಇಲ್ಲ ಬರ್ತೀನಿ, my lord. ಇಲ್ಲ ಬರ್ತೀನಿ, my lord.
ಗೊತ್ತಾಯ್ತಲ್ಲ ಹಿಸ್ಟ್ರಿ ಏನಾಗಿದೆ ಅಂತ.
ಗೊತ್ತಾಯ್ತು,
not a minute time I will grant on any ground. Yes.
Thank you, my lord. Thank you, my lord.
And dismissal with exemplary costs.
No, my lord. I'll be there, my lord, at 2:30.
Yes, yes. Come.
Thank you, my lord.
Thank you.
Filed a suit for the relief of declaration and injunction before the trial court.
Not had lunch?
I had.
ಹೇಳಿ ಸರ್ ಜೋರಾಗಿ ಸ್ವಲ್ಪ.
I have filed a suit for the relief of declaration and injunction before the trial court, before the third additional senior civil judge Devanalli, my lord.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಂತ ಹೇಳಿ ಸರ್, ಕೋರ್ಟ್ ಹೆಸರು ಕೇಳದ್ನ. ಏನ್ ಹೇಳಿ?
Along with the suit, I have filed a 2 application.
39(1) and 2.
1 and 2.
Consider ಮಾಡಿಲ್ವಾ?
Consider ಮಾಡಿಲ್ಲ sir.
ಯಾವಾಗ?
I filed the suit on 17/1/2025, my lord.
17/1/25. Now they would be represented. I'll direct the court to consider it and pass orders in 2
In
weeks.
spite of service of summons, my lord, the defendants, contested defendants and also other defendants have not appeared before the court, my lord.
Service ಆಗಿದೆಯಾ?
Service ಆಗಿದೆ sir.
Service ಆಗಿದ್ರೆ court will pass orders, don't worry. Yes.
Till then, status quo.
Why till then? 6 ತಿಂಗಳಿಂದ ಇಲ್ಲ, 6 months ಇಂದ nothing. Now you want it?
No, my lord. Initially, I have protected that interference. Thereafter, on the taking new advantage of the vacation, they once again they came to the.
The defendants are not appearing.
Not appearing, my lord.
We'll see. ಇಲ್ಲಿ ಸರ್ವ್ ಮಾಡ್ತೀರಾ by way of hand summons? ಇಲ್ಲ, I'll direct you to do it there. What?
I will argue the matter before the trial court, my lord.
The petitioner is
Then
before.
status quo,
1 minute. The petitioner is before this court, calling in question an order dated 22/1/2025 by which the concerned court declines to grant an interim order, declines to grant temporary injunction in answer to an application under Order 39 Rule 1 and 2 of the CPC. The petition is filed on, the subject petition is filed on 13/5/2025, while the emergent notice was issued on 22/1/2025. The learned counsel for the petitioner submits that despite service of notice, the defendants are not appearing before the concerned court.
No notice is issued, my lord, by this honorable court.
Illalla, sir. The learned counsel for the petitioner submits that despite the issuance of notice by the trial court, the defendants are not appearing before the concerned court, and therefore the court has not taken up any steps further. In the light of the application under Order 39 Rule 1 and 2 pending before the concerned court, I deem it appropriate to dispose the subject petition, directing the concerned court to hear the parties and pass necessary orders in accordance with law. In the event the defendants would not represent despite service of notice, the concerned court shall pass appropriate orders with regard to their non-appearance and take up the application for application under Order 39 Rule 1 and 2 of the CPC that is pending consideration In the light of this direction, till the application, next take Malibadi. Status quo ilvala ಈಗ.
ಇಲ್ಲ status at least till consideration of application because they are trying to interfere my possession.
Possession,
My
6 months in the nothing has happened.
No, my lord, in the month of May, during the vacation, they try to interfere my possession. Therefore, I come up before this honorable court, my lord. I have produced all the.
What is the property?
Property, the landed property, my lord. 10 acres of land.
Status quo where the property be maintained by the parties till appropriate orders are passed by the concerned court on the application or otherwise. Ordered accordingly. Yes, next.
87.
Sir, counsel appearing for
As a counsel.
trial court, my lord.
Till the orders are passed under 6 ತಿಂಗಳಾಗುತ್ತೆ. Will direct the court to pass orders in 4 weeks.
After service of notice as to other defendants.
Then it will take 4 years to serve every defendant.
That's okay.
And don't do that. The concerned court shall pass necessary orders on the application order 39 rule 1 and 2 within an outer limit of 4 weeks as observed here in above. The status quo order granted by this court is continued only up to the period of 4 weeks. Yes.
Till consideration of the application. And for
Only a period of 4 weeks. I'll consider ಮಾಡ್ತಾರೆ.
Grateful. Yes.
87.
Sir, counsel appearing for respondents before trial court on 12th of this month. Memo is filed today morning.
ಯಾವತ್ತು ಸರ್ವ್ ಮಾಡಿದ್ರಿ ಸರ್?
12ನೇ ತಾರೀಕು ಸರ್.
Suit for?
A suit for declaration and permanent injunction. An application.
Compromise.
Application was filed for withdrawal of the suit with permission to file fresh suit on the same cause of action. Said application came to be rejected.
Why withdrawal of the suit at what stage?
It was at the stage of evidence, my lord.
Why?
Because certain facts pertaining to earlier litigation was not brought to the pleaded.
Amendment, Kelly. See, should have sought an amendment.
Multiple proceedings, my lord, so that it
Sought an
not be
amendment.
pleaded elaborately in the plaint. That is the reason.
If the suit for declaration.
Declaration and
Cause of action yavaga? According to you, what is the cause of action? Date. Plain tell cause of action yavatide sir?
6 months prior to filing of the suit, my lord.
6 months suit file ಮಾಡಿದ್ದು ಯಾವಾಗ?
2022.
ಮತ್ತೆ if liberty is now given to file a declaratory suit, comprehensive or whatever, Article 58 won't come in the way?
Actually, there are multiple.
Whatever, you should have sought amendment.
There were certain previous litigation, my lords, between the parties. The same could not be placed before the court, my lords.
Anyway, serve ಮಾಡಿದಿರಲ್ಲ.
Serve ಮಾಡಿ.
Less the matter on 10th September in preliminary case. Next.
88, 89, 90.
Orders passed by the RERA, my lords, was sought to be executed before the civil court. I have filed an application under section 47 that came to be rejected, my lord, challenging that order. I'm here, my lord, before this honorable court. My lord, section 40, my lord, of RERA Act, my lord, provides for execution of the order passed by RERA. And my lord, there is section 79, my lord, which bars the jurisdiction.
How do they get it executed?
Section 79 of the RERA Act, my lord, bars the jurisdiction of the civil court, my lord, for the orders passed by the. On the last.
Now, what is
occasion,
under
my lord,
challenge?
Section 47 application, my lord, I
Where?
have challenged the jurisdiction of the execution
Civil court,
proceedings before the
executing
civil
court.
court. That application came
Yes,
to be
Reynolds.
dismissed. And
My
my
lord, the relief, what is sought may be seen, my lord. It is the challenge to the impugned order and allow the same. The application is filed under section 47 in a execution proceedings of an award, not a decree, my lord, which has been answered by the coordinate bench of this honorable court. I have already produced it before this honorable court on the last occasion.
Yes, madam. Tell me.
Memo, my lord, dated 21/7/2025. My learned friend, my lord, was relying on two judgments, my lord. The first judgment, my lord, coordinate bench of this honorable court, my lord. Section 47 is not maintainable because, my lord, in that proceedings, the award, my lord, passed by the arbitrator was challenged in an execution proceedings. In such circumstances, my lord, the award is not construed to be, my lord, a decree. Hence, section 47 application is not maintainable. The second judgment, my lord, which was relied by my learned friend, in that, my lord, the jurisdiction of the original court, my lord, was challenged in execution proceedings under section 47.
So both are not applicable.
Applicable, my lords. And my lords, I may be.
What is
permitted
this
to-
Nirmiti Kendra?
My,
ನೀವು ಕೊಟ್ರದ?
ನಾನು ಕೊಟ್ಟೆ. That is the judgment which we are relying on.
All right, ಹೇಳಿ.
Let's, I may be permitted. Just to show, my lord, the applicability of section 47, my lord, in the execution proceedings, my lord.
Yes.
If my lords may kindly have, my lord, page number 6, my lord, paragraph number 12. Whether the section 47 application is maintainable, my lord, before the execution proceedings. The issue was answered, my lord, in paragraph number 28, my lord, at page number 11. The exercise of powers under section 47 of the code is microscopic and lies in a very narrow inspection code. Thus, it plain and executing code can allow the objections under section 47 of the code to the inexecutability of the decree if it is found that the same is void ab initio and the nullity. Apart from the ground that the decree is not capable of execution under law, either because of the same was not passed in ignorance of such provision of law, etc. my lord. Thereafter, my lord, page number 15, my lord, paragraph number 41. It is held, my lord, section 47 is applicable, my lord. The next judgment, my lord, is at page number 18, my lord. The relevant page, my lord, page number 19, my lord, section 47 of the CPC is extracted, and thereafter, my lord, which is answered in page number 20. A bare perusal of the aforesaid provisions shows that all the questions between the parties can be decided by the executing court, but the important aspect to remember is that these questions are limited to the execution of the decree. The executing court can never go beyond the decree under section 47 of CPC. The executing court can examine the validity of the order of the court which had allowed the execution of the decree in 2013 unless the court's order itself is without jurisdiction. Thereafter, my lord, the next paragraph, it is held, my lord, by quoting another judgment of the Supreme Court, my lord, that section 47 is applicable, my lord, which is once again answered, my lord, at paragraph number 24, my lord, in page number 21. That apart, my lord, the one more issue was raised, my lord, by my learned friend, that these are the transfer decree proceedings. If my lords may kindly have page number 31, my lord. The execution application was filed.
What is the order that is sought to be executed?
It is
order is of RERA.
RERA refund
Orders of
order.
the RERA.
RERA refund along with a direction to foreclose the loan with the bank, my lord.
Where is the order? RERA order.
Let's RERA order notice.
One of the order is
Used to notice. In one of the matter, my lord, the RERA order, my lord, is at page number 34, my lord. 34, my lord, in which the memo which I have just passed on. Out. My lord, the complaint was filed against some other company. The order was passed against, my lord, some other company. However, my lord, challenging that aspect, I'm already in an appeal before, my lord, the RERA, which is at page number 1.
34 ಯಾವುದು order ಇದೆ ಯಾವುದು?
That is the order passed by.
That's the order that is now sought to be executed.
Please, my lords. There are 3 orders, my lord, similar orders, 3 petitions.
So according to you, it cannot be executed
Sections.
before the civil court.
Please, my lord.
How
Section
does one
70.
execute the order of RERA then?
Lords, may kindly have section 40, my lord, of RERA.
Of the RERA?
It provides, my lord, for execution of the order passed by.
How?
Lord, if I may read, my lord, section 40. Recovery of interest or penalty or compensation and enforcement of order, etc. If the promoter or an allotee or a real estate agent, as the case may be, fails to pay any interest or the penalty or compensation imposed on him by the adjudicating officer or the regulatory authority or the appellate authority, as the case may be, under this act or the rules and regulations made thereunder, it shall be recoverable from such promoter or allotee or the real estate agent in such manner as may be prescribed as an arrears of land revenue. Land revenue, my lord, which they have already initiated. There are, my lord, mandamus petitions
Arrears of
filed.
land revenue.
Please, my lords, and mandamus, my lord, was filed, and now, my lord, they are before the contempt court, my lord. That's a different procedure.
My lord, it is not connect. May I make a submission?
No, yes, sir.
My lord, kindly the memo dated 21/7/2025 may be taken up. The judgment. My lord, the judgments which is being provided today deals with a suit and which is culminated in a decree and execution is in
Which are the
progress.
judgments given by you, sir?
That is Bellary Nirmiti Kendra, my lord.
There.
Along with the memo, I have produced it before on 21/7/2025, my lord. Yes, ma'am. This judgment purely deals with a situation where the execution is not pertaining to a decree of a court, but it is an execution of an order, and the legal fiction is created by the statute to treat it as a decree for the enforcement, my lord. My lord, if page number 8 of the memo may be seen, my lord. Para number 23 of the judgment.
This is under the MSME.
This is MSME and Arbitration Act. The very similar to the very same legal fiction can be foreseen in RERA Act as well during the when it comes to execution of the awards, my lord. My lord.
Yes.
23, my lord. That is the Honorable Supreme Court in the case of Paramjit Singh Pateja versus ICDS Limited. When it talks about it, it speaks about 5 points to be considered, my lord. One is the para number 18, subpara number 18 of the judgment, my lord.
Yes.
It says, it talks about the award. It can therefore be observed that it is only for the purpose of enforcement of the award that the arbitration award is treated as if it were a decree of the court. The words decision and civil court unambiguously rule out an award award by arbitrators. Section 15 of Arbitration Act provides for enforcing. It is a very similar provision with respect to RERA as well, my lord. The next underlined paragraph in the same 39. For this limited purpose of enforcement, the provision of CPC were made applicable for realizing the money awarded. However, the award remained an award and it did not become a decree either as defined in CPC and much less so far as the purpose of an entirely different statute such as Insolvency Act. My lord, next page, my lord. An arbitration award is neither a decree nor an order of payment within the meaning of section 9 subclause 2. The expression decree in the Court Fees Act is liable to be construed for the reference to its definition in CPC and hold that there are essential conditions.
Now you have initiated proceedings under arrears of land revenue.
No, my lord. I only approached the RERA for execution through civil court, my lord, because the reliefs what has been granted by the RERA is in two folds. One is the refund. Correct. The other one is in the nature of injunctive relief, my lord. That is, there is a direction to the builder to foreclose all the loan amount. That cannot be treated as refund because, my lord, that is not coupled with the interest. So it is a mixture of both a refund award as well as this, which can be brought before the civil court. And my lord, before making that submission, my lord, what is actually aggrieved by the other side is an order of transfer of the award from RERA to civil court, which is a separate order which is in existence as on today, which I am producing before this.
What is challenged here is
47 hour, which is not applicable in this case because it is not a suit.
We'll answer it. Yes. This has certain ramification. We'll answer it. Yes. Anything else? First matter,
3 matters.
Heard reserved.
My lord, the judgment which is given is purely applicable in the case mutatis mutandis, my lord.
Consider. Yes. What's the next date there?
In the month of September, 9th September or so.
All right. There's if the pronouncement goes beyond that, we'll post it and grant stay and then continue it.
However, there's a protection, my lord, that the trial
Granted
court has
here, is
to
it?
defer
Yes.
the proceedings further.
All right.
Now, my lord, by virtue
any
of
interim,
this-
I have reserved it, so it is any interim protection subsisting today shall continue till the pronouncement of the judgment.
So
much of.
Respond.
One నిమిషం.
issue is fairly. Issue is fairly simple, my lord. We are purchasers of the land 15 acres in 2004. My vendor's vendor were the original villagers landowners. They contend that they divided the land into two halves. One faction has gone and filed a suit without impleading me, obtained a decree. Another faction has filed a suit where I'm sought to be impleaded. I have advised them that ideally both the proceedings should get clubbed. They are saying that the two parcels of land are different, 14 acres, 14 acres. I am the owner of 15 acres.
Let it be decided in the suit.
Well, that's what I'm saying. Let everything be decided in the suit. Let both the proceedings be clubbed. It's as simple as that. That's all that I seek.
My suit.
Let them be taken up together, if not clubbed.
I'll just clarify minutes.
I'll just last submission. I purchased it in 2004. I have developed a full-fledged corporate campus. I am Tesco, international supermarket chain. My corporate campus is functioning for the last 2 decades. Now these original owners are coming and say, Idnan Bhaga, Adnan Bhaga. Ellar Bandri one kade, we will decide it once and for all.
My suit number, my lord, is OS 222 of 2007, which is at the stage of evidence of the plaintiff. My lord, the other matter where
Present suit.
My lord, the
present suit,
present writ petition arises out of my lord, the order passed, my lord, in OS number 222 of 2007. My lord, the other suit which was filed by one of the daughter of the vendors of the petitioner hearing was of the year 1996. The suit came to be dismissed. This honorable court in an RFA granted the decree of 1/4 share. That is in FDP. FDP and the suit which is now pending, which is at the stage of evidence, cannot be clubbed together at this juncture because there is already a determination of the shares. Therefore, that FDP proceedings will go on separately. My suit is altogether different. Therefore, both suits cannot be.
Pardon,
settle agata.
I am way ahead of both of them. My campus is already settled. If at all they talk of money, it is possible. But land, how can I give my land? Campus is going on.
If the other side is open for mediation or settlement, I'll ask my parties to explore. If it is possible, we can explore.
I'll take it on 29th. Try to explore the possibilities of a settlement.
Please.
On the last occasion, my lord had said, make a request to the trial court to defer the proceedings.
Yen madidru?
Impose costs.
Kodi.
And kept it. Day after tomorrow.
Yes. The parties to the list are directed to explore the possibilities of a settlement, as the only settlement that can be arrived at now would be monetary. And monetary, as the petitioner is said to have set up the premises in the land, which is now claimed by the respondents 2 decades ago. In that light, parties are directed to explore the possibilities of a settlement. Till such time, further proceedings before the concerned court shall remain stayed.
Great.
Ashok, may I have this matter on sometime, Lord, on 29th or 30th? In
Yavat bek?
30th minutes.
30th Saturday.
30th
Saturday. Yes.
Obliged.
92.
But my lord, sorry, my lord, just
92
one
ne
clarification, my lord. Parties in the FDP, the other proceedings, can we request them also to join the mediation? That can't be an order there, but
the settlement, the talks of settlement be had from all the stakeholders or the parties to the list or incidental petitions pending, incidental suits pending, suit/FTP pending. Yes.
Great.
Next.
Thank you.
92. For the petitioner,
92
in this matter, short adjournment. I have served the copy, my lord. I will file the acknowledgement in the counter.
1 week.
Any date on this
List the
week, my
matter
lord.
on 3rd September at the request of the council appearing for the petitioner. Next.
93.
Petitioner, please, lordship.
Appearing for respondent number 4, will undertake to file a wakalat.
Learned counsel so and so undertakes to enter appearance for the respondent.
Number 4, please.
Eredidyಾ?
ಇಲ್ಲ ಒಂದು
Both the respondents.
R4 ಗೆ appear ಆಗ್ತಾರಂತ.
Both the respondents. List the matter on next date, issue.
Next date is
24. Yes. List the matter on 10th September. Yes. Next in preliminary hearing.
94 adjourn, 95.
95. Respondent, registered to print the name of Nataraj Ballal as appearing for the respondent.
I'll file
Nor-
it. I'll file it in the registry.
Vakalata. File it in the registry. Nataraj, Learned Counsel Shri Nataraj Ballal undertakes to enter appearance for the respondent, registered to print the name of so and so as appearing for the respondent. Next.
96.
Your copy has been served to the advocate.
96. I'm sorry.
95 ಅಲ್ಲ.
ಅಲ್ಲ, 96.
95 no representation list after 2 weeks. Yes, 96 ಅಲ್ಲಿ ಈ ಆರ್ಡರ್ ಮಾಡಿ ಎಂಟ್ರಿ ಮಾಡಿದೆ ಅಲ್ಲ.
ಇಲ್ಲ, interim order is not given, my lord. The case is also 19th, my lord.
19th.
Just the matter on 10th September.
Much.
97.
Second respondent.
Is there an objection in adjournment?
Allowed in this matter, the
May I
arbitration
submit, my lords? I am
proceedings.
for the petitioner. My lords, I have made an application, please, my lords, for withdrawal of certain damages that they say they have.
Damages, sir.
They are trespassers. Now, my lords, it's something like this. The petitioners and the respondent number 2 have entered into a joint development agreement. 54%, 46%. 54%, the developer has stealthily sold it away, please, my lords, even before informing me also. My area, my lords, constructed area of 46%. With 46%, he inducts, please, my lord, third parties and runs away. Now, these third parties have come up, my lords, before the commercial court, filed one commercial case, please, my lords, and said, suit, please, my lords, and said, now, as to the relief that they have sought is as to whom they have to pay rent, how much they have to pay rent, and where they have to deposit rent, and so on and so forth. Now, my lords, in that case, my lords, what transpires is the only notices were ordered at the stage of, my lords, when the matter was the first hearing stage, and my lord, thereafter they came up before this honorable court. This honorable court said, go and deposit whatever be the damages, my lord, the rents that they contended to be before the commercial court. That they are depositing to my area also, built up areas 46%. There is no quarrel on this aspect.
Now, what is the quarrel?
I filed an application, my lord, seeking to withdraw it. Now,
Lord, there is an arbitration proceedings is pending.
I am not submitting. Let's now what transpires is the trespasser, please, my lords, has been inducted, please, my lords, by the respondent number 2, the developer. He has let out my premises, my lords, for 200 rupees a square feet of rent. He is, my lords, only depositing at the rate of 60 rupees. 2018 onwards, I have given away my property for joint development. Now, 2025, my lords, 8 years, my lords, I do not have 1 rupee, please, my lords, that I have received as rental income till today. How am I to survive, please, my lords? I make an application before the trial court. I may be permitted only to, my lords, whatever be the amount that they have deposited, subject, my lords, I'll for the damages that I will seek, please, my lords, in the future, without prejudice to my rights, I have sought for withdrawal of that amount.
May make consumption.
And that application, my lords, the trial court says, my lords, that let the trial be heard, concluded, and we'll grant you that relief. That is all, please, my lords.
My lord, arbitration proceedings is pending between the parties, my lord. In the arbitration proceedings, my lord, similar application is filed out of 38-5, my lord.
Correct.
And settlement proposal was made, my lord, between the parties, my lord. Arbitration proceedings, the tenant is not a party, my lord. So the learned arbitrator suggested parties to sit together and solve the dispute, my lord. So that, my lord, we are making a proposal.
We are open for it. They have not yet
That's
come
what
forward.
we are asking.
They have not yet come forward.
ಅವರೇ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ ನಾವೇ
ಅವ್ರು
ಕೇಳ್ತಾ
ಬರ್ತಾ
ಇದ್ದೀವಿ
ಇಲ್ವಲ್ಲ?
ಆರ್ಬಿಟ್ರೇಷನ್ ಇಲ್ಲ ನಾವು ಬರ್ತಾ
ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ, ಪ್ರಪೋಸಲ್ ಇಲ್ಲ.
ಪ್ರಪೋಸಲ್ ಕೊಡ್ತಾ ಇದೀವಿ ಸ್ವಾಮಿ ಆರ್ಬಿಟ್ರೇಷನ್
200 ರೂಪಾಯಿ ರೆಂಟ್ ರಿಸೀವ್ ಮಾಡ್ಕೊಂತಾ ಇದ್ದಾರೆ. They are enjoying the benefit out of it, and I don't get anything, my lord, from 2018. Not a rupee. I am a landowner.
Arbitration ಅಲ್ಲಿ the tenant is
somebody trespasser is enjoying 200 rupees rent a square feet, my lords, to my built up area, please, my lords. For the past 5 years, my lords, where will I go, please, my lords? Would there not be something like a horror story, my lords?
ಯಾವುದು?
ಇಲ್ಲ ಹೇಳ್ತಾ ಇರೋದು ಒಳ್ಳೆ
Horror
horror story.
story.
ಇದೆಲ್ಲ ಹೋಗುತ್ತೆ.
Arbitration ಅಲ್ಲಿ the tenant is not a party.
ಮನೆ ಖಾಲಿ ಇದೆಯಾ?
Tech park, my
It's
lord.
become such a situation, my lord.
Tech park.
Would your lordships permit me to appear, my lord, on VC?
200 rupees.
ನಂದಕುಮಾರ್ ಸರ್ ಯಾರಿಗೆ?
Nandakumar is.
I appear for the original plaintiff's counsel, my lords. R1 before your lordship.
Arbitration proceedings ಅಲ್ಲಿ the tenant is not a party, my lord.
I am not a party to the arbitration.
Settlement, my lord. We can explore the possibility of settlement,
Sit
my lord.
across the
Maybe we refer for
May
mediation,
I
my lord.
respectfully submit, my lords?
learned counsel for the respondent submits that the learned arbitrator before whom the parties are for resolution of a dispute had in fact directed the parties to explore the possibilities of a settlement. The allegation is that the petitioner is not coming forward and vice versa.
Allegation ಏನಿಲ್ಲ ಸ್ವಾಮಿ.
Allegation ಮಾಡಿದ್ದೀನಿ. That because they contact
ಇಷ್ಟೊತ್ತು ಮಾಡಿದ್ದೇನು? So and so. The grievance anta ಮಾಡಿ
Grievance.
ಯಾಕಲಿ grievance so and so or vice versa. Therefore, the parties to explore the possibilities of arriving at an amicable settlement by the next date. In the event they don't, the petition would be answered on its merit. List the matter on 2nd
I'm sorry,
September.
I am not a party to the arbitration. Would your lordships kindly say some other party?
The
2018 ಇಂದ ದುಡ್ಡಿಲ್ಲ ಸ್ವಾಮಿ.
correct 2ನೇ ತಾರೀಕು ಇದೆ.
Mediation refer
ಒಂದು
ಮಾಡಿದ್ರೆ
ನಿಮಿಷ.
ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
While
just
exploring the possibilities of a settlement, all the stakeholders are permitted to participate.
Grateful, so grateful.
Yes.
Let it be taken as a submission of respond number 2 because respond number 1 is not party to the arbitration.
Respond number 2.
For that purpose,
Parties hyphen
Please,
petitioner and respondent number 1.
respectfully submit. I have not leased him inside. He is a trespasser in my built-up area.
that's the merits of the matter, my lord. They signed the lease deed, my lord.
My learned friend, my lord,
They
returns
signed
the
the lease
rent
deed,
and
my
then
lord.
comes
They
before your
signed the lease
lordship.
deed
Anyway,
for
I'll point it out.
Kindly appreciate, my lord.
My
The
lord
lease
has
deed
heard
I
the
have-
criminal petition, my lord.
1 minute. ಏನ್ ರೆಂಟ್ ಕಮ್ಮಿ ಆಗಿದೆಯಾ?
Rent
ಅದೇ
ಕೊಟ್ಟೇ
ಸಮಯ
ಇಲ್ವಲ್ಲ
grievance.
ನಂಗೆ. ₹1 ಕೊಟ್ಟಲ್ಲ, ₹200 ಅವ್ರು ತಕೊಂಡಿದ್ದಾರೆ.
Total deposit ಆಗ್ತದೆ ಸ್ವಾಮಿ.
My learned friend should also tell your
Total
lordships,
deposit
my lord.
ಆಗ್ತದೆ ಸ್ವಾಮಿ. That the rent has been
List-
deposited in the court, my
List
lord.
on 2nd September.
Kindly appreciate this
Great.
aspect.
ಬೇಡವಾ 2nd September?
ಅಲ್ಲ, that is fine. That
ಮತ್ತೆ ನೋ ಅಂತ ಇದ್ದೀರಿ?
no, my submission is that the trespasser has leased it to third parties for ₹200.
ಥರ್ಡ್ ಪಾರ್ಟಿಗೆ ಅಪಿಯರ್ ಆಗ್ತಿರೋದು.
ಅಲ್ಲ third part, that's
ಅಲ್ಲ, third parties, there are several tenants he is inducted and he is receiving rents to the tune of ₹200.
Who has inducted?
Not the third trespasser.
they are also party to that lease deed, my lord. I can
I am not,
demonstrate,
I'm
my
not,
lord.
kindly appreciate.
Signatory, yeah?
Signature, one the deed signature.
One
my
the
lord.
deed,
One
yeah.
the deed.
This pertaining to.
My
North
lord has
kindly
answered in the criminal petition, my lord. That only one criminal
ಇರಲ್ಲ.
petition has been, in the criminal petition also.
ಹಾಕಿದಾರ?
ಅಲ್ಲ ಒಂದು ಕ್ವಾಶ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಅದು.
ಯಾವ್ದು? ಇಲ್ಲ,
ಅಲ್ಲ
ಇನ್ನೊಂದು
criminal
ಆಗಿದೆ.
petition has been
ನಾನು
quashed and
evidence
it's
ನೀಡ್ತಾ
been,
ಇದ್ದೆ.
the law has been laid on, my lord. And
Police,
BNSL, the police has to be heard and
But my lords
ಅದ್ರಲ್ಲಿ
my lord's reported judgment.
ಧಾರವಾಡದಲ್ಲಿ.
That had, my lord.
Mandate
Entire
back.
things has been answered in that matter, my lord.
ಧಾರವಾಡದಲ್ಲಿ
Ah.
175 procedure is
Yes,
not
please,
followed.
my lord, please,
ಪೊಲೀಸ್
my
ನ ಕೇಳ್ಬಿಟ್ಟು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್
That's pending before the
my
magistrate.
lords reported judgment. ಪೊಲೀಸ್ ನ ಕೇಳಿ.
In that everything has been answered, my lord.
My evidence is going on. I'm reading evidence in that.
ಅದ್ರಲ್ಲಿ ಪ್ರೊಬ್ಲಿಂಗ್ ಯಾವ್ದು ಗೇಟ್ ಅಪಿಯರ್ಡ್?
Allah is been.
ಅದೇನಾ?
Let's may appreciate, my lord. Page number 168.
No appreciation, only mediation.
ಅಲ್ಲ, ಯಾರು third parties in
Great.
extent.
Senior is in Delhi, my lord, today. That's inconvenient.
Nandakumar sir is in Delhi.
ಅಲ್ಲ
No,
Yes. All right.
ನನಗೆ permission, my lord, to withdraw it, my lord.
ಅವತ್ತು ಕೊಡೋಣ.
ಕಷ್ಟ ಆಗುತ್ತೆ.
ಸೆಟಲ್ಮೆಂಟ್
ತುಂಬಾ ಕಷ್ಟ
ಬರ್ಲಿಲ್ಲ. If no settlement is.
177 crores they are claiming before the
ಎಷ್ಟು ಡೆಪಾಸಿಟ್
Deposit ಮಾಡಿರೋದು.
ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ?
They are deposited.
435 crores.
ಎಷ್ಟು?
435 crores.
No, no, no,
Their
165
claim
crores.
before arbitrator against me is 177 crores, my lord.
ಅಲ್ಲ, ಈಗ my
Their claim
respectful
against me, my
submission,
lord. They are not
this
paid
court
the
has
GST.
held- this
My
court has
security
held-
deposit not been returned. Their claim against me before the
What is your
arbitrator,
security deposit?
6 crores, my lord, plus GST of 20 crores.
I have not sold the property.
No,
GST
that is not the, my
I have not
lord.
sold the
GST is
property.
agreed in the JD,
All
my
right.
lord.
No,
Second-
GST. if it is
2nd
applicable-
September.
Please.
Seconds, please.
ಈಗ ಎಷ್ಟು 35
GST and my
ಈಗ
deposit is
35 crores ಬೇಕಾ ನಿಮ್ಗೆ?
15/7/2022 in the whatever has been deposited, you go and deposit before the trial court and this honorable court has passed the directions. ಅದನ್ನ ಅವರು they have not deposited it not as per the direction issued by this honorable court. First round of litigation, my lord, they filed a petition suit and they were declared as fraudulent. First ಅವರೇ suit ಹಾಕಿ ಅವರೇ fraud ಅಂತ declaration ಬೇರೆ ತಗೊಂಡಿದ್ದಾರೆ. And in my lords have already held.
This criminal case
Yes,
ನೀವೇ
yes,
argue
ತಾವು
ಮಾಡ್ತಾನೆ.
observation
Please,
ಕೊಟ್ಟಿದ್ದೀರಿ.
my-
Criminal breach of
ಅದು
trust is
only-
palpable.
Only on the ground of procedural
BNS,
irregularity
my lord,
ಮಾಡಿ.
BNS,
My
my lord.
lords have
Otherwise-
already held that my lords criminal breach of trust is palpable in this case. It is seen, it is
I think
demonstrated.
I have written
My
so
lords'
also.
wordings are there. ಇಷ್ಟೆಲ್ಲ
But
ಮಾಡಿದ್ದಾರೆ
procedure
ನಾನು.
is not followed and
Followed and-
Only for that reason, my lords. Otherwise, my lords, everything went against them.
That is,
that has become final.
That has become.
Challenge
final because-
ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ, ಅದನ್ನೇನ್ ಮಾಡ್ಲಿಲ್ಲ because that procedure we had not followed, my lords. So
ಅಲ್ಲ
we have-
ಕರೆಕ್ಟ್ ಅದನ್ನ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ
No,
No, we
no,
not
I
challenged.
had to take it, much. We did not.
before that, the
Even-
arbitration has been commenced, arbitration that
Now,
the
these
settlement.
aspects are not, my lords, germane to this. My money has to come.
your money will come, wait.
Our money has also been due, my lord. My
6
GST.
crores.
ಅಲ್ಲ, ನಂದು ಈಗ
ಅಲ್ಲ,
162
GST
ಕೋಟಿ
ಕಟ್ಬೇಕು
ಇದೆ
ಸ್ವಾಮಿ ಅವರು.
ಅಲ್ಲಿ.
ಈಗ ಆಯ್ತು
ಅಲ್ಲ,
ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್
GST
ಆದ್ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿರೋದು ಇದ್ರಲ್ಲಿ.
Please, my lords.
ಲಿಸ್ಟ್ ಆನ್
Grateful.
2nd September.
Second.
ನಂದಕುಮಾರ್ ಸರ್,
Please, man.
you are back from Delhi by then ಅಲ್ಲ?
But yes, I'll be there, my lord. And second, I'll be there, man. So great.
Senior, my senior Navargi sir is in Delhi.
ಓ ಅವರ
Navatgi is there.
Yes,
By that time, let them come forward with something. my lords.
yes, that should not stop. Adjournment should not be taken, that you will not sit and settle.
Told to them
Settle,
not
everything will be over.
Please.
It's all money problem ಅಷ್ಟೇ.
Please.
Yes.
Please.
98.
Appear for the respondents.
Okay, for the petition.
N Natarajan.
This is the case that it's regarding the 4 guntas of land which I am in the possession.
Over here. Senior. All right. Yes, no problem. Yes. Ask him to sit. No problem. Yes.
It is a 4 guntas of land which I am in the possession. Actually, the entire property was a family property, and one of the family member has sold the property of 2 acres 19 guntas.
Why are you here now?
Here I have filed application. The case was posted for argument, and I have filed application to recall the stage to file the list of witness and also to
list of witness.
To examine one witness.
The stage of final arguments.
And also I have filed the application.
Order 18 rule 17. ಯಾವ್ದು ಹಾಕಿದ್ರಿ?
There are 3 petitions are there.
ಅದೇ ಒಂದೊಂದರಲ್ಲಿ ಯಾವ್ಯಾವುದು?
The first petition.
Giving direction to the defendant mother.
The first petition is to produce the directive defendant to
produce
the original sale
mother
deed.
deed so and so. ಆಮೇಲೆ
Another petition is to direct to recall the order and permission to file the witness list of witness, and another to appoint a court commissioner to survey the land.
Yes, sir.
The matter
All
had
are
reached-
rejected.
Yes,
All are rejected. But the matter had reached final arguments thrice. On the third occasion, on 3 occasions, they filed applications, and on the third occasion, when it reached final arguments, these 3 sets of applications came to be filed. The suit itself is not
We'll
made.
direct the suit to get concluded. The applications ಹಾಕಿ drag ಮಾಡೋದು ಯಾಕೆ?
No, not to drag this, my lord.
And my lord,
My case to
this is a suit for bare injunction.
Suit for injunction.
Suit for injunction, my lord.
ಇಟ್ಲ ತೀರ್ಮಾನ
And now-
ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇವಾಗ ಅವ್ರು ಕೇಳ್ತಿರೋದು witnesses to a perpetrate sale agreement ನ ಕರೆಸ್ಬೇಕು ಅಂತ. That is not even a matter in issue.
You are the plaintiff.
Yes, is the plaintiff.
You prove on the documents. It's your burden to prove,
fact, my
not
lord, the
get
suit
everything
was-
from the defendant.
No, not my lord. It is the case that I have to prove that I am in the position to appoint the court commissioner to the disputed 4 guntas, of which I am in the possession.
In fact, my lord,
Also,
originally the suit was for title. They amend the suit and make it only for bare injunction suit, my lord, and thereafter these applications have come to be filed.
Oh, prayer is amended.
Originally it was for declaration. Amend ಮಾಡ್ಕೊಂಡು they seek
Bare
only for
injunction.
bare injunction, and their pleading for declaration was that on adverse position based on an agreement of
You
sale.
urge all these contentions there.
It is because the 4 guntas which is I am using for the water tank, that is the main
ಅದೆಲ್ಲ
source
ಅಲ್ಲಿ ಮಾಡ್ಕೊಡಿ.
for my
Injunction ಅಷ್ಟೇ.
agriculture purpose. This is even it is admitted by the in sale agreement that has been exhibited. The one Kuppamma, who is the person have sold the land to the defendants,
No,
and she herself admitted that she has exhibited.
ಅದೆಲ್ಲ take advantage of all that, but all the 3 applications are correctly rejected.
No, to at least to appoint the court commissioner. that
For
I am
what
in the
purpose, sir?
To
Injunction suit.
No, to mark that I am in the position. my lord.
ನಿಮ್ಗೆ ಎಲ್ಲಿ ಪೊಸಿಷನ್ ಇದ್ದೀರಾ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ವಾ?
ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
Prove it by documents.
Because they are disputing it. They are disputing it. For that purpose, to prove my case, that commissioner has to appointed to that I am in the position.
Yes, nothing wrong with the orders. You urge all the contentions before the court. Or it is pass orders on merits, not a problem.
At least court commissioner.
No,
to
no,
appoint
sir.
it
Regarding court commissioner,
it may
trial court has clearly held that such elucidation is not required. Material on record
It
is
is for the
sufficient.
court to decide.
Clearly, court has exercised the discretion and said that it is not required.
ಮೂರು ಇಲ್ಲ ನಟರಾಜ್. ಕಷ್ಟ.
At least
Nothing
court
wrong
commissioner,
with
because it
it.
won't take at least 1 month. It may be.
I will direct this conclusion of the suit, not a problem.
No, appoint the court commissioner.
No, sir.
To prove that I am in the
No,
position.
no.
Because it is a injunction suit that I have to prove.
Injunction
that I am
suit
in the
ಅಲ್ಲೇ ಬೇಕಾಗಿಲ್ಲ.
That contention itself is untenable, my lord. They cannot use the commissioner's report to show that they are in possession. If there is a dispute regarding the identity of the property, that is.
Declaration is converted to injunction. ಅವತ್ತೇ ಹೋಯ್ತು ನಿಮ್ ಕೇಸ್. Yes. Anything else? ಅಷ್ಟೇ. We'll direct the suit to be concluded if you are withdrawing it. Otherwise, I'll pass orders on merits. Dismissed. All 3. Yes.
99.
I appear for the petition, this plaintiff's writ petition, suit filed in the year 2002, and it is decreed in 2021. Appeal is filed after 1.5 years. Your lordship may kindly see your lordship part.
Yes, government is not appearing, ಅದನ್ನೇ ಹೇಳಿದ್ದು.
Please, my lord.
Also not appeared.
My lord, directions may be issued, my lord.
For what? Why have you not appeared till now?
My lords, we have been appearing, my lords. Only the issue is only regard to why the RA was filed after 1 year, my lords. That inquiry is still pending, my lords.
5/8/2025 they have appeared and.
What is the order that you have challenged? 3/4/2025?
My lord, the application matter after hearing, the court passed the order. Page 29, my lord. Case is set down for orders on IA number 1, filed under section 5 of the Limitation Act, seeking to condone the delay of about 360 days. Since the learned counsel for respondent insisted for the.
What ಏನ್ delay ಹಾಕಿದ್ರಿ?
Well,
What IA on delay?
delay for filing the appeal by the respondents.
RA, my lords, in
By the
RA.
This
respondents.
is 10/6/20. Oh, you have filed an appeal, is it?
Yes,
The state has filed an appeal.
State has filed an appeal.
Please, my
State has
lords.
filed
Yes.
appeal.
In the year 2022, we filed the appeal, my lords, and this order was passed in the year 2025.
3/4/2025.
Please, my lords.
Post for inquiry. ಆಮೇಲೆ ಏನ್ ಬಂದೇ ಇಲ್ಲ, ಹೋಗೇ ಇಲ್ವಾ ನೀವು?
And ಹೋಗೇ ಇಲ್ಲ. And from the even from the presentation of the appeal was also not present. Kindly see the page 16, my lord. Case called appellant counsel absent, no represent, issue notice to the respondent. Court Suyamoto issued the notice.
ಇಲ್ಲಿ ಯಾರು ಸ್ಟೇಟ್ ಹಾಕಿಲ್ಲ, ನೀವ್ ಹಾಕಿದೀರಾ ಇದನ್ನ?
ಇಲ್ಲ, ನಾನಲ್ಲ, ಅವರೇ ಹಾಕಿರೋದು.
ಇವರೇ ಹಾಕಿರೋದು.
RA is filed by the state, my lords.
Appeal is filed by state.
It was due to COVID,
ಕೋವಿಡ್ 2025.
2022 nalli, my lords.
22 ಕೋವಿಡ್ ಇರ್ಲಿಲ್ಲ ಮೇಡಮ್.
Alla, RA was filed because.
RA was filed in 2022.
Please, my lords.
COVID was over.
COVID was over.
State is also taking recourse to COVID for delay. Yes. We'll direct the court to dispose the appeal.
Please.
The petitioner is before this court. Petitioner state is before this, state is before this court, calling in question an order of the concerned court dated 3/4/2025. The order reads as follows, page 29.
My lord, petitioner is not state,
Then?
my lord. Respondent is the state. We are. He is
Or the petitioner, the plaintiff is before this court on the score that the state is not appearing before the concerned court and the appeal is languishing before the court for the last 3 years. Last 3 years. Last 3 years. The petitioner, the plaintiff institutes a suit in OS 367 of 2002, which comes to be decreed. Yavaga?
Both the 366 and 367.
367 comes to be decreed
In the year 2021, 8/2/2021.
on 26/5/2008. The appeal of which,
8/2/2021.
when did you prefer the appeal?
My lord, the appeal
Alla,
is preferred.
appeal is preferred by the state. When did you prefer the appeal?
22/9/2022.
No. RA was filed on 23/9/2022, my lord.
Challenging what?
The order in OS, my lords.
ಯಾವತ್ತಾಗಿದ್ದ order in OS?
OS ಅಲ್ಲಿ 8/2/2021, my lords.
8/2/2021.
Please.
Which is this OS you are talking of, sir? 2008 the OS ಯಾವ್ದು sir?
360, that is once again remanded and MSA was filed and it's a third round litigation. 8/2/2021 finally passed the order.
8/2/2021.
21.
The petitioner, ಹಿಂಗ್ ಬರ್ಕೊಳ್ಳಿ beginning ಇದೆ. Petitioner is the plaintiff in OS 367 and 368 of 2002, which culminate into passing of a decree on 8/2/2021.
6 and 367.
ಎಲ್ಲ ಒಂದು ಎರಡೇ ಹೇಳಿದ್ದು. Yes.
367.
So and so. Culminate in passing of a decree on 8/2/2021. The said decree is challenged, judgment and decree is challenged by the state before the first appellate court in RA 265 and 266. Sorry, ಅಲ್ಲ.
180.
RA
187 and 180.
ಬೇಡದ್ದೆಲ್ಲ ಅಷ್ಟೊಂದು ಹೇಳಿದಿರಲ್ಲ. ಸೂಟ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀರಾ? RA ಏನು?
187 and 188.
RA 187 and 188 of 2022. In the said application, in the said appeal, an application is preferred by the state under section 5 on which the order which reads as follows is passed. Being aggrieved by the said order, the plaintiff is before this court inter alia on the score that the state is not appearing before the court after filing an appeal, and the rights of the petitioner, the plaintiff, is hanging in balance. The learned counsel will further submit. Idyavadu page 42 allirodu?
Page 42 nalli ade idu
In the light of the suit being of the year 2002 and the state filing an appeal in 2022, I deem it appropriate to infuse finality into the proceedings and direct the concerned appellate court to dispose the appeal in RA 181 and 187, 187 and 188 of 2022 within an outer limit of 6 months from the date of receipt of the copy of this order. It is needless to observe that the state shall ensure representation before the concerned court as they are the appellants. In the event they would not represent, the court is at liberty to pass necessary orders in accordance with law.
3 months.
Yeah, Mugsala. Yes. Matte extension. Yes, next.
100.
Appear for a petition. The defendant has filed a partition suit, and the defendant is a daughter-in-law to the petitioner, and she is claiming a partition suit as against the father-in-law. And the court, my lord, directly appoints the defendant as a natural guardian to the mother without hearing the petitioner and others, my lord. The order is at page 195.
Petitioner to serve on the counsel representing the plaintiff before the concerned court and file an acknowledgement of such service. List the matter on 10th September. Further proceedings before the concerned court shall remain stayed till the next date.
Great.
Next.
101.
Lords have not ordered notice, my lords, in this matter. My lords have directed to serve the copy, my lords, to the respondent.
Sir, madidra?
Sir, madidi, my lords, it's been filed, my lord. In spite of that, there is no representation. My lords have
Acknowledgement hakidira?
Acknowledgement is also filed.
Counsel for the petitioner submits that the order dated 13/8/2025 stands complied. Awaiting the representation of the respondent, list the matter on 10th September. Interim order subsisting shall continue to the next date. Next.
But until then, my lords, notice, my lords, notice may be issued.
Big sir, madidiralla. Next.
102.
This case I'm appearing for the petition. I have served the notice to the respondent number 6 and
Enter madam.
I filed a acknowledgement also on it.
For the R7, respondent number 7.
6 and 7. 6 and 7 both?
7.
Learned counsel so and so undertakes to enter appearance for respondent number 7. Registry to print the name of so and so as appearing for respondent number 7. Yes.
There is no interim order, my lord. We have sought for not to alienate. Trial court has not granted. Initially, we have filed a suit for bare injunction against the respondent number.
Iga?
Kotila son. That's why.
La, suit injunction na?
Suit for declaration son. Initially, we filed a suit for bare injunction. We filed during the pendency of the suit. The respondent number 7 took over the position.
Yes, sir.
Therefore, we filed a.
He is in possession.
He is in possession. During the pendency of the injunction suit, the trial court has granted injunction by violating the interim order.
So who is in possession?
Now he is in possession of the property and recent action. Annexure ZA page.
Quarrel. Now again change possession?
ಅದಕ್ಕೋಸ್ಕರ
Stay ಮಾಡಿದ್ರೆ ಮತ್ತೆ change in possession.
ಹೌದು. ಅದಕ್ಕೋಸ್ಕರ we are sought for not to alienate.
Yes, don't alienate the property. List the matter on 17th September. The respondent shall not alienate the property on dependency of this proceedings.
Okay.
Next.
Appearing for
103.
Hearing for petition, my lords, respondent filed a suit for recovery of rupees 14,92,960 before commercial court, my lords. My lords, after the evidence, cross-examination, and the matter was posted for judgment on 17/6/2025. But strangely, my lords, after passing this, after posting the matter for judgment, trial court judge, my lords, recalls the stage, my lords, and educated the respondent that some documents are missing, you are not produced, and your case is not substantiated.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service. List the matter on 17th September in preliminary hearing. Further proceedings before the concerned court shall remain stayed. Next.
104.
Petitioner by me. Lord, in this matter, challenge the memo of instructions filed by the plaintiff, OS number 52 to 54 of 2022.
Was the memo of instructions acted upon before the interim order?
No, no, my lord. But that can be modified and reduced to just one thing. The commissioner can visit the spot and report on the location, boundary and measurement of the suit schedule property. That would suffice from my side.
Yes, sir.
If that is okay with
My
you.
lord,
And
during cross
if there is any encroachment on the northern side, that is the crux of the dispute there.
Suit for?
Suit for declaration. I am alleging, I have a clear title, my lord. It is a sanctioned
We are also not
layout.
disputing the title of the plaintiff, my lord.
Then what, sir?
In this matter, my lord, during the cross-examination, I elicited, there is an existence of site number 341, and the measurement is also admitted by the plaintiff itself. Kindly peruse page number 60 of the deposition of plaintiff, my lord, PW1. During cross-examination, he himself admitted. Now they have given a memo of instruction to fulfill the lacuna where he admitted ಅದಕ್ಕೆ ವಿರುದ್ಧವಾಗಿ ಒಪಿನಿಯನ್ ತಗೊಳ್ಳೋದಕ್ಕೆ they have given the instructions.
Let me clarify.
Kindly peruse the
My lord,
page number 60.
my lord, there is a.
Page number 60, para number 2.
What's the next date?
Madam, next date is 3rd September.
We have deferred
8th
it.
September.
We'll take it on 10th
10th of
September. August ಆಗೋಗಿದೆ.
Lord, this, I thought this could be disposed
If
of.
he agrees on that, no problem. Otherwise, we'll have to decide. Yes.
My lord, that is what his memo of instructions also says.
It's the matter on 10th September.
Interim order may be-
Subsisting, any order of any kind subsisting today shall continue to the next date. Yes.
105.
Satyanand.
Objections file ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ.
I filed my statement about 10 days.
10 days, sir.
Dispute
What's the
is-
matter?
Dispute is regarding.
In respect
My
of
lord,
goods
7
supplied,
rule
purchase
11.
price not paid. Suit filed for recovery of
7 rule
money.
11 application is filed and that is rejected
Stand.
before the commercial
Yes.
court.
Learned Counsel PB Raju seeks 10 days time to file statement of objections. Objections, if any, by the next date, 10th September. Next.
Then 6.
Petitioner, copy served. The respondent is not present.
Serve ಮಾಡಿದ್ದೀರಾ?
Serve ಮಾಡಿದ್ದೀವಿ. 2 times. Last occasion also not present.
Last occasion ಇರ್ಲೇ ಇಲ್ಲ ಅವರು. ಏನ್ ಆರ್ಡರ್?
Order 21 rule 54 allow the application in execution order attachment of the property. Earlier,
Judgment at R.
ಹೌದು.
Yes.
Earlier, the LR application rejected by the trial court matter, my application. That order is not challenged. Now file the writ petition is allowed.
Let him, we'll see one more chance. List on 29th.
The attachment next to till next date of.
ಏನ್? 29th, yes.
Stay up.
107.
Appearing for the respondent number 1 and 107. Have been
Yes,
served
ಏನಿದು
with-
all
I appear
17
in
matters.
107, my lords.
Been served with
I
copies
appear,
of the 16 writ petitions last evening. My statement of objections are ready. If I may request for a
But
date.
107 is connected with 137, which I argued on the last date briefly, my lords.
ಅದೇ
Your
PK Gajra.
Please, please. So in this, why there is an urgency, my lord? Yesterday, the case was posted. We made a mention that just today the argument is likely to happen because in 137 they had undertaken, Leonard Senior had come. Despite the adjournment application, it has been closed and
What is
tomorrow,
closed?
the stage has been closed for cross-examination. I have lost there. Now I have to again file an application. It has been posted for defendant's evidence tomorrow.
Not necessary. We
No, no,
will
tomorrow.
We will revive it without an application.
My lords,
If that is
tomorrow-
the hurry with which
My
the
lords,
court is
No,
proceeding.
no, no, my lords. Tomorrow itself,
Foods are
defendant's
from year
evidence. What is
2019.
involved here? Just a minute, sir. You want time for filing objections. Let me argue on the.
1 minute.
Let
Let
them
him,
not precipitate.
Nitin, sir.
Let a date be
The
fixed.
learned counsel appearing for the respondent submits that 16 of the copies of 16 of the writ petitions listed today are served last evening. The learned counsel Nitin Ramesh representing the petitioner would submit that the court on the previous date has closed the cross-examination despite the submission that the matter was pending before this court and was listed today. The learned counsel further submits that the matter is posted tomorrow, date haki, for the purpose of defense evidence after closing the evidence of the plaintiff in the cross-examination of the plaintiff.
If I may just make one submission. Matters are from the year 2019. They were transferred in the year 2020. application has been filed in January 2025,
All right.
dismissed in Feb.
That's all right.
They've come to this
If a
court
submission
only
is
to-
made that the matter is listed today, it should have a weight.
In fact, my lords, on the last date in seal number 137, the submission was made.
I asked for
saying that it is
inter-prayer,
for
then I didn't press it
cross-examination.
because your lordship said I will hear it on 20th. So I filed an adjournment
Yes.
application. It's not treated with any.
ಧ್ಯಾನ್
risk.
ಚಿನ್ನಪ್ಪ ಸರ್ ಇದಾರ?
Please.
ಬನ್ನಿ ಸರ್. What's the hurry for the court to close everything and post it for defense evidence? Not on you, but the attitude of the court. When the matter is being heard here, it should await. Otherwise, I'll pass an order. It's not difficult for passing an order. I said, mention the matter to the court that is being heard today. Then even then it is closed. Yes, list the matter on 9th September. List the matter 9th September at 2:30 PM.
Please.
The concerned court shall defer its proceedings till the next date.
Grateful.
Tag the
One
petition,
ca-
tag the
one-
petition along with,
Serial 137.
Avat will close it.
Please,
No
please.
adjournments
And
on
there's one
that.
more
Objections, whatever you want to file, file.
And one more writ petition which has not been filed.
Give
Same
that. Yes,
case.
ಎಲ್ಲ ಕೊಡಿ.
All right. Grateful.
ಕೋರ್ಟ್ ಕೇಳಿದ್ರೆ ಕೋರ್ಟ್ ಕೇಳ್ಬೇಕು.
ಗೊತ್ತಿಲ್ಲ.
ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ.
But it's all 9th September, your lordship.
Evidence close ಮಾಡಿ ನಾಳೆ ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್. What's the hurry? That's the problem.
They are undertaken to lead evidence, I'm told, the previous.
Correct, that's true, but what's the mortal hurry? When the matter is listed today,
Adjournment application specifically refers to this writ petition being pending.
then it may not be correct. Yes. We'll take it on at 2:30 on that day. Yes, next.
108.
Lord, divergent findings by the 39 rule 1 and 2 by the court below. The trial court has been dismissed and first appellate court has been allowed. The first appellate court itself has granted an interim order in page number 104. The own order has been stayed by its own court, executing court only. There is a cart road, the claiming of the defendant is.
ಇದು ಕಾರ್ಟ್ ರೋಡ್ ಪ್ರಾಬ್ಲಮ್.
Cart road, my lord.
ಎಲ್ಲಿ ಸಂಪತ್ ಕೇಬೇಟ್ ಇದೆ?
Last time appear ಆಗಿದ್ರು, they have undertaken.
Undertaken what?
Not to.
Take advantage of the stay granted, no putting up a fence. Order ಮಾಡಿದಿನಲ್ಲ.
Yes.
Detail. List the matter on 17th. Interim order subsystem will continue to the next date.
I am appearing for in this case, Millers.
Respond serve ಮಾಡಿಲ್ವಾ?
Sir, the copy Millers have taken steps also and signed the memo regarding the service.
Nobody
of
is
the
represented.
notice memo. Millers, the Advocate Devaraju actually have served the petition papers. Millers.
The learned counsel for the petitioner submits that the copies of the petition in terms of the direction dated 24/7/2025 is served. Despite service, there is no representation. Whom did you serve on? Despite service, there is no representation. In the event the counsel would not, the respondent would not be represented the next date, appropriate order will be passed. This matter has last chance on 3rd November in preliminary.
Interim order may kindly be issued.
Will continue to the next date.
This was the case.
ಅದು ಮೊಬೈಲ್ ಆಫ್ ಮಾಡಿ ಸರ್. ನಿಮ್ದಲ್ಲ ಸರ್ PCB.
This was the case where on the 21st
I
of
love this
July,
petition.
they closed my cross-examination. The exhibits were signed by the learned judge on the 22nd. I got the exhibits. One more thing has happened. Previous judge who was on leave received the documents in evidence. Some other judge who has not seen the documents has signed the documents saying that they are the exhibits. My lord, now the matter is on 6th. Lordship may have it on Monday, the 8th, I'll cross-examine.
I have no objection. 6th day ಮಾಡ್ಬಿಡಿ sir.
6th is Saturday.
Saturday, ಒಳ್ಳೆ day.
Saturday.
I'll have another 48 hours to read. The 3,000 pages of paper.
I was instructed to prepone. I'm saying okay. 6th.
Next week, Abba is 3 days.
Abba. Oh,
I have
correct.
this 20.
27th is there, 26th, 27th is Abba, 1 day extra, 28th. So that's why I said, have it on 8th.
Learned senior friend, my lord, reads early in the morning. ಹಬ್ಬಕ್ಕಿಂತ ಮೊದಲೇ ಓದ್ಬಿಡ್ತಾರೆ ಅವರು.
8th ಹಾಕೊಳ್ಳಿ ನಾನು ಮಾಡ್ತೀನಿ.
8th ಎಲ್ಲಿ ಹಾಕೊಂಡ್ರೆ?
ಅಲ್ಲಿ ಎಲ್ಲ this your lordship
Directed
dispose
as,
of.
it is posted on 6th. If your lordship makes an order that I will commence cross examination on 8th, there's one more request after some years of practice in the trial courts. My lord, the learned judge, as I can see from the order sheet, wants to go ahead in a hurry. My cross examination should not be curtailed to 1 hour, half an hour.
So it should be permitted 1 year, 1 year, 2 years?
Well, it's not 1 year, 2 years.
Then-
I have never done that sort of thing, but with 3,000 pages, it would naturally take maybe 1
A
or 2
page a
days.
day?
Not a page, maybe
I want to say
50
one
pages, 60 pages a day.
day.
No, one second.
60 pages a day.
This is a miscellaneous
No,
petition.
cross examination, you go, you
This is a
conduct
miscellaneous
cross
petition for
examination, the
contempt.
number of pages?
Angilla, because what happens is, this is a question where they have said that is contempt, there's disobedience. They have produced 3,500, 3,700 pages. Well, if they had produced lesser number of things, I wouldn't even have raised this statement. I leave it to your lordship. my lord.
But what's the problem?
It's a Manipal group, my lord, there is a lot of,
Manipal group, and there is a lot of
oh,
problems.
lot of problems. There's been, both of us have been,
No, then I don't know, the problem is on the other side, because
Problem is that
they have
side.
committed contempt.
they have been
And they
filing case
continue to
after
commit
case.
contempt.
Now they have filed contempt.
No, I didn't file contempt now. I filed a contempt long time back. As a matter of fact,
They
no,
waited for 3 years to start evidence, and the day they complete evidence, the judge says, tomorrow you start cross.
that's not true. I think it's very unfair to make that statement.
No, it's not unfair.
No, no,
What
I'll tell
is
you
happening in
what
the trial
happened. No,
court, I am saying.
I
What
was
is
saying the same thing. What happened was, we gave them the entire exhibits. We gave copies to them. They are saying the same exhibits are marked. Now, without certified copy, I can't cross-examine. Is what they are saying.
May make
Where in
one-
law does it
No,
say
no,
you
may
need
make
certified
one
copies to
submission, may make one
cross-examine?
submission. I think my learned friend sees. One learned judge receives the documents. Am I not justified in worrying whether these are the same documents which are marked on that day? Some other judge signs it today, who doesn't even see.
Same documents?
I don't know. I really don't
Sir,
know. I'm not
It is
that's
in
why I kept-
court. The
that's what I'm-
documents are in
no,
court. We
if
give them
that-
copies.
Sir,
If it was signed on the
the
same.
presiding officer changes, leaving the documents there. The
Signed.
next presiding officer comes and takes it the
After a
same.
month?
Yeah, different documents are signed there.
I'm saying, am I not, would I not?
They are
be just-
court records.
They are court records if they were signed on the same, normally when the court clerk puts the seal, the learned judge signs it. Then I have nothing, I won't even open my
Every
mouth.
document was marked in presence of my learned friend's instructing counsel.
Yeah,
He
but
was
what
there.
ultimately was
Sir,
signed, I
no,
don't know.
That's not fair. I think it's unfair to make that statement against a.
No, why
judge.
I'm saying this is the way things have been happening. That is why I said, Lordship may have it on the 8th. Give me a few days time, I'll complete the crossing.
2 days time.
Few days.
Few days.
So that few days is all. Lordship may not say anything about it. Not let the judge regulate his own procedure as to how it is to
Very
be
well.
done.
Now, cross examination, ಯಾವಾಗಿಂದ ಯಾವಾಗ?
8th.
8th ಗೆ start.
Once 8th, no, I will not.
8th, Monday, I'll start.
8th of September.
September.
The show begins then.
Yes.
Oh, sure. It's nothing to show. My lord. Most of what we have filed are orders of the court, which they violated. They want to cross-examine on that every page, no
Right,
problem.
facing contempt and let him have opportunity.
Alla, opportunity andre, it has to be reasonable.
And they have produced, affidavit goes into pages containing material which is prior to the date of the alleged contempt. I'll have to point out all that. You
can
simply
ignore
can't
it.
file 600, 100 pages of
Thing is
affidavit
that-
and then say cross-examine.
No, it's not 6.
What's execution either?
Allala, there's a miscellaneous for violation of an interim order.
39(2)A.
39(2)A.
The petitioner is before this court calling in question an order dated 11/7/2025 passed on an application seeking cross-examination of PW1. This court, by way of an interim order, had directed the concerned court to defer its proceedings. The learned senior counsel for the petitioner and the learned senior counsel for the respondent would submit that if the cross-examination is permitted in time, within a time frame that this court would direct, it would suffice and there would be closure of the proceedings, the examination at least. The learned counsel for the learned senior counsel for the petitioner submits that if the cross-examination he would commence from 8th of September 2025 and complete it expeditiously.
Yes, definitely.
At any rate within
No, not any rate. Expeditious. Lordship has my word. I don't go into these things. I'm not-
expeditiously. Therefore, the concerned court would be at liberty to regulate its procedure the time that is to be granted for cross-examination in accordance with law. In the light of the said submission made by both the parties, the order impugned as a matter of form FORM shall stand quashed. The matter is remitted back to the concerned court to permit the petitioner to begin the cross-examination from the 8th and regulate its procedure thereafter. Thereafter, the concerned court shall also bear in mind that it should not, permission of cross-examination should not become a ruse to drag the proceedings.
11-7 and 21-7, ಎರಡು order.
ಯಾವುದು? ಎಲ್ಲ ಏನಿದೆ ಅದೆಲ್ಲ.
11-7. Great, grateful to you.
Yes.
But service in respect of respondents number 11 to 20 may be dispensed because they are co-defendants. I'm one of the defendants. I'm submitted.
Memo ಇದೆಯಾ?
Please.
In terms of the memo. Interim order subsist. We'll have it later.
Yeah, please.
No time.
Oh, bless.
List on
After 16th.
after
16th.
17th. Yes, list on 17th. Interim order subsisting will continue to the next date of hearing.
Great.
I also thought of the same date. Thank you. Yes.
112 adjourned, 113.
Hmm.
For the respondent, my lords.
My lords, this is the matter which I had filed and the respondents entered appearance on the last day. And they said that the memo of compliance has been filed complying with the order, which is under challenge herein, my lords. They produced the memo of compliance on the last day. They gave me a copy as well.
Comply ಮಾಡಿದಾರಾ?
My lords, we have filed compliance not just once, we have filed memo of compliance twice.
My lords,
But the respondents, for some odd reason, are not satisfied with the compliance. My lords, the issue here is the fact that defendant number 22 in the plaint, which is respondent number 23 here, is a partnership which is doing a business of making agarbattis and selling it, my lords. The suit has been filed by my own children through my wife. My wife has filed it through my children, minor children against me and my extended family.
For what? What is the suit for?
Partition, my lords.
Partition.
A partition suit has been filed wherein the learned trial court has.
Now what is the problem?
They have filed an application by way of which they are seeking the personal assets of individuals who are not even members or partners of the partnership. On the presumption, the Honorable Court has passed an order on the presumption that the partnership deed, which has been constituted, is a Hindu undivided family.
There's an interim order here.
My lords, no interim order has not been granted. It's an interim order.
What's the next date?
My lords, the next date is 28th
I might
of
make
August.
a submission, my lords. The matters now before, after 1 year, they come and challenge this. When a show cause notice is shown in the execution, my lords, they file for execution. And they say they've complied, my lords. If you look at the memo, all they filed is the acknowledgement that they've paid tax. The court has not asked them if they paid tax or not. What they were supposed to produce before the court was the whole IT returns. With the tax acknowledgement, the court cannot determine anything, my lord. So they, according to us, they've not complied with the order. So that's the reason we have even filed an execution of this order, my lords. And after 1 year, they get up, only after show cause notice is shown upon them, they come up and they file this petition, my lords.
We'll direct the execution to go on.
My lords, the only aspect.
You have not produced what is necessary to be produced after 1 year of.
Very well, my lord. My lord, I'm only questioning the legality of the order herein. I understand that I have filed the compliance memo twice. My lord, my only grievance is to this extent. Now, it is a partnership deed that is also admitted in their plaint. They admit to the fact that partners retire and some partners are added. In fact, my own wife, who is not entitled.
Is my own wife, Andre?
My wife, who has deserted me right now, that is the whole issue starts from the fact that I could not.
You can't own anybody. My wife.
Very well, madam. It is influenced by the MC proceedings that were initiated as against my wife by me. Now, as it so stands, there are members of the family who are not partners of the partnership. They have also been summoned to produce their personal assets. My lords, if at all they were.
Why do you want all that?
My lords, because we say it's an HUF, the whole thing we say is an Hindu undivided family, my lords. And what they do is.
They are family properties.
Yes, my
lords. You are
lords,
in a suit for partition.
Yes, my lords. What they come and say is the only time we're going to pay the kids is if kids just stay with me. That's the reason, the whole purpose, they're not ready to take care of the children. There's nothing, that's another.
Who's not able to take care of the children?
They're not ready to take
ready
care,
to take care.
That's another this thing, but I.
Another, it's an offshoot of the MC proceedings,
yes,
nothing.
my lords,
So now partition is another criminal case
to
ಆಯ್ತು.
partition
MC
suit,
ಆದ್ಮೇಲೆ criminal case ಆಯ್ತು, DV ಆಯ್ತು, ಈಗ partition suit.
Very well.
Partition. My lords, they
Law
come-
is evolving, yes.
On a law evolving, my lords, even in the partition suit, they come and file just tax acknowledgement. With tax acknowledgement, nothing can be determined, my
That's
lords.
correct.
doesn't-
What she says is correct. With tax acknowledgement, nothing is determined. You will have to produce the entire.
They say we
assets,
one minute.
all the
This-
assets of the partnership is already made part of the schedule of the plaint.
No, my lord.
All the assets. Now
So
what
if that
you
was
want is-
already made as schedule of the, for the
Yes, please.
plaint, why would there be an order to
My lords,
produce?
I would only request my lords to go to page number 34,
And my
which is
lords,
the
if-
operative
if
portion
at
of the
all
order.
we've
Now the
already-
demand being made is to present the shares, stocks, debentures, bonds, fixed deposits and any other deposits, demat accounts, etc. of all the defendants. My lords, the defendants are not even partners of the partnership. If it had to be an HUF, all the defendants have to be partners of the partnership as well, my lords. It's a presumption that
It's
all
a
of-
HUF.
that it's an HUF. My lords, all the assets of the partnership is already on record.
No,
Alright.
my lords, if it's already on record, they shouldn't have.
We'll
been
hear
treatment
this trending thing later.
Very
My
well.
lords, it might
Yes.
be posted tomorrow. my
No,
lords.
it will-
He has to. My lords,
Not
because-
tomorrow.
Because after 1 year, they come up and they file this petition when we
Correct.
serve them a show cause notice and execution.
Yes,
my
you
lords.
told me, madam.
My lords, the next date is on the
And
28th.
If I can just
Will-
quote you on the orders, my lord, where the court on why the orders been allowed, because there's, if at a page 8, my lords, of the order of the court has told that in one of the documents, my lords, another document that is a copy of sale deed executed by Yashodama in favor of Ashwatthaya and brothers shows that some properties are purchased for the firm, my lords, the said firm. But in other sale deed, it shows that the brothers.
You are the husband.
Please, madam.
Ah,
And my children have initiated
That's
this part.
maintenance just to.
My lords, the demands are too high in the MC petition.
That's alimony or maintenance?
My lords, as of now, we have been referred for mediation.
What's this?
And, the demand is 2 crores each for a child.
Ah.
Apartment in central Bangalore, which has to be minimum of 3.5
All I'm
bedroom
asking is,
apartment.
my lords,
And
all
it has to
I.
have all the minimum, the claim is the fact that.
Oh, you want a penthouse? Huh?
No,
Please,
my lords,
my
all
lords.
I'm asking is give me, my lords, they say.
The issue is my wife's brother has invested in the right places and has become a millionaire. So now I'm expected
My
to
lords,
make my
no,
wife
my
and
lords,
my
I
children
would
also
like,
the same
that's a
treatment.
false
And
allegation.
that
They
is where
stay
I
in
stand, my
Malleshwaram, my
lords.
lords.
That is
They have
in
a
Phoenix,
bungalow.
my lords, in the Phoenix
They have a bungalow in Malleshwaram. They have crores worth properties. They're worth today, my lords. All I'm asking is the way I was staying before, I have to be looked after the same
Same
manner.
status.
Yes, my lord. Nothing beyond that which I've sought for.
Unfortunately, my lords,
Because-
the partnership has all the money that it.
That's all right, but what's the
My lord,
maintenance
husband
awarded?
Also has.
What's the maintenance awarded now?
Not come to that yet, or I'll have to take
We're taking
instruction
care
to
of
that.
education.
We are taking
Maintenance,
care of education.
maintenance order ಆಗಿದೆಯಾ?
My
Not-
lords,
not
order
yet.
agide, appeal gu hogide, my lords. They filed an appeal. It's
We
all
are taking
pending,
care-
my
I'm
lords.
taking care of all the educational expenses, everything to that extent, my lords. There was an arrangement between my wife and I that my wife's parents will pay for her apartment.
That's all right. That's your problem.
Please, very well.
Now this we'll hear
Please,
on 10th or something.
my lords, until then, if the matter.
No.
Sorry, what's the date on which you said?
28th of-
Then we'll take this on 28th.
He's my
Very
lords.
well.
List on 28th in preliminary hearing.
Grateful.
Grateful, my lords.
Yes, it's difficult to solve this new trend.
Please.
Yes.
Then 14 adjourn, 115.
My lord, suit is
Your lordship, I've already
One for
furnished the
partition.
copies.
What's that?
I'm for the appellant.
Already furnished?
I've already furnished the copies and also created the process to give notice to respond number 227.
Interim order ಇದೆಯಾ?
there is an interim.
Yes, your lordship.
My lord,
Connected matter ಇದೆಯಲ್ಲ?
how?
Proceedings are stayed.
Proceedings are
No,
not
sir.
stayed. Specifically made it clear that proceedings may go on,
Ah.
but the order is stayed, impugned order is stayed.
The written
My lord,
statement.
one submission. First respondent is 91 years old, was a practicing advocate. He has given a practice. He is bedridden. Request that early hearing. That's all, my lord. That's all.
Direct
Nothing,
that, that's
nothing
all.
else.
Yes, your lordship.
Yes.
Your lordship
Nothing
also
else.
request that they may be directed to give the WP 23194 copy.
is
that-
After disposal, they'll give it. Yes. We'll dispose it.
Please.
The petitioner in 11, what are these two? Both are by the same?
Both are,
You are the plaintiff.
I am the first defendant.
He's
They
defendant
are
number
the
one, your
plaintiffs.
Suit for?
Suit for partition between the brother and sister.
Partition suit ಎಲ್ಲಿ ತೀರ್ಮಾನ ಆಗುತ್ತೆ sir?
My lord,
Your lordship, one more thing.
It's a written
Now, new
statement
breed
is-
of partition suits are coming up. Now you
I
can't.
have not.
Himdalla, sir. Not, you are not.
Your lordship, they have put an allegation that we have been delaying the procedure. But if you see the
2017.
Yes.
uh,
After 7 years, a written statement by the dependent number 2 is filed.
Additional written statement.
No,
That
for that,
again
no, madam.
later
It's
they
a
filed.
written statement. Ma'am. 7.5 years after the filing of the suit, written statement.
Permitting additional written statement ಅಂತ ಇದೆ.
ಅದು additional written statement.
Defendant number one
He filed written statement for which I need,
No,
to-
if,
he is supporting the plaintiff.
If both of you agree, we'll direct disposal of the suit in 6 months.
Your lordship, because the suit was delayed mainly because of the defendant number 1.
Whatever be it, 6 months
Lordship,
we'll dispose it.
It went on because
It's all right, I'm asking. Whatever, let bygones be bygones. Whatever has happened, we'll now direct the petitioner. The petitioners in these cases are either the plaintiff or the defendant in OS 67 of 2017, instituted seeking partition in separate possession. The learned counsel appearing for the respondent submits that the parties to the list are of advancing age and one of the plaintiff is 81 years old now.
First defendant.
And the first defendant
91 years.
91.
91.
And first defendant is
And
now
he was a,
91.
he was a,
I thought 91 years old.
yes.
In the light of 91 years old, what brings the petitioner to this court is permitting filing of a written statement or additional written statement as the case would be after about 7 years of the institution of the suit. ಅದರಲ್ಲೇನ್ ತಪ್ಪಿದೆ?
No, your lordship.
ಅಲ್ಲ, ನಾನೇನು oppose ಮಾಡಿ, though it is 7.5 years later supporting the plaintiff, first defendant did not oppose. He just filed the additional written statement because it called for additional written statement.
Your
That's
lordship,
all.
we were not provided an opportunity to file a rejoinder. And directly it was posted for
That's it.
additional written statement of defendant number 1.
Difficult to dispose it like this. Yes, list the matter on 3rd September preliminary hearing. Yes.
116.
Hearing for petition.
Your lordship, the interim order may be extended.
That will be, whatever is that will be extended. Yes.
Hearing for petitioner, my lord, in this.
List on 17th. I
interim
will
order to be
extend it till then.
extended. My
Next.
lord, for this, directed to take notice for the respondent has the counsel for the respondent has refused to.
The learned counsel for the petitioner submits, the counsel for the respondents have refused to receive the notice. In that light, emergent notice to the respondents returnable by the 17th of September, list on 17th, interim order subsisting will continue to the next date of hearing.
I
Next.
file a memo for dispensation of respondent number 132.
Only after filing a memo. Yes.
Please,
Next.
my lord.
Next.
117.
Lord, in 117, please permit me to appear, my lord, on VC. I appear for the petitioner's counsel, where against a non-grant of an interim order, there's a registered agreement to sell in my favor. Your lordship should please see
3rd
that.
September preliminary hearing. Next.
My lord, the interim order may please be granted till then, my lord.
No, sir. Avat Kodana. Yes.
Not to alienate it, because there is
Next-
another
next
writ.
date ಏನು, sir?
I'm sorry, my lord.
Next date.
My matter was today. From April, he's been avoiding service of notice in the section 9 petition.
It's all right. What is the next date?
It was today, my lord. I'll just have
If
19th
it
of
was today,
September.
next
it's
date, you
adjourned
should
to.
tell. Next date here is.
I'm sorry, it is
3rd
adjourned to 19th September. 19th
Oh, it's
September.
first fresh alva. List on 1st September. Yes.
My lord, interim orders in some protection if your lordships are kind enough
Yes,
to.
yes. On that day. Next.
18.
My lord, it's a fresh matter, my lord. That's why I was pointing. Great, that's great.
Fresh preliminary hearing.
Suit is for specific performance and the defendant, my lords, has not filed my written statement. My lords, the matter is posted for judgment for tomorrow, my lords.
Not filed a written statement. Why?
Lords, on 13/6, it was, my lords, due to some ED raids were there, my lords. I could not
Huh?
meet the enforcement directorate, my lords. Raids were there, my lords, being
So?
conducted. My lords,
Then statutory limitation extension submission.
ಆ ಥರ ಇಲ್ಲ, could not appear, instruct the lawyer, my lords. It's posted for judgment.
ಯಾವ್ದು ಕಮರ್ಷಿಯಲ್ ವಾಯ್ಸ್?
ಇಲ್ಲ, specific performance.
Suit.
I'm the landowner.
ಹಾ.
The plaintiff has filed the specific performance. Tomorrow it is posted for judgment, my lords.
What were you doing till now?
My lords, on 13/6, my lords, it was posted, a written statement was taken as not filed.
Hmm.
Posted to 23/7. 23/7, my lords, very same day evidence
and also arguments were heard, my lords, posted for judgment, my lords. I advanced the case, my lords, filed an application. Application was rejected on 9th, my lords. 7th it was advanced. They did not file objections to that application also. The court heard the matter.
That's the matter on 3rd September in plenary hearing. Petitioner to serve the counsel who represents the respondent in the trial proceedings. Further proceedings before the concerned court in OS 1242 of 2023 shall remain stayed till the next date.
Request for a memo for hand delivery.
It will be uploaded, hand delivery in Adel. Yes. Don't call B group.
Number 2.
Alenida. Plenary hearing. No idea where.
Serial number 20, my lord. Only
Correct.
serial number 20.
230 mode matter.
30 mood matters. Order seal number 1. Ramakrishna Hegde.
Quoted for mental. Lord, the order passed under order 21 rule 32 is challenged before some. Already kindly seek
Appeal.
appeal ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ರು ರಿಟ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಲ್ಲ kindly see I have
PRP ಹಾಕಿದ್ದೀರಾ?
ಹೌದು I have one judgment my lord in
EMCPC ಹಾಕಿ.
ಅಲ್ಲ ಆಯ್ತು ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ.
ಈಗ ಏನು ಅರ್ಜೆನ್ಸಿ ಏನು ಹೇಳಿ?
ಅಲ್ಲ ಅರ್ಜೆಂಟ್ ಇನ್ ಡಿಟೆನ್ಷನ್ ಆರ್ಡರ್ is passed.
ಡಿಟೆನ್ಷನ್ ಆರ್ಡರ್ ಏನು?
ಅಂದ್ರೆ my lord 1997 ಅಲ್ಲಿ RA was allowed, injunction was granted, suit or dismissed. In RA injunction was granted my lord. And also liberty is given to the defendant to dispossess the plaintiff. But on the other hand, the defendants approach to the revenue court, my lord. Revenue, the DC is trying to dispossess them. It is challenged before the Sound Court in writ petition.
What happened?
Pending.
No stay?
No stay. Another, my lord. Now, they filed execution petition under order 21 rule 32. Seeking to put the judgment letter in the civil prison. The judgment letter in the civil prison, my lord. My lord, the petition is allowed, my lord. Kindly see final order, my lord. It's a similar judgment, my lord, in this honorable court passed. Kindly page number, my lord, in the page number.
Petitioner to serve on the counsel who represents the petitioners shall serve on the counsel who represents the decree holders.
Page number 3272, my lord.
By way of hand summons, list the matter on 29th in plenary hearing. The order impugned shall remain stayed till the next date.
This admission ಬರಬೇಕು.
Admission, sorry. For admission on Friday, yes, 29th.
Till then.
ಕೊಟ್ಟಾಯ್ತು.
Please.
Satyanand B.
For the petition on this matter.
List
As against my lord, refusal of the ex parte temporary injunction and before your lord.
Refusal of temporary injunction.
Ex parte. My lord, I had sought for not to interfere by altering the nature of the land. Schedule A property. Kindly see, my lord, the photographs which I have produced.
Not to alienate.
Not to interfere with the.
Interfere,
with the
not to
possession,
change the
my lord,
nature
by
of the.
altering the nature
You are
of
in
the land.
possession?
Yes, my lord. My
Then
lord,
why
what
are
has
you
happened
worried
is
about?
it's a common
Why are
passage.
you worried about somebody changing it?
No, what is, kindly see the photographs for a minute.
Photographs bidi, if you are in possession of the property.
Please, it's a common passage. Common passage ಅಲ್ಲಿ ನಾನು sanitary lines ಎಲ್ಲ ಹೋಗ್ತದೆ. Now, my lord, in the anxiety, my lord, of putting up construction, he has demolished and he has dismantled the entire thing. Kindly see the photographs for a minute. 97 in the. My lord, the
sanitary line ಯಾವುದು ಕಾಣ್ತಾ ಇಲ್ಲ.
Kindly see the photographs. The next 98.
Our property ಅವ್ರು ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
None common passage ಇದು. There is a common
passage where?
My lord,
who has sold the common passage?
My lord, it is not sold. It is all passing through. It is for the benefit of both. My lord, from 1941, my lord, this arrangement is there. Now, my lord, suddenly, my lord, they start doing like this. My lord, kindly see the sketch, my lord, which I have produced before your lordships, which is registered along with the document in the year 1941. Kindly see 21, page 21.
All right, is served by way of hand summons. Petitioner to
serve
by way of, not sir, counsel. Learned counsel with the petitioner to serve the defendants by way of hand summons and file an acknowledgement of such service. List the matter on 1st September, 3rd September. The respondents are restrained From interfering with the property of the, ಅದು interference ಇಲ್ವಲ್ಲ?
Insofar as A schedule property, that is the common passage which has.
Restrained insofar as A schedule property till the next date of hearing.
Please.
Yes.
Still number 3, Sudhakar MR.
Petitioner, my lords. My lords, I am the plaintiff, my lords, filed a suit for bare injunction. During the pendency, my lords, I sell the property, I'm not the owner, I'm not in the possession. The same sale, my lord, got to be marked with the defendants. Immediately, my lords, I file a memo, my lords, to dismiss the suit as not pressed. But, my lords, however, the trial court would post the matter for arguments, my lords, for judgment, my apologies, and judgment, my lords, on 23rd. I'm not the owner, my lords.
Petitioner to serve on the counsel represents the respondent before the concerned court 10 September till such time for the proceeding shall remain stayed. Next.
Number 4, Sudhakar MR.
Same, my lords.
Same.
Same.
Office objections?
I'll have you complied.
Office objections to be complied with in the meantime.
Please, my lords.
Yes, next.
Passed over 56.
Passed over. Kariri, no.
Passed over 56, list 1.
Petition and was.
Next, yeah, date, yeah, third,
Third peda, Your Lordship.
Only jurisdiction issue, man.
After, not only jurisdiction, Your Lordship.
ಯಾವತ್ತು ಅಂತ ಕೇಳಿದ್ ನಾನು ಅಷ್ಟೇ.
And after 4th, any date.
List on 10th, yes.
58.
Same. Same stage. ಅದು ಅಷ್ಟೇ 10, all passed over matters on 10th.
Serial number 58.
Number 2.
List number 2 ಅಲ್ಲೂ ಅಷ್ಟೇ.
Serial number 5, my lord. List number 2, serial number 5, my lord.
List number 1 ಆಯ್ತು, ಅದನ್ನ don't ask anything.
Serial number 5. There is an urgency.
List number
2.
Wait, list number 1 I'll get back.
List number 2, my lord.
ಆಯ್ತು, ಅದನ್ನೇ ಹೇಳ್ತು, ಒಂದ್ ನಿಮಿಷ ತಾಳಿ.
List number 2, serial number 5, my lord. There is an urgency. My lord, my mother has filed a partition suit. After filing the suit, she came to know that land in question has been notified by the KADB. Therefore, she has given representation to KADB.
Acquisition first, partition suit first.
Partition suit later.
Later.
ಹೌದು 2000 ಅಲ್ಲ, ನಮಗ್ ಗೊತ್ತೇ ಇಲ್ಲ ಸ್ವಾಮಿ. We filed suit in the year 2000.
Compensation determine ಆದ ತಕ್ಷಣ partition ಬರುತ್ತೆ.
ಇಲ್ಲ, ಇದರಲ್ಲಿ we have given
ಬೇರೆ ಏನಿಲ್ಲ
ಅಲ್ಲ, ನಮಗ್ ಕೊಡಿ ಅಂತ ಕೇಳ್ತೀರಾ ಸ್ವಾಮಿ.
ಮತ್ತೆ
we requested the KADB not to disperse the amount pending.
ಎಲ್ಲ ಒಂದೇ.
ಅಟ್ಲೀಸ್ಟ್ ಇಲ್ಲದ್ರೆ ಕೋರ್ಟ್ ಮುಂದೆ ಯಾವ್ದು ಡೆಪಾಸಿಟ್ ಮಾಡ್ಲಿ. ಇವಾಗ ಏನಾಗ್ತಾ ಇದೆ ಅಂದ್ರೆ, ಪ್ರತಿದಿನ ಹೋಗ್ತಾರೆ ಅವರು, ನಾವು ಖಾತೆದಾರ ಯಾರಿದ್ದಾರೆ ಅವ್ರಿಗೆ ಡಿಸ್ಪರ್ಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಹಾಕಿರೋದು ಆಮೇಲೆ ಕಾಂಪನ್ಸೇಷನ್
ಅಲ್ಲ, ನಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ಸ್ವಾಮಿ. ಮೈ ಮದರ್ ಡೈಡ್ ನಾವು. ಅಲ್ಲ, ಡೆತ್ ಆದ್ರೆ ಆಫ್ಟರ್ ಫೈಲಿಂಗ್ ದ ಸೂಟ್ ಮೈ ಮದರ್ ಡೈಡ್. Immediately we made an application before the trial court.
Let it come later. Yes. Learned counsel for the petitioner to serve on the private respondents by way of hand summons. Learned HCGP accepts notice for respondents 1, 2 and 3. Board, sorry. 1, 2 and 3. HL Pradeep Kumar accepts notice. Petitioner to serve papers upon HL Pradeep Kumar. List on 10th. Yes.
Alright, sir. Till such time no amount should be disturbed. ಯಾಕಂದ್ರೆ ಈಗ ಅವ್ರು
ಏನ್ ಪರವಾಗಿಲ್ಲ. ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಆಮೇಲೆ ಯಾಕೆ ಹಾಕಿದ್ರಿ?
ಅಲ್ಲ, ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ. ಈಗ ನಮ್ ತಾಯಿ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ. ತಾಯಿ ತೀರ್ಕೊಂಡ್ಮೇಲೆ by filing an application.
All these, I am seeing daily 10 partition suits being instituted after compensation being determined in land acquisition case.
ಇನ್ನ ಇದ್ರಲ್ಲಿ compensation
I will have to lay down saying if the partition suit is subsisting as on the date of acquisition, only then. Otherwise nothing else.
No,
all gone.
She is uneducated. She is uneducated.
ಎಲ್ಲ ಇದೆ, ಎಲ್ಲಾದ್ರಲ್ಲೂ ಇದೆ ground.
ಅಲ್ಲ, ಯಾಕೆಂತಂದ್ರೆ ಅವ್ರ ತಾಯಿ
because somebody else will be shooting from the shoulder of the mother seeking partition
and 24/7
seeking compensation. Yes, 10th, 9th, sorry. Yes.
23rd serial number.
Number 6.
GM 29(2).
General award.
General award.
ಯಾವುದು?
6 madam.
ಈ ನಿಮ್ದಾ?
ಇಲ್ಲ.
ಶರಣ್ ಲೋಕ್ ಮಜ್ಜಿಗೆ. Yes.
2 and 3 KADB madam. 3 is 4 is Harish.
ಜನರಲ್ ಅವಾರ್ಡ್ ಕ್ಲೋಸ್ ಮಾಡೋದಾ? ಪ್ರದೀಪ್ ಕುಮಾರ್ 2 and 3 board HL Pradeep Kumar accepts notice 1 HCGP. General award ಅಂತ ಕ್ಲೋಸ್ ಮಾಡಿ. 4
is the right KRL. Harish sir will apply.
Sir, yes. Next.
7. Hearing on 8. Delay. RP.
Notice.
11.
11, yes. Sir. 11, no. Yes. List it on 10th. Next.
16. My lord, serial number 16.
16.
Number 60, it pertains to 28A, my lords.
Ah,
Redetermination of compensation.
correct.
The
Yes.
notice has been served on.
PP Vivekananda.
That's for
Yes, my
R2,
lords.
GB Sharad Gowda's name has to be reflected.
Shalva.
We've been
Registry to
instructed.
delete the name of TP Vivekananda and print the name of GP Sharath Gowda.
Yes,
List the matter on 2nd September.
My lords, they need to
Avath
serve
will
a copy.
dispose it.
Yes,
They
my
need to
lords.
serve a copy, my lords.
On copy Kodi, madam.
So I will give 1 second. my
Ainand
lords.
Kodi.
Okay.
On that day, I'm disposing it. Yes.
Yes,
It's
much
28
obliged.
redetermination. Next.
17. VW.
Covered. Both disposed.
18 also.
18 also. Yes.
20.
20, my lord, can you fix that this IVOM will be
20.
serial number 20.
List on 2nd September. Yes.
IVOM
21.
will be extended.
Entry mode idea. List on 16th September. Entry mode subsisting will continue to the next date of hearing.
51.
In this case, appears for the petitioner. My lord, they have executed the execution petition, they have their delivery warrant have been handed over. My
ಈಗ
lord.
stay ಆಗಿದ್ಯಾ?
Stay ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ಇದು first shoot.
We will take it on 3rd.
My lord,
Yes.
there is a demolition threat, my lord.
First, yes.
My lord, until that I have to change the nature.
Demolition. ಯಾಕೆ?
Demolition, but so I would get to- I am not a party to the partition suit, I am not a party to any of the proceedings.
The
I am an objector.
objector.
Objector. ನನ್ನನ್ನು ಆಚೆ ಹಾಕಿ 5-8 ಗೆ ಹಾಗೆ ಹಾಕಿದ್ರು ಸ್ವಾಮಿ. They are taking the advantage of.
List the matter on 10th. The property of the objector shall not be demolished till the next date. Yes. List on 10th September. Yes, next.
22.
22, 2nd September. Yes. 2nd September. Next.
23.
I appear, my lord, in this matter, lordship was pleased to, matter is tomorrow in the trial court for confirmation of the sale.
Respondent ಯಾರು? ಆಂಜನೇಯ. K8 ಇದೆ.
Was present just now.
Present just now.
He's very much here, but he's not appearing.
Very much here, but not visible.
It's not appearing. I'll
Appearing.
serve copy on the council. Not tomorrow is the.
ಈಗ
matter.
entry order ಕೊಟ್ರೆ he will appear. Yes. The concerned, list the matter on 3rd. Concerned court shall defer its proceedings till the next date.
Obliged.
You are the notified ಖಾತೆದಾರ್. Partition suit ಹಾಕಿದ್ದೀರಾ? ಮತ್ತೆ? Agreement holder. Registered agreement? Registered agreement? Correct ಆಗಿ ಹೇಳಿ. Registered agreement? ಇಲ್ಲ. Decree in your favor, specific performance decree. Execution is pending. First time ಬರ್ತಾ ಇರೋದಾ? 22. KDB,
Very good.
Learned counsel so and so accepts notice for respondent 1 HCG AGA 2 ಮೆಟ್ರೋ ನಿರ್ವಹಣೆ ಯಾರು? ಯಾರು ಇವರೆಲ್ಲ? ಬೈಯರ್ಸ? ಅದೇ ಯಾರು ಇವರೆಲ್ಲ? ವೈ? ಅಲ್ಲ ಸರ್, ಇವರೆಲ್ಲ ಯಾಕೆ ಮಾಡಿದ್ದೀರಾ? ಯಾರಿದು? ಯಾರು ಮುಂಬೈ ಆಫೀಸ್ ವೈ? ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ಮೇಡಮ್?
22.
ಯಾವ್ದು 19 ಕೊಟ್ಟಿದ್ದೀರಾ ಮೇಡಮ್? ಸಾರಿ. ಅಲ್ಲ 19 ಟ್ಯಾಕ್ಸ್ ಅಲ್ವಾ? ಹಾ, ಅಲ್ಲೇ KDB ಇದೆ ತಾನೆ. ಪ್ರಕಾಶ್ ಹೆಬ್ಬಾರ್. Learned counsel for the petitioner submits that the petitioner is an agreement. Petitioner had instituted a suit for specific performance against the khatedars, and the suit is decreed in his favor and execution is pending. The issue in the case relates to disbursement of compensation by the board on acquisition of the property, which is the subject matter of the suit which the petitioner holds a decree in his favor. In that light, compensation shall not be disbursed by the KIDB till the next date of hearing. List the matter on 9th September.
Copy.
Copy. Copy of the petition be served upon the counsel representing the respondent.
37?
37. Ek madam.
37, Lordship. 37.
Ek 37. ಎಲ್ಲೇನಾ ಬಿ ಗ್ರೂಪ್ ತಾನೇ ಅದು ಮೇಡಮ್ ಬಿ ಗ್ರೂಪ್ ಬೇಡ
Serial number one.
ಬಿ ಗ್ರೂಪ್
First list, madam.
ಸೆಕೆಂಡ್ 9th.
Serial number 134, second, first list.
Lordship, in the serial number 120, list number 1, the matter shut down for the judgment on Saturday, please Lordship. Mention that the writ petition is pending.
ಬಿ ಗ್ರೂಪ್ that is
Also.
not a date given by me.
The judgment ಹೋಗಿದೆ ಅಂತ and request, I move the matter, I request the court
ಯಾವ್ದು ಕೊಡಿ
to,
ಮೇಡಮ್
the matter shut down for judgment. Saturday.
25/7 ನೀವು ಇರ್ಲಿಲ್ಲ.
ಅವತ್ತು ಅಲ್ಲ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ 110 application is condition.
1 rule 10 ಪರವಾಗಿಲ್ಲ.
Earlier also the same petitioner was filed a suit against the proposed respondent number 6, my lord. The suit came to be rejected and filed with 7 rule 11. Lapse of so many years.
It is a suit for partition. Present suit is a suit for partition. It is the brother, in the name of brother, the property is standing.
We'll see.
Allah, my humble submission, 23rd judgment ಗಿದೆ ಸ್ವಾಮಿ.
Yes, yes.
Allah, I request judgment may be deferred and
No,
matter
no,
may
no.
be.
We will not defer judgment. Yes, sir.
Can I request, my lord?
50.
55, my lord.
In what first list?
Second list, my lord.
ಏನು?
My lord, this is case where this is the only.
Mercy petition.
Yes, my lord.
Mercy deferred. Yes.
My lord, my lord, this case, my lord.
Mercy deferred by 2 weeks.
May be
List
disposed of
after
by
2
the
weeks.
merits, my lord. This may be disposed of. I am the petitioner, my lord. In this
ಯಾರು
case-
ನೀವು ಅವ್ರಿಗೆ ಮರ್ಸಿ ತೋರಿಸ್ತಾ ಇದ್ದೀರಾ?
In this case, what happens, delivery warrant has been challenged before the Tribal Court, my lord.
Yes.
And on merits, my lord, I don't have any case, my lord. Maybe disposed on merits, my lord.
ಅದನ್ನ ಅದು ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಆಗ್ತದೆ. ಆರ್ ಫ್ರೈಡೆ 22nd ಆಗ್ತದೆ. ಈ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಏನೇನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದೀನಿ. There is no interim order. No interim order.
May I mention, my lord?
We'll see.
Truth,
Madam, 125.